Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit. I'm not a camel.
As the agent for Peyton, Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton, Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton, Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
no, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. So. And it's
I'm not a person, I am one of the people. Thank you.
Okay, thank you.
Thank you. Okay. Welcome to the Court of Public Opinion. Good morning. Sorry I'm late. I'm the Recovery Addict. That's all you get. Just the sorry I'm late. What is it? It's after 10 o'clock in the morning. I'm just waking up. It was a late night. That was all. Ashley's one of the people. You are here. Thank you very much, Ashley. Appreciate that. Do you know who else is here, Ashley? Do you know who else is here? Kimar's here. Congratulations, Kim. You were first in chat. Thank you very much for being here. You know what to do. The internet is all yours today. That's the punishment, the penalty, the prize that we award you when you were first in chat. Paula Mack, I was just reading this and I lost my train of thought. They were working. I heard a couple of them. I turned them down very quickly.
You're talking about
still working.
That is not relevant.
They work at the very beginning. I was wondering if anyone was going to get a command in before I actually rolled the intro.
I'm not a cat.
But it's a very brief opportunity to do that. We'll see if somebody is quick enough to be able to do that. That's going to be like the new first in chat thing, who gets the first command in. All right.
Send someone with more experience.
We already did happy birthday virtually at 10 a.m., says Greeners. Is there anyone who has a birthday today that needs to be sung to? It's Thursday. I realize there is a trial that started. We may jump to and catch up with when our trial is over. Nikki, yes, it's the Treehouse trial. We may jump down there and take a look at that and follow that one because we have a pro se defendant. It is Florida man defending himself. I know nothing else other than that there was a Treehouse involved and a murder and pro se. That's what I know about that one. And but we're not going to jump to it now. So if we do jump to it, we're going to be catching up. Probably skipping the jury instructions and then beginning with opening statements and then going through and listening that way. But we have another trial that is going to start here in about an hour and a half that we're going to finish up. It is out of Thurston, Washington. They go live in just as soon as they get there this morning, which is 8:30 their time. Thurston, Washington has just delivered amazingness after amazingness. So we're super excited to have that at, let's see. Reckless, not reckless. Did I messed the whole thing up, huh? Well, arguably, Reverend Beasy, he didn't wreck either. So it was a reckless driving event, right? I realize the charge is completely backwards, but I failed. My English teacher would be very disappointed in me this morning. Let's see, we have a buffer sound somewhere. Here we go. Let's see. Malayla, Kevin, and Cynthia are celebrating their 21st wedding anniversary. There's too many people in that list. Malayla, Kevin, Cynthia is celebrating their 21st wedding anniversary today. Well, I hope the three of you have a fantastic anniversary. No, just kidding. I think it's Malayla and Kevin have birthdays, and Cynthia is celebrating her 21st. I might need a little clarification on here because we've begun the day with a thruple allegation, which although is not new to LawTube, that's a little more than we wanted to start with. Technicalities, just technicalities. Michaela says, it's Michaela, and I'm 31 today. Michaela's birthday. It's coming together for me. You guys, I just woke up. You have to realize that my brain is not quite functioning on the next level. Law Talk with Mike would approve for sure. Who did the content warning? Greeners, was that you? Yes. Let's see. Let me go back. Let's see. So Michaela, you're 31. We're going to sing to you. So
Have them send someone with more experience.
what I need to know is Kevin and Cynthia, is that a thing? Or is it Michaela has a birthday, Kevin has a birthday, and Cynthia is celebrating their 21st. Inquiring minds want to know before I sing or pronounce somebody married that it isn't.
We're going to break for lunch, Judge.
Good luck, Linda. It's always fun to follow two at the same time. Okay, Kevin is my brother. Okay, so Zoe loves unicorns. Kevin, and I'm imagining, does Kevin have a birthday today? This would help. This would help me figure this out. If Kevin has a birthday, we can add him to the birthday list. We've got Michaela, possibly Kevin, but Kevin also might have an anniversary today. I'm not quite sure how this goes. Kevin says, I don't have a birthday. Kevin, do you have an anniversary? Kim says, I think you need to go back to bed. Okay, I see, Zoe, that he's your brother, but I need to know. I need to know who we're singing to. That's it. Sharon says, Michaela, Kevin both have birthdays. Cynthia has a 21st wedding anniversary. Okay, whoa, now we're talking. Thank you very much, Sharon. I realize that's what you were aiming for, and I'm sorry for putting you through that. But good morning. Thank you very much. Let's sing to Michaela and Kevin, and then a big congratulations and shout out to Cynthia with the 21st wedding anniversary. Maybe he got married on his birthday, so he always remembers their anniversary. Okay, parts, you guys, stand up, sing loud, shoulders back. Happy birthday to you. Happy birthday to you. Happy birthday, Michaela and Kevin. Happy birthday to you. That was funny. Happy birthday, Michaela and Kevin. Anyone else who's celebrating a birthday today, today is your special day. And hopefully you do something very special to celebrate your special day. The fact that you are here celebrating with us, it's our honor, privilege, and pleasure to be able to do that. So thank you very much. Hope you have free pancakes at Denny's and all the good things that life has in store for you today. So happy birthday. Thank you to everyone who's singing along. The chorus was beautiful. I especially like that little falsetto harmony, Greeners. That was good. That was really good. I like that. Was a nice touch. And we had the cha-cha-chas. We had everything. So good morning. Happy birthday. Have a wonderful day. With that, I wouldn't say with that out of the way, but with that accomplished, now that we know that we've got the birthdays properly celebrated, we can start to move on and talk about some other things. I'm intrigued by the Treehouse trial, but I can't. The Thurston stuff, they delete stuff right after they post it, so we have to show Thurston as it happens, and then we'll probably pick up the Treehouse trial tomorrow and then play some catch up, depending on how long it goes. Happy anniversary to all those who have anniversaries today or on or about today. Thank you to Brown Barn. Happy birthday anniversary, y'all. Kind of new here. Why do people put in exclamation point C? Nancy, this is just a fun thing that members on the channel get to do. You don't have to be a member to be here. And there's no pressure to become a member because it does require some sort of financial contribution to the channel. It's what makes it possible for me to keep doing this, but don't think that you have to do that. You being here is great and wonderful. And if that's not in the cards for you to financially support the channel, that's great. And thank you just for being here. Just make sure you type exclamation point gifts in chat and then turn your setting to on, which is what Michelle Media Madness did. And you might be able to win a membership as well. But if you have a membership, your name will appear in green. And next to your name, like Michelle Mixed Media Madness, you'll have a color of courthouse. And that color of courthouse corresponds with the length of time that you've been a member on the channel. So the longer you've been a member each month, and if you might have a break for a couple months, say you go to Fiji on a world cruise.
I'm not a camel.
And you just stop your memberships and you just focus on the fact that you're celebrating the world, surfing the world or whatever it is. in a yacht. Let's say that's your life. You might take a break, and then when you come back, you're like, hey, I want to join and be a member on the channel again. And when you join, you would then get the next color of courthouse, or you would get your same color back if you were still in the same period. So it doesn't matter how long you've been gone, you don't lose any of your progress. But that's it. And when you're a member, this is one of the only commands that is restricted just to members. Members get reserved seating. It's virtual seating. It's basically, we tell you that you get a place on the front row, and you get to sit there with all your friends. It honestly, I have to say this, to full disclosure, the view doesn't change. The view does not change. But it's a little way of me saying thank you for your support on the channel. And let's see, is the seat command working? Yes, we will do the Treehouse trial, but we can't pick it up until this other trial ends. So we're going to go back and catch up. We have a special emoji just for using catch up, and we'll do that. But Treehouse trial, it looks like it's going to be next. So we'll either start that today if this trial ends quick enough, depends how fast it ends, or we'll start it tomorrow, and then we'll play catch up and work nights and weekends. No, just kidding. We're not going to do work nights and weekends. We're just going to play catch up until we're back up live following that, as we've done in other trials. Let's see.
There's a lawsuit. My
dog Clover, good to have you here. Welcome. Look at that orange courthouse by your name. Pop in and see the orange courthouse. The other commands, to answer your question a little bit in a more broader way, there are other commands that start with an exclamation point. All those commands trigger a response from, well, it looks like it comes from me, but it's actually a bot. Some of them trigger audio responses. Some of them trigger a typed response. There's actually one of them that actually triggers a change on my system here, but I can't get it to work properly. But there's just a lot of commands you can use to interact at the same time. All right, where are we? I'm watching you and Brandy at the same time. Wonderful. Which trial is Brandy following? Is she doing the? Can't remember.
You're talking about stuff that is not relevant.
Alley Cat, member for 5 months. Happy Friday Eve. It's never too early to celebrate. Guess what we do on Friday Eve? We do a podcast on Friday Eve. Tonight.
Is that correct?
I think Weatherwatch is up for it. He may be out of town. If he is, he'll let me know. But we might have a podcast tonight. I'll let you know a little closer as it gets closer. It's usually
don't
8,
miss
8
the
PM.
forest for the trees.
Members get special emojis. Reverend Beasy, I completely forgot. Special emojis, like the emotional support zebra emoji, which we have right there, which looks a lot like the emotional support zebra I have right over here on my microphone stand. Is there a list of commands everywhere? There is a list, and sometimes the commands work. That list works, and sometimes it doesn't. It looks like it's not working right now. I haven't seen it respond yet.
Have them send someone
I can
with
check.
more
Oh, here we
experience.
go. All these words, if you put an exclamation point in front of it and then type the command, and then hit enter in chat, it will do something. It might pull up somebody's URL for their channel, a friend of the channel. It might trigger that, have them send someone with more experience sound effect. It could do something. We've got these words. We've got all the words right here, and maybe a couple more that you might just find. Like
You're talking about stuff that is not relevant.
There we go. Now they're all working. Now they're all working. No roaches yet. I'm so close.
I'm not a camel.
That's a lot of special emojis. I'm so close to having that done. It just needs to be edited down to the right size. Let's see what it sounds like. Ready?
Somebody just sent me a video of roaches fighting. I don't know who won.
That's what I want it to be right there.
I object.
I actually need to trim it because
somebody just sent me a video.
Okay, we're gonna trim it just a tiny bit so it takes the pause off on the front end. Now it's just.
Somebody just sent me a video of roaches fighting. I don't know who won.
That's so good. Okay, it's saved. Hang on, we're gonna get there. We'll have this done here in just a minute. Save the file. It's gonna be called Roaches. That's Judge Boyd, by the way, and it's fantastic. I need to save it somewhere else. File, save. Desktop. All files go on the desktop.
When
right?
are we going to break for lunch, Judge?
Okay, save to the desktop. Now we're going to move it over to my other computer where it needs to reside to make all this happen. We're going to share it with AirDrop because that's how we roll.
I'm not a camel.
Go to the iMac. Okay, nope, just arrived. Special delivery. Have to turn that off so we can fix this. Just one moment. We'll get roaches working, okay? Hang
Have
on.
them send someone with more experience.
Okay, commands. Chatbot commands.
Bring the jury.
We're going to mirror another one. Probably the squirrel one. Let's see. Yeah, let's mirror that.
Don't miss the forest from the trees.
Hang on, guys. Hang on. And they updated the software. Now there it is. Copy.
Alex stole it.
So now we have 2 squirrel commands. Now we're going to fix the other squirrel, and it's going to be
When are we going to break for lunch, Judge?
no chatbot. Audio. Select audio file. Get rid of squirrel. Select roaches. Bring the audio down. Test audio.
Somebody just sent me a video of roaches fighting. I don't know who won.
Have them send someone
Somebody
with
just
more
sent me. Somebody
experience.
just sent me a video of roaches fighting.
Okay. All right, there's the audio. The cooldowns is going to be command cooldown, 60 seconds, so it can only be done at least once, the most once a minute.
Don't miss the forest for the trees. Because he's the guy.
Okay, complete. And we're going to call it roaches. How about just roach? Just roach. Does that work?
Have them send someone with more experience.
ROACH. I like the
jury.
commands nice and short. And everybody can do it. What does skip Q mean? Hang on. Oh, don't skip Q. I need to change that setting on all of them. Okay. I'll fix that.
I'm not a
That way
camel.
sounds don't. Okay. So now we're done. The command is set up. It took that long to build it. But let's see who gets the first.
Somebody just sent me a
Somebody
video
just
of
got it.
roaches fighting. I don't know who won.
There we go. Now we have Judge Boyd as with the roaches. What's with the roaches, says Nana 233. You need my phone? You're ordering from the store.
Are we going to address subject matter jurisdiction?
I have this mug that was sent to me that has Raid on it. Look, maybe I can do it this way. There's the logo, the Raid logo. There was a bug in my studio crawling on the wall. It was a roach, and the video clip the clips that contained my reaction to all of it as that happened were put together by a good YouTuber named Rob from Lawn Lumber and into an epic little montage, and it became a thing. So I even had somebody send me a 3D printed cockroach monster, which is massive and has big, huge jaws. It's nasty. Anyway, that's what the roaches are. And then we heard in Judge Boyd's court, she's announced something about roaches.
Somebody just sent me a video of roaches fighting. I don't know who won.
It's Febreze, not Febreze. Did I say the wrong thing? I said it how we say it in the South. Febreze. But is anyone following Melanie Little on the Karen Reed case? Melanie Little's following that. Brandy Churchwell is following that as well. Both fantastic YouTubers with great insights on that. We will not be following Karen Reed case. I'd encourage you to watch. Brandy's our first go-to, but Melanie's also great. So They've done a lot of work digging in the background of that, so I'd encourage you to watch over there on those ones. Ohio Palm Mom says, I found you through Rob's clip. That was fun. It was a lot of fun. Rob did a good job. Peter Tragos had a roach too. Yes, like a week or two later. It was fantastic. He like squished it and it was all over. Oh yeah, it was too much for me. Not seeing comments on the screen. Anyone else? I can see them. They're right there. Sorry, my bad. Amanda, I turned them back on. We speak cornbread in the South.
Somebody just sent me a video of roaches fighting. I don't know who won.
Roachgate has begun. All right, we've got it fixed now. So let me go ahead and close this out. Done. Close. We've got a couple things coming up. First of all, Thurston, Washington. The Treehouse trial is going to be a lot of fun. It looks awesome. Did I spell Febreze wrong? I mean, is that really? Febreze. Okay, so I have to fix that now.
I'm not a camel.
Chatbot commands, roach, edit, cooldowns, go get the southern Febreze.
I was kicked back, taking it easy.
Why is it not working? Using the wrong keyboard, that's why it's not responding. All right, there we go. Complete and save. Refresh.
Don't miss the forest for the trees.
All right, and now we're back. Okay, we are a little late.
Somebody just sent me a video of roaches fighting. I don't know who won.
I think it's a little loud. I might turn that volume just on that one down a little bit more because it was a good, clear audio. All right, so let's do this. We are going to we're going to get ready for a court up in Thurston, Washington. Sorry, I'm a little distracted. So let me get the feed going here. Let's see. See, District Court on YouTube. We're in court 4, right? Are we in court 4 for this one? I think it's 4.
When are we going to break for lunch, Judge?
Because this is a West Coast trial, I realize it's starting late in the day. It's starting about our lunchtime. But
You're talking about stuff that is not relevant.
Google wants to know your location. Why? Don't allow. Why would I do that?
Bring the jury.
Okay. Court 4.
Is that correct?
Okay, so yes, we've got court 4. So as soon as that comes up, we'll have that feed. The Toyota Fibris. The Toyota. So apparently I said reckless wrong, right? So it's a reckless charge. I need to fix that as well because I'm gonna. If I don't fix this now in the title
Somebody
and in the
just
thumbnail,
sent me a video of roaches fighting. I don't know who won.
If I don't fix that now, then it's going to. I will get messages on the burner phone for perpetuity. They'll go on forever and ever and ever. So let's fix both the thumbnail, which I just fixed. Download over Prius. YouTube thinks now is a good time to insert ads, and what they don't know is it's never a good time to insert ads. Change for Prius. Right there. Thumbnail is now reckless without the W. Save. All right. It's all corrected as if it never even happened.
Bring the jury.
Brandy is covering Trichonis. That is not the Treehouse trial, right? But remember, this is a climate-friendly Prius donut case. It is, very much. So let's go over a little bit about this case. PNW transparency, the trial yesterday, because the jury selection took so long, they ended up taking longer during the day, and we only got through the opening statements. So we have the opening statements from both parties have been provided. That's where we found out it was a Toyota Prius.
How did he do that?
His mom's Toyota Prius that he was allegedly, out recklessly driving in. So we're going to have the rest of the trial today. We're going to have the witnesses. There will probably only be 2, maybe 3 witnesses, not very many. Then the defense is going to have their shot. The defense may not have any witnesses at all. Don't be surprised if you don't see them have no witnesses. Uh-oh, somebody's calling. Just one second.
Squirrel!
Hang on, Hank. Hold on one second here. Hank, hold the phone. Okay, don't go anywhere. Just one second. Because I haven't plugged in my phone yet today, so I need to. I'm going to take this one on the air. I think we have Hank Blatt on the phone. Well, we'll see here. Hang on one second. Hank, can you hear me?
I can hear you.
And I can hear you. How's it going, my friend? You're live on the air.
Good. It's reckless, not reckless.
Thank you.
I'm sorry. I just had to call and do that.
It's fixed already. Look.
Also, if you can avoid driving in Thurston County, I think I'd recommend it.
Yeah, what is Thurston County for the locals? I guess PNW maybe. We've got a couple up there that are in Thurston County in chat right now. Is Thurston County known for, like overly? PNW might have a little tainted view of this, but are they overly aggressive police officers? Are they the law enforcers taken to the next level? Like you were speeding 1 mile over, or we were going to arrest you and take you to jail type thing. It's the reckless
It's
Prius.
just funny that every case we look at there is always about the traffic infraction.
They have. I'm surprised at how many traffic infractions go to jury trial. And I don't know what it is. I need a local to explain it, because honestly, when you look at our legal system in the U.S., they're known for their weak cop cars now, says Ayden. When we look at the U.S., this is a right everybody has when they're charged with a crime. You have a right to a trial by jury of your peers. Okay, most people, the vast majority of people who get a traffic accident, even if they, first of all, a lot of them are able to just pay a fine through the mail and it's done. But if you have to make a court appearance, most people make their court appearance, say sorry, pay the fine, and go. And the number of people who fight it is very, very low. And the number of people who fight it and then get an attorney and get a jury to hear it, it seems like a waste of time. But at the same time, this is the system we have. Okay, in our country, we fought a revolution over the fact that we could not get these juries of our peers.
Somebody just sent me a video of roaches fighting. I don't know who won. Thanks,
Judge Boyd. Literally, this was one of our complaints. Okay, when the colonists wrote that letter to the king, they said, "Hey, this is what we don't like. When we commit a crime, or you say we commit a crime, we're charged with a crime, we're dragged all the way over to England, and we get charged, and our case is heard over there, not by people who are here, who know what we're living like, what the situations are, and how things are different here. So this right to a jury trial, it's ingrained in our country, in our Constitution." For some reason, Thurston County, everybody just knows that resonates with them. They're like, "Oh, good, traffic got pulled over. I get a jury trial," and it's cool to see, but at the same time, it is sort of funny because we end up seeing a setting that we more commonly associate with a more serious event, say like a murder or attempted murders and things, these serious felonies and crimes where people could spend the rest of their life in prison. And now we have that same setting with a jury, usually albeit a smaller jury, usually 6 members instead of 12, that are deciding whether this guy gets a fine and suspended sentence, if he can't drive for 3 months. But it's fun. Hank, what if you were in this situation? If you had a cop behind you that had pulled you over and alleged you had done something, and maybe let's give you this, and maybe he sort of over ticketed you. Okay, he said you were doing 40 in a 20, and you were doing 35 in a 20. Would you get a jury? Would you take it to court?
I don't know.
Well, you have that right, Hank. We do enjoy Thurston County. It's a lot of fun. I don't know. I think we need to visit there now. It has to be on our bucket list to go up and carefully drive through follow the speed limit. Don't cross over the gore point. All the things we've learned from all these traffic. No reckless driving in our rental Prius. But it's good stuff. Hank, I can't wait to watch the end of this case with you. I look forward to your comments in chat. Thanks for the call, my friend.
Bye.
Bye. Oh, man. We've got a couple people up from Thurston. Tell us a little bit about it. Tell us a little bit about Thurston. What makes Thurston different? Cynthia says, I'm up north of Thurston. I'm in Skagit. Down south is a bit more in the sticks, and they are a bit more lenient. The Brown Barn says, when we lived in Washington State, they used airplanes to clock speed and then sent troopers to pull you over. I've never seen more people pulled over for speeding. That is just not fair, really. The traffic enforcement, it has always been a game, and don't let anyone tell you otherwise. I realize, sadly, people can get killed through people's poor decisions in driving, and sometimes through accidents in driving, or mechanical malfunctions and everything else. But following the law, specifically the speed limit, has always been a game for almost everyone who drives, and it's how fast can I go and not get in trouble. Every state has a different limit. There are some states where, like, hey, 3 over is okay, but 4 is not. There was a small town that I got my first ticket in that I found that out that 4 over was not okay, and they told me that had I only done 3 over, it wouldn't have pulled me over. But 4 over is not okay. Uncivil law says you're only entitled to a jury under the U.S. Constitution if you're facing more than 6 months imprisonment. Baldwin via New York. So these are criminal charges. Typically, a traffic infraction would have to be. Well, in this case, had he just been speeding, he would not be entitled to a jury, is what you're saying. I guess the court must have just looked at that and said, look, too many people are wasting the court's time fighting these speeding tickets in 1970. Thank you, Uncivil Law, for the education. We can always count on you for insightful information and updates. So now you know, jury's not going to get you off the hook for 3 miles an hour over. You're going to have to do a bench trial for that one. You can still go to court. You can still take it to court and have the judge hear it, right? Is Hank in chat right now? I think he is. I think he's in chat. I keep my eyes on the road, not the speedometer. Likely having his license suspended until he's 21. Okay, Barbara Johnson, this gentleman, the 16-year-old who's being charged in this particular case in Thurston County, I think he's got some priors, right? I think he's got something about driving on suspended license or driving without a license. Something else that happened that's on his driving record. And so this would not be the first offense, and it might be treated harsher that way. But I think his maximum is like 1 year in prison for this, because reckless driving is a crime. It's not just a traffic infraction, it's a crime. And he also could have up to a $5,000 fine. So I'm not sure if in addition to that there are suspensions of the driver's license. What's mutual combat? That's a duel, right? Mutual combat. They use airplanes and cop cars in New Mexico and Texas on I-25 and I-10 respectively. The technology is there. I mean, unfortunately for people who do get caught speeding, the technology does exist to clock a car very accurately from the air. Is it illegal in that county to have radar detectors? Isn't Arizona the anti-radar detector state? There are a few where they're not legal. There are some. I'm not going to send you down this rabbit hole, but there's more than just radar detection. There's radar jamming technology that's available. Typically, when you get caught using a radar jammer, they want to throw the book at you. So we don't recommend that at all. But it just from an interesting technology standpoint, there's some great equipment out there that makes it difficult for police officers to clock you. Try own a Prius in Wisconsin. The battery wouldn't take 5 winters sitting outside every day. One cool thing Washington has is mutual combat. Only Texas has it also. Mutual combat. Is that when you say, hey, we'd like to go out, we're going to settle this out in the alley by agreement. What are the rules for that? Let's do a quick Google search. Texas and Washington mutual combat. Washington mutual combat. Mutual combat states 2024. Washington state is only one of 2 states in America where mutual combat is totally legal. Reddit has an article on here, of course, in the /Seattle Washington Reddit. Mutual combat is legal in Washington. Okay, hang on. Diving into Reddit here. You and I can declare ourselves fighting and beat each other up lawfully. Do we get immunity from liability or injuries when we fight? Asking for a friend. Then there's a counter opinion. It says there's no mutual combat law. There has not been for a long time. Washington state law is simply written in such a way that excluding domestic relationships, romantic, sexual, family, and roommates, for the crime of assault to occur, there has to be a victim. If 2 people who are not in a domestic relationship get into a physical fight and one of them gets injured but refuses to assist with prosecution, no crime occurred. There are always exceptions to this if the victim is mentally ill, high, drunk, etc. It's not against the law to fight physically in the city of Seattle. It is against the law to fight in such a manner that creates a substantial risk of injury or harm to subjects not involved in said fight or to property that does not belong to the involved subjects. Certainly open to interpretation, but if you and your homie who have never lived together want to throw down, find a nice empty alleyway with no cars or people around and have at it. Crank Janker on Reddit gives us that breakdown. Mutual combat. Don't worry, you have to both agree. It's not like somebody can just want to fight you and it's okay for them to beat you up. You have to both agree to make that happen. Okay. Have a fight, then buy each other a drink, kiss and make up. So fisticuffs are more acceptable than cannon warfare. Yes. Although the important thing is cops can't even intervene. They have to just watch. And then at the end, they talk to the loser like, you want to press charges? And like, no, I'm good. And so they're like, oh, it was a waste of time. Nothing illegal happened here. Fight clubs everywhere, says Judy M. We don't talk about fight clubs, Judy. That's the number 1 rule. Apparently, is it organized? Is it different if it's organized and people are betting on the outcome? Do you need different sorts of permits, or is that also considered mutual combat? Does it include dueling? It can include dueling. There's no way. Let me just say, there's no way that this law allows a fight to the death, right? Because then you have a victim, and when you have a death occur, the person who died does not have to say, "I'd like to press charges." Right? Otherwise, you would never have a murder case. Yes, very much different. That's licensed by a relevant state authority. It's funny that we have government agencies that control when we can fight. Had to take an oath not to duel to become a member of the Kentucky bar. Barbara, Kentucky. Was that enough? Was it enough of a problem, Barbara, that they had to be? We've got to make this rule because we've got this. We're losing bar members. We're losing bar members because of this duel situation. We've got to have them stop dueling. Oh my goodness, crazy laws all over the United States. It's funny that some of these laws are very, very old and on the books, and just have never been changed. And some of them, are so recent. You're like, what in the world led to this? What was the situation that the legislature in this state decided that this was the right solution to whatever problem they were facing? Can state authorities manage other criminal activities? It's not criminal if it's state sanctioned, right? That's the thing. It's if you do it without their consent that it's a crime. Didn't the president lose a duel on the White House lawn? We have a colorful history when it comes to politics, especially going back a ways. There had to be enough of a problem to make it a law in the first place. Yeah, but they're the laws that, you read about, strange laws about you're not allowed to walk your giraffe on the side of the freeway, and it's like, okay, clearly this wasn't like an endemic problem. I mean, it wasn't widespread. Everyone was doing this, and it was causing problems, right? There was one guy with a giraffe, and there was another dude who didn't like giraffes, and that dude who didn't like giraffes happened to have some friends or he himself sit on the legislature, and that's where laws like that come from. He had enough favors that people would just go ahead and pass it. Imagine you lose. Who was this saying? Imagine you lose a trial and then challenge the defense attorney to a duel. Yeah, you just you take off the glove there at the end and you throw it there in front of the jury, and it's recognized as just part of an extension. It's almost like an appeal, Carmen. I imagine the duel after the court case is the first appeal. How do you stand those blinking lights on your panel? I can tell you, Nana. And here's the secret. To me, they do not blink. Honestly, they're not blinking. They're solid. Now, granted, they are in reality, they are blinking, and the camera rate of this camera right here that is filming them, the refresh rate occasionally catches a moment where the pulse width modulator of each one of these LEDs has turned off and on the light, because that's how an LED works. They save a lot of energy because they're not always on. They're off more than they're on, right? So they're turning on and off very, very quickly, and to our eyes, we can't see the difference. But to the camera shutter, who takes a very rapid picture, it can catch the moment when they're turned off. But the way it doesn't bother me is because I can't see them unless I look at the screen. I can turn them down if they're too bright. Does that? Let's see if I can fix these here. Let's see. Labels, audio controls. Oh no, I can only turn them brighter. I can make them. This is all the way down, and this is all the way up. That's all I can do. They're all way as dim as they can be. Sorry about that. All right, we've got a few minutes. Is there anything else we need to discuss before? Because we've got quite a while before court starts. This West Coast trial, they start like halfway through the day. Texas has some weird laws. All the states have some weird laws. Rules for thee, but not for me. Power corrupts absolutely. There's a legislator here in New Mexico trying to put a law against necrophilia on the books. Nothing on the books yet. Wow. There's a case we won't be following. You have a law in England that forbids members of Parliament from wearing suits of armor in Parliament. Also, taxi drivers are supposed to ask if passengers have smallpox or the plague. It's like, hey, it's just a formality. But me as your cabbie here, first of all, welcome to England. Thanks for flagging me down. Do you happen to have smallpox or the plague? Is that I just have to ask. Shutter speed of 130 can fix it, says Mother Oats. You know what I can do? Check this out. I can control my GoPro using like this camera right here. I can control it using QR codes on screen, which is a really cool feature they enabled. I just have to find it. Here we go. QR codes. Wait for it. Okay, so the code's going to look like this. And it's a rapidly shifting and changing code that actually programs the, let's see, frames per second. Let's change it down to 30 instead of 60. Is that what you said would fix it? Still linear. Let's see if this programs it right. It's not. Oh, I have to take it out of HDMI mode. So hold on one second. Okay, it beeped. It accepted the code. Let's plug it back in. Did that fix it? It didn't. It didn't fix it very well. What if I change it to like 24? No, I can do 24, 25, 30, 50, 60, 100, 120, 200, 240. Seems to still be blinking, if not even faster. Okay, Ivan's on the phone. Just one second. Let me talk to him, and we'll figure out how to program the camera.
Call from
Mr. Ivan.
Good morning, Ivan. How are you doing?
Hey, just out running police here on the moped.
Yeah.
Below zero, doing donuts in the Walmart parking lot.
Recklessly. Yeah.
Think I can outrun them?
Is it your mom's moped? That's the question.
Yep. It's older than me, just like this Prius. The Prius is literally older than the defendant.
It is.
It's a fact that I think is being ignored here. Okay.
Oh no, I just unplugged you. Hold on a second, Ivan. Come back. You said the fact that you think is being ignored here. Say it again.
The fact it's being ignored is the car is older than him. I'm not a math surgeon, but 2008, 16. I mean, for crying out loud here. Can you just imagine the DA's office getting this case and having to see that it was a Prius, a 16-year-old Prius that supposedly outran every one of those cop cars. I don't care what brand they are. They have what's called an enforcer chip. I mean, the terminology may have changed over the years, but they're not just your standard. They're already like souped up to begin with.
They're high performance. They're high performance. They're very responsive. They accelerate faster. They generally have a couple of little bells and whistles that makes them more capable in a pursuit. This officer is going to have to testify today that he couldn't keep up with the Prius
for 4 blocks. I mean, 4 blocks. It's not like he's saying he whips around the corner and a cop car he could have that car turned off. Okay, he could have a box of Krispy Kremes on his lap right as it happens. Car turned off, just listening to some Willie or some Merle, and he could start that car and catch up in less than 4 blocks. Okay, that's what I can't wait to see the dash cam video because the DA said some pretty assertive statements in her opening, as short as it was.
Yeah, it was short. She left out key facts like the fact that it was a Prius, a 2008 Prius.
Man.
The way she described it,
meeting?
I would have thought it was like a Camaro.
There was a meeting amongst the minds. We leave out Prius. Was there we can't say Prius, right? If we say Prius, we lose the jury in the first 30 seconds, right?
Yes, the Prius, both Prius and 16-year-old are two things that the jury is just like, I've heard enough. Tell me no more. Yeah. I'm ready to vote. Okay, a 16-year-old having to drive his mom's Prius to school. You can't convict him of anything. He's already been shamed beyond all possible shaming. Nothing this court.
Buddies. Can you imagine his buddies? I mean, oh my God. 16, all you're trying to do is look cool and, do some donuts and this is the car you got and you're grateful for it. Yeah, but dang it, it's a Prius. And so, dude, his buddies must be, he's going to have, his nickname is going to be Prius until he's 82 years old. Okay. That's coming.
Yeah. And I realize Hostronic says electric hybrid cars can accelerate immediately from stop because of their torque. They have the instant power to ground. It's really cool. It's awesome. But I mean, the Prius is not a Tesla Plaid. Okay, this is not a vehicle that's going to be winning.
2008 electronic vehicles are not Teslas. Okay, they are not even in the same. That's like saying a golf cart is a Tesla because it's just not the same thing. That's what makes Tesla so different is the fact that they are so fast. You know what I mean? That's what he has. Done differently there because before they were literally you could hear the thing winding up, like a jack in the box, ready to finally kick into gear.
Yeah, but launch control. There's the Prius has launch control. He's just revving that battery.
Yeah, right. You're cranking you're cranking an old phone. I mean,
even if the defense doesn't win any points doing it or score any points in the argument. I hope they bring up that just to sort of bring up the absurdity of the situation. And I realize everyone who's got a Prius says, yeah, they can go fast. You know, you can get them up to speed, and he was driving fast. I'm not saying that's impossible for this to happen, but the way they describe it, it was like it was in a street race, and you've got 6 jurors and dollars to donuts. That one of them owns a Prius. Okay, one of them owns a Prius.
One of them's been in one.
Yeah.
Or at least tried to passing a car on a 2-lane highway in a Prius. That's like a death trap. That's scarier than a 1980s slide at a park. Okay, you don't know what's going to happen, but So, well, in any event, I would honestly take a side by side. These new side by sides, 1-on-1 on the line in a quarter mile.
A Can-Am. I'd take a Can-Am any day.
In a quarter mile, no questions asked.
Yeah.
But this is where a good closing, man, I hope this lawyer has been practicing this closing, because we know it's not evidence, but that's where he can really lay in to, like you were saying, the absurdity of the situation. We have a 16-year-old in a car that's as old as him, and it's a Prius.
Yep.
Case closed.
Here's the thing, that at the very beginning, and Ivan, I'll let you go. Thank you very much. I appreciate the call. I'm going to talk a little bit about the judge, if that's all right. But
go ahead.
Thanks, my friend. Catch you later. Bye. The thing is, at the very beginning of this case, we watched right before the all the motions in limine and all the pre-trial arguments. We watched the judge get up there and say, "You guys, I just looked over the docket and read a couple of these documents, and I'm just, you guys sure you can't work something out?" And I've never seen this, and honestly, it was probably inappropriate for the judge to do this, but to say, he's 16. He's 16 years old, and you're charging him with this reckless driving that's going to stick with him for the rest of his life. Is this the face of the prosecution? The prosecutor's office that we really want on display in this situation, where he was speeding by a park. There could have been people there, but there weren't. Even in the opening statements, the prosecutor's like, he sped past structures that typically have, that people play at. It's like, okay, this is a bit of a stretch, right? It's like he sped through a crosswalk that no one was in. It would be different had there been kids there. It would have been different for that. But the judge looks at this whole thing and says, "You guys, he's 16 years old. Okay, reckless driving in a Prius. This is what you want to have him branded with for the rest of your life." And she gave them opportunity, saying, "Hey, talk this over. Come to, see if there's something you guys can do, because I've seen cases where we've got people on repeat offense DUIs in here in court, and you guys look over and you're like, hey, okay, we'll make a deal. We'll make a deal for you. I realize this isn't the first time you've got drunk and got behind the wheel and drove and could have killed anybody, but we're going to cut you a deal, and we're going to lower the charge, and it's not going to be the impact that this is." And she's like, "And this is not a DUI. This is a kid who was having a little fun in his mom's car, and it was a Prius." And so she presents this to the two sides, and they do nothing. They do not talk to each other one bit. They just sit there. There's no conferring going on. This new prosecutor lady, this is her first trial. She's going to run with this all the way till the end, apparently. So we have had one prediction already that the judge is going to, if asked, if the motion is made, is going to rule with a directed verdict. And I don't know if she could do that. I think the judge has to rule based on the evidence. And I think there's enough evidence that there was some reckless driving, unless, of course, the donut was on private property. And what you do on private property is not, it's not the same. You can't get a speeding ticket as you're racing your four-wheeler in your field, right? So I don't know. There could be a directed verdict, and we'll see if it goes that way. I think the judge would be happier with this kid not getting sentenced with a conviction for this. So let's see. I have to unplug that camera one more time, and I'm gonna go up to 120 frames per second, see if it fixes the flashing lights. Okay, we're up to 120. Let's, it does nothing. It's all the same. Flash, flash, flash. Now they just seem to flash at weird speeds. Flashing lights are here to stay, apparently. All right, Cast the Sass, sorry, gifted 5 Recovery Addict memberships. Gifted I Wasn't Born Without Thorns, Michelle Johnson, Franco, BG, and Linda Dockery. Congratulations to the winner. Thank you very much, Cast the Sass, for that generous donation. 1/100th. Do I have 100th? Yeah, I can do that. I have to switch cameras. I wish I could program it while it was like live, so I could just like show the picture and it would be done. I think we're trying to find the refresh rate of the. Oh, look at that! Look at this, guys! Look! That was it. It was 1/100th. That was the color. I mean, that was the speed. Who suggested that? Who was the 1/100th suggester? The frame rate. Adam Sharpest Mansky, you are the winner. You fixed a problem that we've had for, I don't know, a year on the channel. And you did it in 5 characters or less. Congratulations. Everyone's like, I didn't even notice the flashes till now. Thank you from Julie Weaver. Thank you very much for the super chat. Appreciate that. So the frame rate is 1/100th. Is the fix. I imagine it would probably also be fixed on, because you're still getting a periodic flash. Like, watch this red light. Occasionally it will just go a little flicker. It's probably also work on 150 frames per second. But that's a little better. Cash cow's in the way. You can't see everything. But winner, chicken dinner, Adam. Adam Sharper, Image Mansky, and we now need to update your name. Are you stuck with what you have right now till Monday? Not sure. I killed the lights. Hey, in this quiet period while we're waiting for Thurston Court to start, I'm glad we could accomplish something. So we've got a sound effect who's now there. We've got the sound effect from the roaches, and then we also have the lights fixed. I mean, what else can we accomplish in the next half an hour? Allie Lane says, just another perspective and probably not popular, but there is a reason we have minimum driving age of 18 in Australia.
Somebody just sent me a video of roaches fighting. I don't know who won. Did I cut off? I think I cut off the won part a little too tight. I might have to redo that one. We can watch you do TurboTax. Greeners, I have called the company. I've called the company and said, look, I surrender. Every year leading up to this, I've done my own taxes. It's a point of pride, even since I was just a young lad working at a fast food restaurant which shall not be named the Golden Arches. Ever since I was just a young kid and filing my taxes, I did them myself. Did them myself using software called TurboTax, which always advertised that it's free, and it ends up being like, oh, it's free for everybody but you because you have a special situation which requires this form. Now we have to charge you $50. So I've paid for TurboTax every single year to do my taxes. And last year, I realized that it needs to change. And this year, I definitely need an accountant to do my taxes, because I have lots of things that, as I've built this channel, that I've got expenses and things I don't know what to pay taxes on and what not to. And we've got income coming in that I didn't have for a long time, and so now, yeah, we're gonna pay somebody else to
I'm not a cat.
Calculate that. Julie Weaver, never feel bad. Never feel bad. Just being here is great, Julie. Thank you for your generosity. Don't feel that you should give when it's tight like that. Not at all. Please just be here and enjoy and keep your gift setting turned on. That's going to be great.
There's a lawsuit.
All right. We don't need a criminal charge to get a kid to stop acting like a kid. Age and paying your own bills does that just fine. Let's see. I'm stuck like the lights. You can't change your name. Rudy Patootie didn't get my license till I was 33. I think that might have been a personal choice, probably not a state rule or something. Spend the next 30 minutes making a clip about the MIT method. Oh.
I don't think we're going to do the MIT method. That's just, I mean, we've got sound effects. We have sound effects that are similar in theme. Right?
Your son just smeared feces all
Have him
over
send
my
someone
bathroom.
with more experience.
We've got sound effects that are potty humor related. That was from the Mark Jensen trial, that clip I just played. But they're just not always appropriate. We don't. A lot of people come here and like, you know, I'm cool with everything else, but the toilet stuff needs to go. Lucy JBJ, it's my birthday. Congratulations, happy birthday, Lucy. That's awesome. Medicare, 65 Medicare. You see, did you see Mr. Anderson, the hand video? Did I send it? I did not. Jamie, I need the link. I was going to send it to Joe, Dr. Joe, I think. Or at least a link to it. I just haven't dug in to see when it was. Let's see, dead battery again, and dang, this isn't even a year old. Savannah, my phone lives on a charger. That's the only way I'm able to keep it going all day long. I would get a new one and give this one to Mrs. R.A., but she would not plug it in either, and then it wouldn't do any good. It's Dr. Joe who hasn't seen it. Oh, we need to find where the hand video is. Did we do it separate from everything else? Let me refresh my feed here to make sure we're not missing anything. Thurston County has not started. Let's see, K-Rab says, I had to laugh. I drive a Prius, and I can't imagine a car less likely to be driven recklessly. LOL, it boggles the mind that the cop car couldn't keep up. That's what I'm saying. If there is a Prius owner on the jury, he's going to be like, look, guys, I hate to break it to you, but as much good as we're doing for the environment by driving an electric vehicle, it's not good for the driving experience. This is not the performance vehicle that the prosecution has made this out to be. Marilyn Skoll, attorney for 11 months. Love this community so much. Thank you for being here. Marilyn, one of the huge supporters at the attorney level for us. Marilyn, thank you so much. Appreciate your support so very much. 11 months, you're almost to the 12-month mark. That is wonderful. You can get a new colored courthouse here next month. I hear in Texas, says Dilly Pickle, I've always done ours for all three businesses, but I've about had enough of it. Now there's like what's the Fin? I forget what it was. There's some Corporate Transparency Act, the CTA that applies that now you can't hide behind a shell company anymore. I think at least most people can't. It's a separate video. Okay, a separate video means it will be easy to find. Ivan says, I hate how Apple and iCloud have made me Apple dependent forever. Oh, that's how they get you. They give you a few free gigabytes of space, and then once you put everything you need and own on there, you can never leave. It's like a storage unit that you can't take things out of. You have to keep it in the storage unit for the rest of your life. Look at this, Dilly Pickles. Dilly Pickles, jury member with 12 months. Orange Courthouse. Thank you very much, Dilly. That is awesome. That is just wonderful. It wouldn't be the same without you here, Dilly Pickles. Glad you could be here. Congratulations on a year. I'm going to make some left-handed mitts for post-surgery. Left-handed mitts. Carol O'Neill, welcome to the gallery. Look, Yellow Courthouse. Thank you very much, Carol, for your support. It's iMessage that won't let me leave. Man, do you guys have that one friend that's on an Android? There you are. Cast the sass. You're the friend that's on the Android. Everyone else is on the iPhone that fell for the trick. And now we can't text you. What is it with Androids and Apple phones that we can't text each other and have it just work? You have an S-Corp, so you have to send in some forms. I think I have to be an S-Corp as well. S-Corp's the only way to avoid some of the taxation issues. And, oh my goodness, are there taxes? Wow. What was the post office scandal in the UK, Welshie? I did not hear about that. What's our posties over there doing? Android for life. Android all the way. You leave us Android people alone. I apparently stepped on some feelings there. I apologize. Let's see. I'm on Android. I don't text, Snapchat, and WhatsApp are in Discord are all cross-platform. And WhatsApp's encrypted too, right? Isn't that encrypted? We might have to. Let's do a quick poll and see. I honestly I don't know. We're going to do one of the most important polls of the day. It's going to happen right here. I need to see how to spell something. I need to turn off. You can't hear what I'm saying. It's going to be a secret. Okay, I spelled it right. So the poll's up. The poll's up. For those who can't read it, the question is, I pledge allegiance to, and it's either your choice is Apple or Android. Apple's the first selection. Android is the second. So we'll see where everyone falls. Ricky, we can watch Judge Boyd. Here's the problem: we've got 22 minutes before court starts in Thurston, Washington, and we have to watch that live because they often delete the video as soon as they're done. We can't go back and watch that. Judge Boyd has her videos stay up. She has a trial that's starting today. I believe they've got a jury selection again because the jury got tampered with out in the hallway immediately before their last one. They've also got some issues with some illnesses with some witnesses and defendants in that case. Wow, it's holding, the percentage is holding right at 50%. This is remarkable, guys. It's neck and neck. If you've ever not voted thinking, oh, my vote doesn't matter, now it does because we are tied right now. We are tied. I see why we're tied. The Android folks are voting multiple times. That's it. No, that's all good. Carol O'Neill, I didn't welcome you to the gallery. Welcome. I think I did. Talia, bus stop juror, says, yay for 2 months longer, but yeah, best way to spend my days off. Talia, thank you. Thank you very much. Glad we can enjoy your days off together. Greeners is adding fuel to the fire, saying Android equals Reddit. Is there a correlation between the two, the usage of the two? See, I had an iPhone. My brother talked me into an Android and broke 3 Androids in about a year. I switched back to Apple because I can do more with it. So, Britta, let me tell you what happened with my phone this morning. I woke up, and in my mind, it was 2 a.m. It was 2 a.m. and I was mid dream. And it's one of those dreams where, in that moment, if you said what was your dream about, I could have written probably a 4 or 5 book saga, a series of it was probably some weird twisted sci-fi fantasy novel that I had been dreaming, and I could have filled out all the details, and within about 2 seconds, all those details were gone. I just knew that there was something, and I was on guard. I had to watch for something, and I also knew that in real life, my ears had heard beep, 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 back door, which means somebody just came in my back door. So I reached for my phone. What do you think I was going to say? I reached for my phone, and in my haste to grab it, because I don't know. Why did I grab my phone? I don't know. It's like I couldn't control that any more than I controlled what I was dreaming. As I grabbed my phone, it's sort of I scooped it up, but I didn't get it in a grip, and I chuck it, okay, because I'm trying to stand up and jump out of bed to see who's intruding in my house at the same time, and I chuck it at the floor, which I have hardwood floors in my house, and it just bam down on the ground. But because it's an Apple, it does not break. I have never broken an Apple phone, and I've had them for I've had Apple phones since they had the Apple III, and I haven't had every one, but I've had Apple phones since then. And I chuck it at the floor. And in testing my throw the phone at the floor exercise, like we did in the Alex Murdaugh trial, the phone does indeed turn on, and it shows that it is 6 o'clock, and it's my son who's just leaving to go out with friends because he has an early morning class that he goes to, and
And it was all in one moment. I'm not sure why I'm telling you that story, but oh yes, the Apple phones don't break. And that was I don't know what my dream was, but it had me so on edge that when that backdoor alarm went off, I threw my phone. I have a drawer full of broken Apple phones. You know you're going to break a phone in the next month right now. Well, Vermillionaire, if I do, I'm due for a new one. I mean, I'm to the point where I think if I were to trade in this phone, they would be like, wow, I didn't know they still connected to the network. It's been a while since I've seen one of these. I have 3 wrecked iPhones, usually involve horse riding. Does the horse step on them, or is it back pocket saddle situation? Apples don't break, they rot. So 6 isn't so early. It wasn't that early, but the wake up, the sudden wake up, my body was not ready to wake up then, which means I went and then laid down again. And then I got up after I was supposed to already be live. So I would have been fine had I woken up half an hour later. But that's what happened. More people have voted than more people have not voted than voted. Okay, we're going to close the poll, and I have to tell you right now, Apple is winning. So if you're an Android fan, get your vote in now. But it is neck and neck. I would have thought that it was a little bit more slanted. So we've got about 10 seconds here. To who came in? It was my son actually leaving. It was my son leaving, and I forgot that he was leaving this morning to go to his class. Okay, so we're going to go ahead and close the poll. And it is... Okay, it shows Apple with 50% and Android with 49%. What Apple, the polls do this. They're tied at 50%. There are only 2 options. One has 50%. But it was 50-50. So we are split down the middle, but Apple came first. There we've Apple products are far too expensive. They are, but the Androids are also getting pretty expensive. I mean, they've got like 30 cameras on the back. That's not cheap. Judy says, for the past 2 nights, I dreamt I was partying in Vegas. Never been to Vegas. Don't go to parties anymore. Why were my deceased parents partying with me? Weird dreams. Vegas parties are weird, all in all. All right, I've lost 2 iPhones riding horses myself. None broken at this point. Maybe I should start metal detecting where people ride horses. That Sarah chick. So what happened? Who was at the back door? It was my son leaving to go to his class. That's what happened. But yes, that was the rest of the story. It turns out it was nothing. But I was dead asleep, and that little beep you hear, where you guys think it's the microwave's done, it's actually my alarm system, and it every time a door is opened, it will tell me what door. If it's a garage door, if it's a basement door, if it's the back door. We've got sensors on all these doors. And when the sensor is triggered, it will tell me which one was triggered. And when we first moved here, we got this alarm system when we first moved here, and I hated it. And now I can't live without it. I need to know when my kids are leaving and where, and who's coming in and what. And really, it's just to keep an eye on the kids, who's where, who's running outside. But now I couldn't live without it. All right, where are we on? No cell phone, they track you, says Celestial Force. What about a burner phone? Treehouse trial tomorrow. I believe we are. As soon as we get this, there's this Thurston County Court underway. Oh, I didn't realize I was off screen. Sorry about that. As soon as we get Thurston County out of the way with this trial, which should be pretty quick. I imagine starting at 8:30 in the morning, they're going to most likely be in deliberations before lunchtime. Let's see, Thurston County is going very slowly. Thurston County, District 4. Should be going in the next 15 minutes. Had a coworker tell you he was switching from iPhone to Android when the new Samsung comes out next week? I wonder if he stays. A lot of people have a hard time with the transition.
Aria's home is more secure than Cavalcante's prison. I do take home security quite seriously, and both electronically and backup wise. I will tell you, there was one time when I lived in our first apartment when we first got married. I'm not even sure if we had. I think we might have had one. Our oldest child was just a baby. We had a family member who had stayed with us for a while, one of my wife's siblings, who had stayed with us for a while and had a key to the house. We'd given him a key because his hours were a little different. But he was away, and then he was coming back, and he sort of came back. What his plan to come back was late, and so he didn't show up until late at night. Well, he still had the key, and we didn't know he was coming, and he pulled up to the house and got out and walked up to the front door and put the key in the front door. And I didn't hear anything until the key went in the front door, and then I distinctly could hear a key being fumbled around on the lock. And I was out of bed with a loaded pew-pew in firing position before he got the door open. And he opened that door a couple inches and was looking down the barrel and closed the door and started shouting, "No, it's me, it's me, it's me!" And it was, yeah. So yeah, we take it seriously here. Let's see, get a golden retriever. They'll distract intruders by demanding to be pet. I love golden retrievers. They're such nice dogs. So good with kids too. Nissa, I don't have one I'd recommend. I do like the ones that you sort of can build yourself, because a lot of the home monitoring systems out there, the commercial units that you have to have installed and everything, you end up overpaying for what you're getting, and you can get sort of the same coverage, the same security, and the same redundancy and everything else in a much cheaper unit, and you end up paying a lot for the ongoing bills for that one. Miss Jack Sam says they've got a mixed marriage, an Apple and Android. My partner's Apple and I'm Android. I'm not sure if it's marriage, but in the relationship, partner Android, your app. Partner's Apple, your Android. Best security, 110-pound German Shepherd that hates all humans and animals. No one even touches the gate. I know about it. Let's see. Keith B says, I wish we'd stop calling them phones. I rarely use it as a phone. So what would we call it? Question of the day. Well, what do you use it mostly for? Is it a portable TV? Is it a web browser? I think we should call it what. And I guess if you have an Apple phone, or I guess Android has this as well, you should be able to look at your your user report and see what you use the device for most, like what the battery life, how much of the battery life is used by different applications. Pocket computer, mobile internet, a YouTube unit, pocket pewter. I have a Siamese cat, useless as a guard cat, but very useful if you need cuddles. My cat is a guard cat as well. It guards the door from the outside and prevents you from opening it because it wants to be pet. Call it device. Bathroom YouTube device. How many people are not able to get their business done when they're doing their business without a device? It's crazy. My iPad is pretty much for knitting patterns. YouTube and games. My dog would help you out with all my belongings. And then jump in the truck and drive away with you. It's a magic box to Motor Troy. All right, let's keep an eye on Thurston here. Any minute now, we should be getting a feed. So as far as the plans for the day go, we're going to follow this court case in Thurston County. We may keep an eye on what's happening out of Judge Boyd's court. I realize that that she's got a trial coming up. Depends what it is, because I don't know a lot of details about that one. We're keeping an eye on Judge Boyd because she happens to be one of the possible judges that could be handling that that stepmom, dad, and son situation with the murder of the young couple in the car in San Antonio. That case, there's a potential it goes through her. If they're all together, I don't know, but. So we're keeping an eye on her situation and San Antonio in general, as far as that goes. And we're also looking at the Treehouse murder. I realize it started already. We're going to play catch up once we're done with this trial, because we've already started this trial. But we have trials coming up. All the DUIs, we need to call it thirsty Thurston County. It says no mandates. It was remarkable how many potential jurors, had DUI or reckless driving charges in their immediate circle of family and friends. And also how many also had police officers in that same immediate circle of family and friends. I'm not sure if they were the same person, but. Weather Watch, are we good for the podcast? Are you good for a podcast tonight? I'm not saying is it prepared. I can help with that, but as far as schedule. Kids are never happier when we get back from our summer retreat, dang near the Canadian woods, when there's no screens for 3 weeks. Ivan, that's a thing. If you're able to get kids away from the screens, it's good for their soul. Oh my goodness, just being out in nature is good. Going out on a walk, being out on the water, if you can, be out on the lake, fishing, enjoying the sunshine. There's going, what do they call it when you hunt for mushrooms? That's fun as well. Could you update us about your cat, please? Cat is doing well. The cat got fed rotisserie chicken this morning because my son found the new package of rotisserie chicken that we got from the store and thought the cat might like that. And then he reached in and grabbed some and then went out and fed the cat and pet the cat, came back and reached in and grabbed some more. And now the whole package is it's just cat hair and chicken, which means it all belongs to the cat. So the cat got some good stuff. It's just called mushroom hunting. No, there's a word for people that mushroom hunt, right? Thurston County's like a preacher's daughter. The naughtiest ones are in the family. Careful there, John. What are the fungus hunters? What are the people that look for mushrooms? Isn't there like the scientific term? It's foraging. That's when you eat them. But I swear there's a word for this. Hippies, shrooming. No, you're close. There's something else though. Mushroom hunting, mushrooming, mushroom picking. Mushroom foraging. Isn't there like a scientific word it's like a class of people that study mushrooms, or people who hate showers? Addicts? Yes, on the hippies, fun guys. I thought there was a word. I can't think of it right now. It'll come to me later if it is. The finder of human remains. Britta says, we sell a rotisserie chicken at my part-time job. A fellow employee asked me if they're any good because they have holes in them. Yeah, I wouldn't try it. Save it for the rest of us. You don't want to try those nasty rotisserie chickens that are, lemon, herb, spices, little salt and pepper on it. I know what you're talking about. There's definitely a word. Abby, mushroomologist, close. It's like this. This is probably the closest one, Jamie. Honestly, is this really a thing? A mycophilia? Mycophile? Rudy, you guys would not believe this, but I've trained our cat. The cat does not come in. The cat sits at the door. The door can be held wide open, and the cat will not come in. In Sweden, we say svamplakar. Swamp. Linda, I don't know what swamp. It looks like it has swamp in there. Mycophile. See, I've never heard this word before, Nikki, so I thought there was another one. Clearly, we don't have any of the people. By show of hands, how many of you have gone and foraged for mushrooms and found? I don't know. What's the one that has the little spongy top, the closed cell on the bottom? There's the morels. Have you found morels? Not the false morels, but a true morel. I've found a stash. I found a place that grows morel mushrooms, and apparently they're a thing because fresh morel mushrooms are worth something like $250 a pound. Okay, they're ridiculously expensive, and they also keep. They have like a 24-hour shelf life, so they go bad very quickly, and they're extremely expensive to find. A swamp liquor is what it is. But I found morel mushrooms, and I found a place that grows them, and yes, morels, for people who know, Susie, the morels are the good ones, right? I've lost my morals. Where the morels grow is once you know where they grow, you basically do everything. You spend the rest of your life trying to protect that property from anyone else finding out. That's how it works. Well, I did not know this, right? And so here I am. I'm growing up. I'm a young guy. I'm married, and there was some morning talk show, like a Saturday morning talk show, where they were talking about all these fun things you could do in the state that I was living in, and just like it sort of evolved into here's an insider's view. You know, here's stuff that no one would know about this area. You know, the hikes you can go on, the waterfalls that the secret waterfall that you have to hike to, and just all these cool things. And so I'm like, I've got something cool. I found a place that I just read about these mushrooms, and I found a place where these mushrooms grow. I call up and I get in on the show, and they take my call, and I'm on the air, and I'm telling them about all these mushrooms. And I say, hey, I found a place where these really cool mushrooms grow, and I'm thinking it's really neat. And they get all excited, right? And they're like, seriously, wow, and they weren't expecting me to go to the next step and tell them exactly where it was. But I did. And I went and like the next 10 minutes of calls were people that were mad at me for revealing the location that they knew about, where they go and pick these mushrooms, that they thought they were the only person that knows. And they're like, well, now you ruined it for everybody, because I outed this location. That's public. You need audio of that show. No, I think it was a greenhouse show, come to think of it. I think it was a greenhouse show, because there was an expert gardening person on there. But yeah, anyway, don't ever give away your spot. I know now, but I gave away apparently everyone else's spot, and I, to this day, have never eaten one of the mushrooms. I've found them, I've dug them up, I've given them to other people.
When are we going to break for lunch, Judge?
We're not going to break for lunch. We're actually going to break for court, which is about to begin. It's supposed to start in 15 seconds. So give us just a minute here. Hopefully everything works properly. It's like fishing or hunting. See, I handle this sort of thing the same way I do with YouTube. You guys know that I'm not protective of YouTube. I love this community. I love you guys. I love being able to spend time with you.
Somebody just sent me a video of roaches fighting. I don't know who won.
You have to watch the end of the video. But I'm all about sharing. I'm like, this is a great thing. I'd love to share it with other people. I'd love to share you guys with other channels, other channels that are awesome. I think that you would enjoy them and they would enjoy you. So I've been like this throughout my life and everything, whether it's hunting, fishing, or mushroom locations. I just think there's enough for everybody to go around. So, but apparently there aren't enough mushrooms. Mycology. What do they call it when a group of mushroom hunters get together and go out? Is that the term I'm looking for?
When are we going to break for lunch?
Keep the cheddar says, my mom taught me not to share. All right, come on, Judge. We are ready for you to go live.
You're talking about stuff
Thurston
that
County.
is not relevant.
I'm going to turn down Judge Manning just a little bit. She's a little noisy this morning. Where did you live in 86? How old was I in 86? Well, 87 I would have been 10. I lived in an unincorporated part of town on the Wasatch Front. I can tell you my bike story from that area if you want. I have 3 bike stories. One that I broke the neighbor's window, one that my bike got run over by my best friend's dad, and one that I rode my bike down the hill as fast as I could and crashed into a tree. I've got those 3 stories. Apparently, the only things that happened when I lived there was on a bike. I've shared some great fishing spots, and I realized that I've also lost great fishing spots because of that. But I don't own the fish. Everyone has a right to fish. Come on, Thurston. Yeah, let's hear it for 1977. That was a good year. Tomorrow Troy says court doesn't start until 9 a.m. Pacific. She said it would be 8:30. Or is that when they have to arrive? No, she said they were going to start at 8:30. I don't remember the Carter presidency. Obviously, it's Pickles, not politics here, so we're not going to go too into it. Mycophagists, mushroom pickers. What is a club? There's a word, you guys. There's a word out there. There's a word that describes the club members that go foraging together, and it's not forage. Words related to mushroom. Yeah. I think it's not mushroom hunting. Foraging. What are mushroom pickers called? I'm getting all the answers you guys gave me, but I thought there was another word. Synonyms for mushroom hunting. Mycological Society. Yeah. Guys, there should be a word. If there isn't one, there should be a word, because in my head it exists. I just don't know what it should be. Yoko Karama, we're going to go to the Treehouse murder. We're going to catch up here as soon as this trial that we're in the middle of is over. Tomorrow, Troy. You're wrong, Ari. I have been wrong before. So it might be another half hour. Half an hour to name mushroom hunters. Microphones, nope. The Hoosers, no, Julie. I was out, actually, I was filming a YouTube video for another channel, a metal detecting video. We had a big YouTuber fly in from drive in from out of state. And he came down, and we were doing this hunt on a property that we had this permission. It was an old gold mine property. And this guy shows up, and he's crazy. Okay, he's absolutely he will crawl down in a whole collapsing mine. I mean, there could be like dust billowing out from the cave collapsing. He's like, "Oh, let me see how open it is." He wiggled down into it. He would do that, and so we like lowered him into holes and everything. But while we're going around, and I'm filming as they're metal detecting and checking out different things and rescuing turtles out of big craters and things like that. While this is going on, I see a morel mushroom. I'm like, hey, check that out. It's a creative shot, and I'm like getting the shot of the other guy metal detecting with the mushroom in the foreground, so it just looks cool. And the big time YouTuber showed up. He's like, oh, that's a morel, and he's like digs it up. It's like mid shot. He's like scoops the whole thing up, puts it in a little baggie, takes it home. Troy saying that with a big smile, big smiling profile. Yes, Troy's probably right. The fact that it's Tumwater Troy. Tumwater Troy, aren't you in the area? Aren't you local to that area? I believe Tumwater is one of the villages or the towns up around there. Ivan, this is my whole life. I search for things that don't exist. Spelunking sounded like the right word to me when you first mentioned it, but that has to do with cave exploring. Wasn't too close. I've done some good spelunking. I've been in caves that now are closed, that now have bodies sealed in them. That's a little creepy. I've been through the same spot in a cave where there's now a dead body permanently entombed in the ground. Nutty Putty Cave, if you want to research that. A truffling society. Okay, I realize truffles and mushrooms, yeah, they go together, but there was a different word. It's just foraging. Geocache. I did geocaching. I've got one of the oldest geocaches in the state I lived in. It was placed in 2001. Let's see. Hunter-gatherers. Stop confessing, says Greeners. I'm pretty sure the statute of limitations has run out on most of these things. The cave. I was in that cave as a kid. I'd go in. Nutty Putty Cave was an amazing cave because it's in the middle of the desert. You go out on a little hill, go out on a hill, and then there's just a hole that drops down into the ground, and then you lay down flat and slide through just a narrow slit, and then it opens up. But the whole cave, there's just constant air blowing through, just constant, just blows through, and there's a little bit of humidity in it, so it's the clay, the sand gets really putty. You get really dirty in there. But the cave is amazing, and you don't get claustrophobic in most cases because that wind is blowing. It's like there's a wind blowing through the cave. You feel like you're outdoors, and it's fresh air. But we'd go there as scouts. We'd go there all the time. Our leaders would take us up. Leaders wouldn't come down. We'd go down and just have a blast in there, and then hour or two later we'd come out. There's a couple spots where you can get in a tight bind where there's a very narrow entrance and a tiny room at the other end, and a lot of people trying to come in, and you can't trying to get people to stop coming in because there's no room, and that's a tough one. But Buffer Court 4 is live. There we go. So we split the difference at 1:38. They went live. Let's pull this up. Let's see.
Thanks, folks. Please be seated.
Please be seated. We're going to bring the video up. Just one second.
Life is interesting. My husband tested positive for COVID, so I'm feeling fine. Fully vaxxed, boosted, everything I could get, but I'm masking and just heads up. And then, of course, only one arm. So
broken arm and
looks a little ridiculous up here.
COVID positive. But the judge is still here.
We've got all our jurors, right? Yeah. Great.
5 people in the background.
Yeah, they're here. State ready to go forward with your case, Ms. Mann? Ready to go forward with your case?
Say yes.
Okay, great.
The whispering has started. Her husband tested positive. She feels fine. She has a broken arm, a recently broken arm.
So, what did you say?
I'm going to show you a picture. Finish it around. Of ours. Yeah. So I don't care about the technology. I'm going to do video class. You can do video class. Yeah, okay.
Actually,
okay, you guys count the whispers. I'll try to get the whisper counter running. Okay.
And then we'll be able to talk about it. Thanks. That went really well. All right, so defense ready to go?
Yes, Your Honor.
Great. All right, so why don't we bring the jurors in? We'll start with the state's case.
Okay, I've got to go off camera to plug in the iPad so it'll charge so we can do the counter. Just one second.
Why don't we rise for the jury?
Oops, I sat down for the jury.
Alex stole it as well.
Then you can be seated as you come in. Thanks so much. Thanks, everyone can be seated. So life is interesting. My lovely husband tested positive for COVID this morning, so I'm masking. I feel great and fully vaxxed, boosted, everything they could give me. So I'm just keeping my distance, putting the mask on and hoping for the best. So we're ready. In a moment, we're just going to start the state's case in chief.
The judge is hiding behind my picture, so we're
Great,
going to
ready
move
to
on
go?
that.
Great. Suzanne?
Your Honor, state moves to call Officer Dustin Leishman.
Great. Becky, you want to come on up?
Okay, keep counting the whispers. I'm going to get, once we get updated, we'll
Raise
have.
your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Thanks. I'm just gonna have a seat. Go ahead.
Thank you for joining us today. Would you please state and spell your name for the record?
My name is Dustin Allen Leishman, D-U-S-T-I-N, Allen, A-L-L-E-N, Leishman, L-E-I-S-H-M-A-N.
Thank you. And what's your occupation?
I am a deputy with Thurston County Sheriff's Office.
And how long have you been a deputy?
I've been a deputy for just short of 4 years, so 3 years, 9 months.
And what kind of training did it take for you to become a deputy?
I went through the Criminal Justice Training Center for approximately 4 months to become a deputy. On top of that, I also conducted basic collision course as well as specific DUI training.
And was part of your training estimating car speeds?
Yes, ma'am. Well, let me please. Not estimation of car speeds directly. It was more to identify exceeding speeds. For example, if my vehicle is doing 40 miles an hour and I can see the vehicle in front of me breaking away or creating distance, I have an understanding that they are now going faster than what I was doing.
Thank you. And were you on duty as a police officer September 12th, 2023?
Yes, ma'am.
And what were the hours of your shift?
8 in the morning to 6:40 in the evening.
And what area of Thurston County were you patrolling that day?
I was patrolling the Edward District, which is the area from Nisqually Reservation, Yelm, Rainier, all the way to Tenino.
On that day, what type of vehicle were you driving?
I was driving a 2017 Ford F-150, fully marked sheriff's office vehicle with white doors, emergency lights, and sheriff's riding across the side.
A Ford
and
F-150?
Were you wearing any kind of uniform?
I was wearing the similar uniform that I'm currently wearing today.
And how did you come in contact with the defendant?
I was sitting at 210 Rochester Street West in a parking area. I was parallel to the road when I heard the acceleration of a vehicle. I heard gravel kicking up. I looked to my left to see a blue small Toyota Prius heading past me, going eastbound on Rochester Street West. I seen the passenger. I did not have clear view of the driver. However, the vehicle was breaking traction and swerving to the left and right. And at that point, I attempted to make a stop.
And what did you do when you say you attempted to make a stop?
I turned on my lights, which activated my in-vehicle camera. I proceeded onto the road. The vehicle was in front of me at that time, passing Center Street. It did not stop at Center Street as directed by the stop signs. Continued straight through Center Street. I continued forward towards Rochester Street East. I got to about a speed of 40 miles an hour. I could see that the Toyota was gaining distance upon me, so it was going faster than I was. The vehicle went off to the right into a gravel parking area, as well as it's a small parking area, and then it's also grass. And I proceeded through Center Street intersection. I had to wait momentarily for some vehicles. I believe a dump truck was also coming through. As I went through, I seen the dust coming up from the vehicle that was spinning circles, or common term is roadies, in the grass. The vehicle then proceeded back out to Rochester Street West, proceeded towards Valesky. Having knowledge of the area, I knew that Valesky was a loop, and the only way the vehicle could come out of that area would be to come down Olympia. I made a left on Idaho in an attempt that if the vehicle came down Olympia, I would be able to cut the vehicle off. So that's what I did, at which time I came to the intersection of Idaho and Olympia, and the vehicle was approaching from my right. It was the same vehicle. I could identify the passenger was the same passenger. That's when I identified Mr. Wakeman. I didn't have his identification yet, but I seen Mr. Wakeman in the driver's seat. I motioned to them to pull over. Mr. Wakeman complied, pulled to the right, pulled over, at which time I conducted a traffic stop while I had backup on its way.
We've got a Prius. I need to send backup. Send backup.
And do you recognize Mr. Wakeman in the courtroom today?
Yes, ma'am, I do.
Could you point him out for us?
Mr. Wakeman is the gentleman to the left of the oval seat.
Let the record reflect the officers identified the defendant. Can you describe the neighborhood where this happened?
It is a residential area. There is housing to the left where the vehicle was, where I was first tried to stop the vehicle. As the vehicle went through Center Street, there's more residential houses to the left. They're maybe 20 feet off the road houses. To the right side, there is a parking area followed by a children's playground. After that, there's a baseball field, and then there is a basketball court.
And were there any pedestrians around this area at that time?
There had been throughout the afternoon.
And are you familiar with this neighborhood?
I am.
How are you familiar with it?
I actually, throughout my time working in the field office bureau, have to go through that area and that neighborhood daily on my way to and from work.
So would you recognize a map of the neighborhood if I showed it to you?
Yes, ma'am.
Maybe you can put on the record what exhibit that is numbered.
This is Defense Exhibit 1, Your Honor.
All right.
Do you recognize this map?
Yes, I do, ma'am.
How do you recognize it?
I frequent this area. Center Street is a main thoroughfare. For anyone traveling down towards Rainier Road, it's faster than taking Minnesota.
And just for the jury's benefit, could you explain exactly what the map is?
The map is an area of the residential area on Binghamton in the middle of Rainier. It encompasses a housing area to the upper portion of Olympia Street, Rochester Street, as well as Thurston County, the trail that runs through, which is frequently walked by pedestrians.
Permission to publish Defense Exhibit 1 to the jury, Your Honor?
Certainly.
Now, could you explain where you first spotted the defendant's vehicle on this map?
So Mr. Stillwell and the defendant are unable to see that, and we need to have, I don't know how we're going to organize that. The jury seeing it and all the parties seeing it and the court seeing it.
I have a paper copy of the map. Perhaps Defense could look at that.
No, that's a lot. We'll see. Why don't you look at that and see if that's going to work for you, Mr. Stillwell? Okay. What? Turn that off.
Whose phone is that?
I think it would be helpful though.
It's the prosecutor's phone.
We're going to be referencing points on the poster. I think it would be difficult to track, even if we had printouts. I wonder if I got an idea. Yeah. You guys slide over here, and then.
Did we count that as a whisper? I've got an idea.
Now the judge can't see.
Unfortunately, I have to see it too. So.
Yeah.
I may suggest I can stand up, and if we place it here, I believe everyone can.
Might work. Make sure the jury can see it. We can get out of the way.
They never had an exhibit before in this court. It's a Google map.
And if I may, I think we can see it okay. If I may just request that if you could just orient as best you can, sort of where Rochester Street is and everything as you're examining the witness, that would be helpful. Thank you.
And if you wanted to get closer, that's fine. You probably don't want to get closer to me, but we can work it out.
Thank you. Thank you. I think we're okay.
All right. Well, if you're not, let me know. Remember, let me know what you need. All right. Go to it.
Would you mind pointing out where Rochester Street is on the map?
Yes, ma'am. There's two Rochester Streets, Rochester Street West and Rochester Street East. Rochester Street West actually begins over in this area. However, from here to here is Rochester Street West. Rochester Street East goes from center all the way up to Valesky Drive.
Okay, so it's going to be important for the record as well, Ms. Mann, and I don't expect you to understand this, Deputy, but the oral record, that when you say that off of the bottom right corner of that, you're saying Rochester West is?
Yes, the bottom left down here is Rochester West from Minnesota. And I believe it also continues southwest of Minnesota, but it's a dead end road.
So just to be clear for the record, because someone listening to the record will have no idea what's being said.
Thank
Like
you.
us.
And where were you when you first heard the defendant's car speeding?
I was parked. This here it demonstrates as a gravel area. It's since and during the time of the incident, it was a blacktop parking area here at 210 Rochester Street West. It's owned by the city of Rainier.
And where would you estimate the defendant's vehicle was?
When I first made a visual identification of the defendant's vehicle was approximately at most 30 feet from me here at Rochester Street West.
And can you point out where the defendant's vehicle ran the stop sign?
At Center Street, there's a stop sign here at the corner of Center Street and Rochester Street West. This is the Rainier City Hall parking area. There is a stop sign here before proceeding across Center Street to Rochester Street East.
And where did the defendant do the roadies that you described in your testimony?
So as the vehicle continued down Rochester Street East, you can see the basketball court right here, the children's park here. There's actually a baseball diamond right here. It just has not been marked in years. There's a fenced off area for the baseball diamond. The pull off here is this. There's a small parking area right here at the end of Rochester Street East before it turns onto Valesky Drive. And at this point, it was through this area right here.
And where did you end up pulling the defendant over?
I pulled the defendant over, was right off of Olympia Street East. I met the defendant at Idaho Avenue North and Olympia Street East, instructed him to pull over. He pulled over to the right side of the road, or rather the north side of Olympia Street East, and I pulled in behind his vehicle.
Thank you very much, officer. You may be seated.
Yes, ma'am.
You may be seated. Okay, so he's sitting back in the jury box. So we have the map. We understand where, well, we know that there was some distance between where he was, but the kid drove by the officer. The officer says he heard the vehicle accelerating, heard the sound of the tires, the gravel on the road, so windows must be down. I'm sure that question will be asked.
Permission to approach defense's table, Your Honor. Sure.
Permission to approach. There's another whisper.
Your Honor, permission to approach your podium.
Sure. Have these been marked?
These have been marked.
Okay, good. All right. So these are copies. You gave a copy to the defense, and this is a copy of what you intend to use.
Yes, sir.
All right.
That's what she should have verbalized.
Would you recognize a picture of the area?
Yes, ma'am.
Do you recognize this picture?
Which is what?
Yes, ma'am. That's a view of Rochester Street East, looking at it from the direction of, I would be standing at the southwestern area looking northeast on Rochester Street East.
And is this an accurate depiction of the area?
Yes, ma'am.
Permission to publish this picture to the jury, Your Honor?
Sure. Maybe I'll have Ms. Garza just give it to the jurors and they can pass it
Your Honor.
around. Oh, you've got it electronically. Great. Go to it.
I wish we could see this. This broadcast, this TV should be a feed on the Zoom. Should be one of the participants.
Can you identify the posted speed limit in this picture, officer?
Yes, ma'am. The posted speed limit in that photo in that area is 25 miles an hour.
And what's the structure in the right-hand side of the picture?
It's a children's playground.
And what speed would you say the defendant was traveling on this section of the road?
I could not give a specific number. I can say that I was doing approximately 40 when I approached Center Street, and the defendant's vehicle was pulling away from me, so he was doing in excess of 40 miles an hour.
Thank you, officer.
So that could be 41. So that's 15 miles over the speed.
You mentioned before that your camera activated on your car.
Yes, ma'am.
Was there a video taken of the incident?
Yes, ma'am, there was.
Would you recognize that video if I showed it today?
Yes, ma'am, I would.
Your Honor, permission to publish State's Exhibit 2 to the jury?
And that's already been admitted by agreement, certainly.
Yeah, so you could have been going 38 and he was going 39.
Your Honor, if we may, I think the only way to do this is if Mr. Wakeman and I maybe come around the side here.
Yeah, let's do that. However, we can work that out.
I'm really excited for the cross on this one. I think it's going to be great.
Sorry to kind of put you in the well there. Coming. Is the podium in the way?
No,
you're fine. Just good to go. All right.
We have a chair.
Good. All right. Go ahead.
Yeah, this would have been better to see in person. I think it's a little over, 2 minutes long? We need a little bit of narration here. We have a meetup instead of an actual meet. Would you agree? We just
Officer, is that an accurate representation of what happened that day?
Yes, ma'am.
And whose car was it that you pulled over at the very end of that video?
It was a vehicle occupied by Mr. Wakeman. I believe it was registered to his mom.
And can you reiterate where in the sequence of events the video starts?
The video starts when I activated my overhead lights.
Why does the video start when you activate your overhead lights?
The overhead light has a sensor that when I activate my emergency lights, it then triggers the video to activate on the vehicle.
Would you describe it as automatic?
It is an automatic feature. Yes.
And where on your vehicle is your camera situated?
My camera is situated to the upper right in the center of my windshield.
So almost directly straight?
Well, correction, it's about the center, and it's just off to the right, approximately 6 inches from center.
I see. And can that camera adjust its angles at all while you're driving?
No, ma'am. That camera is fixed to the front with a wide angle view.
Now, it's difficult to see the defendant's car in the beginning of this video. Could you explain why that is?
The camera itself is a wide angle camera. It picks up far to the right and far to the left. It's difficult to pick up on far distances with the camera itself.
Gotcha. But could you see to the left or to the right of the car during these times?
Yes, ma'am.
How would you describe your viewpoints of what's happening around you?
My viewpoints, I had clear view of my right, my left, at a minimum of 180 degrees. I did not have any obstructed view within my windshield outside of the right and left windshield beams.
Did you have a clear view of the defendant's driving?
Yes, ma'am, I did.
And just to clarify, did this happen in Thurston County, Washington?
It did, ma'am.
Thank you very much, officer.
Yes, ma'am.
Examination, are you gonna see the video there? I mean, feel free. Okay, either turn it off or.
Mr. Stillwell, you said you don't need it?
Correct. Yes, thank you.
Probably doesn't help his client at all. We also don't need your poster board.
We have all the exhibits that are marked somewhere or and admitted, the ones that were admitted, so we don't lose track of them. Okay.
This is a whisper counter. Sorry.
Mr. Stillwell, feel free to cross-examine.
Thank you, Your Honor. Good morning, Officer Leachman.
Morning, sir.
Was that another whisper?
So we just admitted and was published for the jury this map of Rochester Street thoroughfare. Actually, if I may ask you one additional question about this map.
Yes, sir.
Everyone's able to see it okay? All right.
You know, you could take that music stand, actually, if you wanted to get that closer to the jury, and feel free, both of you, to however it works. I mean, I don't need you to ask me permission, either of you, Ms. Van, Mr. Stillwell, to wander in the well and approach folks. It's done fine. But if there's some way you can work with it, get it closer to the jury to see, and, you know, the deputy needs to get up closer to the exhibit, feel free to figure that one out.
Thank you, Your Honor. So I'm going to grab the music stand. I think I've got an idea.
Kind of cumbersome, but feel free, both of you.
Perhaps we put it here.
Deputy needs to get up to deal with your questions. That's fine too.
All right. All right, and then this also is too as I ask my questions. So, officer, the intersection of Rochester Street and Center Street is this point on the map. Is that correct?
Yes, sir.
All right. And the gravel parking lot where you observed Mr. Waitman enter is this gravel parking lot here at the edge of Rochester Street?
Yes, sir.
Would you estimate the distance between these two is the intersection of Center Street and Rochester Street and the gravel parking lot at Rochester Street East is approximately 1,000 feet?
Approximately, yes.
Approximately 1,000 feet. Thank you. I'll have no more questions about the poster, but I'll perhaps leave it up and it's helpful for the jury.
He's getting math into a corner. Let's see the math.
Now, you've testified that you've been an officer for a couple of years now.
Yes, sir.
You guys think it was 4 years, just about?
Just shy of 4 years, sir.
And in those just shy of 4 years, I imagine you've written countless reports.
Yes, sir.
Right. So you know what you're doing when you're writing these reports.
Yes, sir.
Miss Mann discussed you had officer training. Is report writing part of that training?
Yes, sir.
Okay. And those reports are important to your work as an officer because you could be in court being asked questions by a lawyer about an incident that occurred a few months prior. Is that right?
Yes, sir.
Okay. And so because you rely on these reports, it's important that they're thorough.
Yes, sir.
And that they include all the important details.
Yes, sir.
And you wrote a report in this case.
Yes, sir.
And it included all the important details from this case.
I'd have to review that report again to identify that.
Okay. I believe we do have a copy of your report. We'd be happy to allow you to take a look at it.
Yes, sir.
The state had
It's
marked
over on the clerk's side.
Honor, I am approaching the witness with what has been marked as plaintiff exhibit number 3. Officer, if you wouldn't mind taking a look, see if that refreshes your recollection.
Let's see here, trying to get this looking just great. It's not too big, is it? We do have a jury trial here, L. Diamonds. We've got 6 jurors, 1 alternate listening to this the evidence. The defense attorney right now is sort of facing the jury. The podium, the lectern is turned towards him.
So, have you had a chance to review your report?
Yes, sir.
And so I'll repeat my question from before. Does your report include all the important details from this case?
Yes, sir.
Thank you. Your report does not include the speed with which Mr. Wakeman was driving that day.
Correct.
Okay. Now, you testified on direct that you were going 40 miles per hour.
I was, yes, sir.
That was not in your report. Is that correct?
Correct, sir.
Okay. And you testified that you came to the opinion that Mr. Wakeman was traveling at an excessive speed based on the fact that you were driving 40 miles per hour. Is that correct?
Yes, sir.
That analysis is not in your report. Is that correct?
Correct, sir.
Okay. Now, you also testified that you are able to base that opinion on Mr. Wakeman or any vehicle exceeding the speed that you're driving based on the fact that you are driving a certain speed and you observe a vehicle traveling further away than you. Is that correct?
I'm sorry, can you rephrase?
Sure. You testified sort of describing this procedure where you're driving at a certain mile per hour, and if you observe a car sort of pulling away from you, that's the basis of your conclusion that that car must be traveling faster than how fast you're traveling.
Yes, sir.
Okay. And sort of in order to make that determination, you need to be driving at that pace for a certain amount of time.
Well, at the time that I am viewing my speedometer, yes, sir.
Okay. So in order for this procedure to work, as far as you being able to estimate whether another vehicle is exceeding your speed, you need to be traveling at a certain speed at a relatively frequent and consistent rate.
Not necessarily. I could still be accelerating and look down. I can see 40 miles an hour at my current speed. I'm still accelerating. The vehicle's still increasing distance from me which would indicate that he is still going faster than the 40 mile an hour in which I viewed down and seen.
Sure. Okay. So what you're saying is you could accelerate, and if the other vehicle is still pulling away, you can determine that the car is going faster than you're going.
Yes, correct.
Okay. Thank you. Turning back to your report, sometimes police reports will include witness statements. Is that correct?
Yes, sir.
All right. And witness statements are important because they capture what someone observed soon after an incident.
Correct, sir.
And so witness statements allow you to preserve what others saw in addition to any observations you may have had at an incident.
Yes, sir.
Okay.
Objection, Your Honor. Can we have a sidebar?
Well, further questioning, our motions in meeting, I think, are clear. I don't see any basis for objection at this stage. Go
Overruled.
ahead. But continue, if you need to object at any point that you think I'm missing this. Ma'am. Go ahead, Mr. Stillwell.
Thank you, Your Honor. You testified that there were pedestrians around this area throughout the day.
Yes, sir.
Okay. Did you collect witness statements from anyone?
No, sir.
Police reports will also sometimes include photographs. Is that right?
Yes, sir.
And photographs are similarly important because they preserve images from a scene of a potential crime.
Yes, sir.
And photographs may be particularly important in a public place where a scene may be changed or impacted by members of the public who don't maybe know that that's where a potential crime had occurred.
Correct.
Okay. And you've testified that you observed Mr. Wakeman tearing up the grass in this field at the end of Rochester East.
Yes, sir.
Okay. And you did not include photos of the condition of the grass in your report, is that correct?
Correct, sir.
You testified that you observed the Prius that Mr. Wakeman was driving run the stop sign at the intersection of Center Street and Rochester Street. Is that correct?
Yes, sir.
And this occurred prior to your dash cam turning on?
No, sir.
Okay, so your dash cam picks up Mr. Wakeman running the stop sign?
No, sir. My dash cam is set at a 12 o'clock for my vehicle. Okay. I was pulling out of the parking lot, and as I stated before, I had 180 view from my seat. I could see the intersection, and I could see Mr. Wakefield go through that stop sign and that intersection without stopping. The dash cam only picks up the 12 o'clock view with a wide angle and was not able to pick up all the way the degrees to the right.
I see what you're saying. So your dash cam was on, however, it was just pointed at a different direction.
Yes, sir.
Okay. You did not issue Mr. Wakeman a traffic infraction for running the stop sign?
No, sir.
And you did not issue Mr. Wakeman a traffic infraction for speeding?
Correct.
Okay. Thank you, Your Honor. I have no further questions. Thank you, officer.
Serious?
Okay, any cross-examination?
Yes, Your Honor.
Okay.
Can you do this without any whispers? Or are you good? So the
Officer Leisman, do
camera
you
didn't
take
catch it.
witness statements or photographs in every case that you do?
No, ma'am.
Why is that?
Well, sometimes for example, photographs in this case, I did not have an opportunity to go over there, take prior photographs, nor would I have preempted the event happening to be able to determine that the tracks of tearing up the grass were present or not present prior to the vehicle going off the road, spinning in circles. Therefore, I could not determine whether or not it was only Mr. Wakeman's tracks or if it was other people's tracks prior to. Therefore, it would not have made a difference in my assessment and what I viewed.
And in your reports, do you document things like the color of the sky or what you're wearing?
No.
Why is that?
They were not significant to the event that took place.
And when was the last time you were actually in the area of this incident?
Yesterday, ma'am.
Why is that?
I was conducting evictions on the area of Rainier and Military Road. And from there, I traveled down through Rainier and to Yelm PD where I processed paperwork.
And do you remember what the fields looked like then when you were traveling through them?
Objection, relevance to the condition of the field
Seriously.
on the date of this incident.
Okay. Ms. Mann.
Your Honor, the defense was questioning what the fields looked like during the time of the incident, why there were no photographs. We're establishing what they regularly look like and what the areas regularly
After
like,
the fact,
which speaks to the recklessness of the defendant's driving.
This is alleged from September, and we're now in January. I find it not relevant. So move on with another question.
Do you always need a report to remember exactly what happened on the day of an incident?
No, ma'am.
Why is that?
Because I have my recollection of what I've seen, as well as, in this case, the dash cam footage of the vehicle.
Thank you, officer. So your report isn't a blow-by-blow verbatim of what happened on that day?
No, ma'am.
Is it more of a summary?
This is a summary narrative of a traffic citation identifying that there was reckless behavior, wanton disregard for the safety of the public and the operation of the motor vehicle.
Thank you very much, officer. That'll be all. Could we also clarify if all of the states and defense exhibits were admitted?
They were yesterday. We've got not the police reports.
Yes.
The ones that are admitted, and that was the dash cam, the map, and plaintiffs won the photograph of the road. So those are all admitted.
Thank you, Your Honor.
You're welcome.
And thank you, officer.
Any recross in those areas?
Yes.
No, Your Honor.
Okay. So, Ms. Mann, can this deputy be excused from his subpoena?
Yes, Your Honor.
Right. Any objection to that, Mr. Stillwell?
No, Your Honor.
All right. So, deputy, that means you can be on your way and back off to work or not work, whatever you're doing today. Thank you.
Nicole, you need to write a book. You need to write a book.
Any other evidence, witnesses, anything else to present in the state's case in chief? Ms. Mann, anything in the state's case in chief to present?
No, Your Honor, it's state rest.
Okay, so we're gonna take a quick break, and then we'll be back.
That's
So
good.
just a good, and even mid-morning, here we are. But we'll take 10, 15 minutes just to get refreshed, all right?
What?
And then we'll be back.
We barely sat down. Okay, there's more whispers. She didn't know how to rest. She didn't know how to rest. We have one witness. The cross was weak. Was weak. So I realized they got in important points, right? We got some important points. We've got the points that basically some of the allegations that the officer is that his child because he's 16 years old. This child is being charged with. Were not observed on the camera, and they also some allegations were not included in the report, but now he's testifying to it.
Just give you a few minutes, 10, 15 to talk to your client if you need it.
Yes, that would. Yes, thank you, Your Honor.
We'll be in recess then, and I'll see what I can do about turning off.
Are you going to turn off the feed? You're not going to turn off the feed, are you?
Thank you.
Jake, do you guys want to use our office?
That would be great. Yeah.
It's unlocked.
Jake, do you want to use our office? It's unlocked.
You're going to use this in your closing?
Yes. Yeah, I'll just be referring back to it.
So this assistant guy who's just supposed to be the handler
Yes, I think that makes the most sense.
very active in the courtroom.
making suggestions to the judge as far as layout, seating. Yeah, lots of things going on. So we'll see if they give us
Yeah. Thank you, Corey.
Jake, Corey.
I try to be done by lunch.
No, that's helpful. Thank you.
So they're going to go out and confer. Now, here the purpose of this conferring, and I love that we get the audio on because now we get full volume discussion happening right here. I know we're going to get it. This is going to be good.
No, you asked a perfectly legitimate question. And my response was not technically improper, in my opinion, but it was pretty close. What was it? Because you asked, was this a blow by blow that happened? They know it's a summary of. Or would it be fair for me to say that this is a summary? Yes, this is a summary of documenting what I interpreted as or what I was investigating as reckless behavior. Blah, 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 blah. So.
Wait, why would that be a mistrial?
Because he actually gets the elements.
Did he say? I completely went over me.
Wait.
I observed his want to disregard. Things like,
why would that be a mistrial?
Yeah.
Just saying, I told him not to do that.
Yeah. He was getting frustrated, but he didn't object at the time. And now that we've rested, and there, it might be a done deal. Okay.
Somebody call a lawyer.
It's a legitimate trial strategy for the defense.
To leave it.
Typically, unless they object, unless the offense is so flagrant, it's so basically done and I think in the context of the question, it's actually a privileged answer. It's like, I was conducting an investigation related to reckless driving. Yeah. This documents what I view as relevant to that reckless driving at the time. So that's the other thing is when they ask this in every case, and you got to be very fluid in how you phrase it. Yeah. And the generalized responses or generalized questions we have to ask is like, okay, so let's say, was the defendant's length of hair important that day? No. Yeah. Because I identified it by other means. Yeah. So there's just find something that's kind of innocuous, but at the same time has no reason to document it. She took a break. She did, I think, take us off the electronic record, but I think we're still on Zoom.
Oh, okay.
He knows we're on Zoom. He knows we're live.
You really like this tie.
Famous last words. Okay, so now they killed the feed. The feed is down now. Whoa. He knew. He knew the whole time. He said, yeah, this could have caused a mistrial, but they didn't object, so just be quiet. Just be quiet. Oh, man. We need a quick little, just quick call to an attorney would, might fix this whole thing. We might never have to go to a jury. Oh, my goodness. Oh, this is crazy. You guys, only in Thurston County. I don't know what to say. Only in Thurston County. We're going to go back and listen just because we get the prosecutor, the handler knew that we were on the electronic Zoom, knew the Zoom was going out on YouTube. He knew it was live, and he's sitting there talking. Okay, so this is not an expectation of privacy. Oh, he's sitting in the courtroom where anyone could hear, anyone can watch, and he's on Zoom, huddled around the microphone. I love this tie. I hope you like it. That might be the last one you wear in court. This could be Nicole. Do you have a minute to call? Oh, this is. Oh my goodness. Okay, we're gonna back up just a little bit. Give me just a second. We're gonna go back and watch just that last little bit. Just the hot mic portion. So give me just a second to. Okay. Back up.
Okay, so here we're going right
So
here.
just
Ready?
give you a few minutes, 10, 15 to talk to your client if you need it.
Yes, that would, yes, thank you, Your Honor.
We'll be in recess then, and I'll see what I can do about turning off.
Thank you.
Do you guys want to use our office? That would be great. Yeah. It's unlocked. Thank you.
Okay, so
Are you going to use this in your closing?
Yes.
the whispers
referring back to
are
it.
Just want to use.
so they're gonna leave. He's gonna walk around. He's sort of like straightening
Yes,
up the
I think that
courtroom.
makes
I don't know
more
why
sense.
he's doing this. Nothing he's doing right now is crucial. Right? He's just like, I'm gonna put this over here, or you want this? What do you want? And it's not even his trial, right? He's not the prosecutor. He's just the assistance for the
I
prosecutor.
just want to be done by lunch.
No, that's helpful. Thank you.
I just want to be done by lunch. His priority is just out there. Okay, so as everybody leaves, listen carefully. We'll turn the volume up.
No, you asked a perfectly legitimate question. And my response was not technically improper, in my opinion, but it was pretty close. What was it? Because you asked, was this a blow by blow that happened? They know it's a summary of, or would it be fair to say this is a summary? Yes, this is a summary of documenting what I interpreted as, or what I was investigating as reckless behavior. Blah, 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 blah. So.
Wait, why would that be in this trial?
Because he actually gets to keep the elements.
Did he say? I completely went over it.
I observed as want to disregard. It's like,
Just saying, I told him not to do that.
Yeah, he was getting frustrated, but he didn't object at the time. And now that we've rested, and there, it might be a done deal. Okay. Now it's a legitimate trial strategy for the defense
To leave it.
typically, unless they object, unless the offense is so flagrant, it's so basically done and I think in the context of the question, it's actually a privileged answer. It's like, I was conducting an investigation related to reckless driving.
Yeah.
This documents what I viewed as relevant to that reckless driving at the time. So that's the other thing. Is when they ask this in every case, and you got to be very fluid in how you phrase it.
Yeah.
And the generalized responses or generalized questions we have to ask is like, okay, so let's say, was the defendant's length of hair important that day? No.
Yeah.
Because I identified it by other means.
Yeah.
So there's just find something that's kind of innocuous, but at the same time has no reason to document it. She took a break. She did, I think, take us off the electronic record, but I think we're still on Zoom.
Oh, okay.
Okay, so just like that. Whoa.
I really like this tie.
I really like this tie. That's how he leaves it. That's how the feed cuts. I don't know the legal, the argument he's making or the thing that he says was an issue, but whatever it was, he thinks it was enough that it could have been a mistrial had the defense made a motion right then. And he's true. Something has to be, objections have to be timely. But it's possible that they could come back right now and say, we'd like to object. Okay, I don't think the timeliness factor is expired because they've taken a brief recess. We have not progressed on in court. Like the next guy hasn't gone yet, right? Monopoly, if you roll and you land on your friend's hotel and he doesn't ask you to pay rent and your turn finishes, the next guy goes. Then once the next guy starts, he can't charge you rent. He's like, hey, wait, you were supposed to pay me the last turn. This is a standing rule. All of you guys know this rule in Monopoly. It's like, it's too late. You had your chance. You didn't charge me. I'm free. I got a free stay. That's basically what he's saying happened in the court here. The Goodman Law Firm, Nicole says, the officer said the defendant committed the offense with wanton disregard and without any defense objection or request for a mistrial. That statement stays with the jury. Wanton disregard. Okay, so that could have been the mistrial.
Oh my goodness. It was the statement that came from the witness that was the problem. Nothing that the attorney said directly. The person assisting the attorney supervising the newbie doing the trial, he's not an assistant, he's training her. And he says now it becomes legitimate trial strategy to just let this lie. Don't mention it. Okay, everyone quiet. Just pretend nothing happened. As long as they don't object, it gets to stand. Oh, man. Reckless driving is a gross misdemeanor. It's not a felony. You're right. It's a gross misdemeanor in Washington. Up to a year. What is it? Up to a year in prison and $5,000 fine, I think. Think about an officer, witness testifying that the defendant is in a murder case, intentionally and deliberately committed homicide. It's the same thing. So he's speaking about intent, which he can't do. He can't make that observation saying he was. Yeah, it's not an observable fact, right? So he can't testify to that. Wonder if it's too late to ask for a mistrial. I can tell you what this attorney is not doing. This attorney is not watching this feed. And this attorney is not going back and watching what happened, and he missed it. He missed it. So unless somebody from his office is watching this feed or is watching the court feed, I mean, he could watch any feed and see that. It's a legal conclusion. I believe there is a prior, but it's not the same prior. It's not like previous reckless. I think he was driving without a license. Something like that. PNW. What did you miss? You missed at the end of the live stream. With the feed still on and the prosecution team knowing that the live stream is still running. They were talking with each other about a possible mistrial level mistake where they elicited testimony from the officer who made a legal conclusion as to what the defendant was doing. And they said, hey, they didn't object at the time. It could have been a mistrial. They didn't object it at the time. So we're just going to let it lie. You know, our strategy is just to let it lie. But so now that attorney doesn't know that if he had objected right now, that this case in very likelihood would have been a mistrial or struck some of the testimony at the least. But a hot mic at the prosecution table right at the break, right at the end, if you go back and see that. It's bizarre, but his defense attorney has no clue that this is going on. He just missed it. And so right now the defense attorney is sitting with the defendant, and the thing that's on their mind is they're going over the evidence that was presented in court. So this might come up. They might look at this and say, oh, yeah, that's a legal conclusion. He might come to that conclusion on his own, but the big thing is he's deciding if the defendant is going to testify in his own self-defense. And if he takes the stand, one thing we know from the motions in limine is that the defendant's statements at the time of the traffic stop have been excluded from court unless they're introduced as rebuttal to a previous conflicting statement that he made. So that's going to be interesting. So if he takes the stand, I think it hurts him. But let's see. Let's see when they come back. This is going to be interesting. They've just got a couple more minutes and they'll be back. Let's hush hush a kid's permanent record. Well, it is the defense attorney's job to object there. And I'll tell you, the prosecutor, she had no clue. She didn't even know how to rest her case. Okay, I mean, she is so new at what she's doing. She didn't know. This is, I believe, her first trial. There's no way she knows what's going on. So she would not have caught something as subtle as that legal conclusion mixed in with the testimony in response to her question of the witness. That would I wouldn't expect her to catch that. But her handler, her trainer, with years of experience, definitely did catch it. Given law firm, is testimony that enters the testimony that the elements of a crime occurred a legal conclusion or a finding of fact, i.e. the jury's purview? Mary, I'm excited for the Treehouse case. We're probably going to take that one tomorrow, maybe this afternoon if we get through this one quickly. What's this case about? This is a reckless driving case. 16-year-old kid driving his mom's 2008 Prius apparently sped past a cop. swerving back and forth, breaking traction, throwing gravel. The cop was in his fully decked out and marked Ford F-150, gave chase, turned on his lights, gave chase. Due to maneuvering the vehicle, the camera, the wide-angle lens, did not capture much of the offenses that the officer testified to, even though it's happened sort of in front of him. So like the running the stoplight was not observed. The swerving back and forth was not observed. There was no speed. There was no radar used to determine speed. The officer just and the defense gave him a pass on this. The officer testified that he was going about 40 miles an hour, and could tell that the other vehicle was still going faster than him. So that could have been 41. Well, 38 is also about 40 miles an hour, and that would have mean the other guy was going 39 at a minimum, you'd say. 39 in a 25 is different because a lot of thresholds for laws are 15 miles an hour over to get reckless. So you've got the defense missed the opportunity to capitalize on that, and instead they redirect, ask the officer, you testified you were driving at 40 miles an hour. No, he did not. He said he was going about 40 miles an hour. That's up or down, and it could have been down, and you have to give them the benefit that it could have been down. All right. Great case here. Great case. Okay. Oops. Let's go back here. Wrong button. Thurston County. Are we coming back yet? Not yet.
Somebody just sent me a video of roaches fighting. I don't know who won.
I've got to make that longer. I cut the one off. I'll fix that. Did the kid mouth off to the cop or something? There's got to be something. There's got to be some element of revenge in here. The officer just seems like they're trying to throw the book at the kid. I didn't take pictures of where he did donuts, allegedly. It also didn't occur on camera, I think, but there might have been some dust. About 40 mile an hour does not count. We're trying to see if the defendant is going to testify in his defense. If he takes the stand, it's going to be bad for him, I admit, but the defense had so much they could have done and didn't do in the cross-examination. I'm floored. I should have done better. The title of today's video shouldn't be Reckless Prius. It should be How Not to Be a Defense Lawyer. The poor girl, it's her first trial, okay? And if she loses this, what a crushing blow. First of all, you've got an officer who barely caught a Prius, and then the defense attorney can't get the charge to stick on the Prius driver. It's like insult to injury. Would argue the donuts happen on private land and can't count to reckless driving, says Richard Chambers.
Taking it easy.
Unless it was like city-owned land, obviously. But the testimony, there's so many things that it missed. The testimony of when the question was asked of the attorney. Yes, I'm seeing this, PNW. When the question was asked of the police officer, were there people around? And he's like, this is an area where people go, and they've been there before. I'm like, that was not the question. Why didn't defense jump all over that and say, were there people there? Does your camera observe anyone in the area? No. It would suck. First of all, I'm not a fan of reckless driving. Okay, it is no joke to get behind the wheel of a 2,000-pound vehicle and operate in a manner where you could lose control or you are not in control. Not a fan of that. Okay, this kid, if this is what he did, this is a problem. Okay, it needs to be addressed. It can't just go on like this. But I'm also not a fan of just pinning this guy with a charge where I'm not convinced as a member of the jury that everything happened exactly like I have issues when you've got a police officer who writes a report and doesn't include any of the details that he's testifying to, or any of the substantial details, including the fact that he was speeding, ran a red light, some of the things that you need to prove to add up to that reckless driving charge. That's a problem for me. Whoa, it's like in the moment it didn't come back to you, but here you are months down the road, and you're like, oh yeah, I remember I was going 40. Didn't say that in my report, but I was going 40, and he was pulling away from me. I also didn't say that in the report, but I remember now, clear as a bell. Clear as a bell.
Court is back. Here we
Be
go.
worth including. Is there motion and limit?
Oh, we're going to back up just a little bit.
Received from defense, the way the state put them together, and if you can, since we've got some time right now, I wanted to look at those. They seem in a sensible order. Is there anything else that either Ms. Mann that you would be asking to include here or to take out?
No, Your Honor. The state accepts the jury instructions.
Mr. Stillwell,
they started
anything
late.
you think
We
you
missed
should
it.
include or take out?
Your Honor, one that comes to mind that I wonder if it'd be worth including is there motion in limine number 15, which was unopposed, prohibit any argument by the state that reckless driving may be inferred from excessive speed, given the withdrawn WIPIC on that subject, and not arguing that that was the case, but given the reliance on speed and the importance of speed in the case in chief, I propose an additional instruction that simply that excessive speed alone cannot be used to infer reckless driving. I think there's a WIPIC for that.
So look at that.
And that WIPIC is 95.03.
It sounds like they're not going to put on a defense. They're going straight to jury instructions.
I do have, I printed out one copy of it.
Oh, great. We can share it there.
Sure.
Yeah, Andrea, I remember there was one. I don't remember what the verbiage is. You share that with Ms. Mann. Ms. Mann, do you have a ability to look at that with me?
I got it here. You can give that to him.
Okay.
Long hand of justice reaches out towards the camera,
So, all right.
grasping the evidence with seasoned fingers.
So this is, all right, there isn't a WIPIC.
It's the notation that WIPIC had been withdrawn, as the law is now that excessive speed may not be used to infer reckless driving, and I think a limited instruction just clarifying that, while that may be used as part of the case, speeding alone is not enough for reckless driving. I think that would be important given that WIPIC was withdrawn expressly.
How would you fashion the instruction? What would it say?
I think similar to that, it would be that the defendant's speed may be used as evidence of reckless driving, but reckless driving may not be inferred solely from excessive speeding.
It would be creating an instruction along those lines.
Yes, Your Honor, just to make it clear that it can be used as evidence, but it cannot on its own be used as the basis for finding reckless driving.
He needed to object in the moment.
That's generally what it would say. Defendant speed may be used as evidence of reckless driving, but reckless driving alone is not. Reckless driving does not be used to infer.
Excessive speed alone may not be used to infer reckless driving, would be my suggestion.
The whispers just keep happening.
Well, Ms. Mann.
Your Honor, the state would object to that. It's overly confusing to the jury. If the court felt that was necessary, they could have created it before. I think it's overkill.
And Your Honor, I that's why I did mention that this was included as at least a motion in limine. This wasn't included as an instruction, as the state hadn't put on its case in chief yet. But I feel, given that it was included as a motion in limine, at least the subject matter was, and that this withdrawn WIPIC is published for a specific reason, and given now that the state has rested and there's been a lot of testimony about excessive speed. Again, not arguing that it can't be used as evidence, but I think it's important just to clarify that speed alone cannot be used to infer reckless driving.
Some states, 15 over is reckless. Sounds like in Washington that's not the case from what he's arguing here.
So an instruction that might say speeding alone may not be used to infer reckless driving.
That language would be fine by the defense, Your Honor. And I think that's simple and clear.
So, Ms. Mann?
Like I said, Your Honor, the state would object to that. Nearly every reckless driving case involves some element of speeding. The fact that there isn't a preordained wicket describing this speaks to the fact that it's inappropriate and misleading to the jury.
Wait on this one.
Crowding the judge with her wearing the mask and all. I don't want to make her uncomfortable. We have no allegations of gore area crossage.
To counsel's comments, again, I'm not disputing that speeding is used in reckless driving prosecutions. I'm saying that it alone cannot be used as the basis for a finding of guilt of reckless driving.
I'm hesitant to add something that the Washington pattern jury instructions do not have, and so I'm not going to add an instruction along those lines that I would create. It's an interesting thought, though, but I don't think Rosenkamp, that's how I say it, Rosenkamp, I read earlier yesterday or the day before, would have me doing this. I think it would be invited error. So I certainly think that can be argument in your closings, and because the tenor is what you have to be proved is the willful and disregard for the safety of persons or property. So I won't add that instruction. And then anything else in this packet?
No, Your Honor.
Okay, so what I'll do is have you get those together, the insights for everyone. We'll do it in this order. Remember to take the form out so that we have a different verdict. And then we'll get the jury back in here, we'll do closings. I'll instruct them because we'll have those packets. Don't want to have to take another break before we bring them in. I'd like to kind of smoothly do that and then take a break into deliberation. So
in the interest of moving smoothly once the jury returns, I do have a PowerPoint to present in my closing.
Okay.
And I haven't yet done a PowerPoint in this courtroom. I've got it on a USB here ready to go. Is it that laptop up there that I would be using?
Yes. I am not helpful there.
It would be on this. It's only connected this one right here.
Okay. All right. Use that. Okay.
Well, why don't we just take a break, give Teresa a chance to get all of those juror packets together. You can
breaks all over the place.
Making sure you're smooth with the PowerPoint. So we'll just come back over here ready to go with all those. We won't hand them out yet. Okay. Back in about 10 with ready to bring them in for closing and then that off. And then we'll go into I'll go into instructions, then we'll do closings.
Okay. So this is where we're at. She's done. She dropped the feed. It appears they did not object. We have another break go figure. We're going to go back and watch for the next update. We have a 10-minute. Hey, Siri, set a timer for 10 minutes.
10 minutes starting now.
Between my timer and all the other timers that you have that just got set, I think we're going to know exactly when the when the court's back. But now we have another break. So he brought a USB. He's got a presentation. He's missed a couple opportunities as the seasoned defense attorney that he is. He's also very young and missed some opportunities, possibly looking too far ahead instead of being present in the moment in the testimony. There's a couple chances that he really could have capitalized on that could be substantial. And maybe the jury caught it. I mean, honestly, maybe the jury caught the testimony from the officer saying that I was driving about 40. And I wasn't going a set speed, and like sort of paced him, and could tell that way off in the distance across through the intersection past the dump truck, he was actually getting smaller, faster. I couldn't tell, but maybe they've got all these pieces together, and this is a open and shut. I do not have a corn dog emoji. I don't have any corn dogs either, but actually we might have 2 in the freezer. State Fair corn dogs. She breaks more than she courts. Let's see. PNW, what were you saying there? Let's see. The fact that the cop wrote it as reckless without impeachable evidence. Something more here. Long hair. Yeah. Did he not like what he looked like? Or is it just insult to injury that he sped by the police vehicle? Was that the original offense? This case hinges on the PowerPoint presentation of the defense, a real nail biter. It does. He's got to put all these pieces together, and I realize he did a good job excluding some evidence, namely the comments made by his client at the time of the stop. That was really good, but he also, he missed some opportunities, some big opportunities.
Mr.
Ivan, how are you doing, my friend?
I'm fired up for this kid. Like, I'm ready to start a fan club, because let me tell you something. Every single accusation or criminal charge they have accused this kid of, they somehow either didn't include in a report or isn't visible by Dashcam. All the things that this rookie DA or assistant DA told us we would see, we didn't see any of those. Okay? In fact, we exactly saw the opposite. We saw none of those. So, I don't care about like it's bad enough they're hushing. Like, imagine hushing, knowing you just committed a mistrial accusation. Imagine hushing that for a kid, a child, to be on his permanent record, just so you can score your first win, just so you can check a box. Like, how gross is that? That's what our system is. That's what we're spending money on. That's what we're allowing to go to court, admitting to quieting trial errors for the prosecution of a kid, his first charge. Are you kidding me? Like, I'm ready to throw my phone through a couch and submit it to the Murdoch trial. Like,
well, then you have to get an iPhone. Yeah, this is a little bit. It seems sketchy. Now, just know, these things probably happen more often than we'd think, but usually we don't get to hear about it. This court, we have heard everything. We saw jury selection. We heard the jury questionnaires through voir dire. We heard the deliberation about excusing jurors. We've heard, that sidebar that occurred. We've heard everything.
We've heard a lot. Except, what we haven't heard? Any actual evidence of a single crime being committed, except what people say, or except opening statements, or all the things they promised to show us just happening to not show up on the angle of my dash cam. Yeah, well, the angle of your statement is suspect, sir. You were outran by a moped, and you don't even have the proof to show it.
Oh, man. Yeah, the camera did not capture the vehicle fishtailing down the road. It apparently, the defense tells us, we didn't get to see, but the defense tells us that it shows the vehicle driving straight.
They make it sound like this guy ran onto a golf course and started ripping up greens and spitting gravel, with a
and who hasn't done that? I mean, honestly. Yeah, no, just kidding.
Yeah, and even if that was the case, like, forever, he needs to be punished forever, but they don't even have proof of a single word of it. It's just, like, if this isn't direct verdict material, then what is? Like,
well, that is an opportunity. That's an opportunity. If the defense they have to make the motion, right? They have to make the motion for a directed verdict, and I have not heard that happen yet. But this would be the time, and it just didn't occur. I don't know why. I don't know why you wouldn't make that motion. Absolutely nothing bad can happen from making a directed verdict motion at this point in the trial.
It happens in every case, even when they're dead to rights.
Yeah, even if all the evidence is there, the only thing that can happen is things are going to proceed as we thought, unless the judge is like, well, You're right. Good day. Dismiss with prejudice. Have kid get back to school.
Especially since this judge told him to go in the back room and make some sideways Dutch uncle handshake deal.
Yeah, she's already they told them amicable to the idea of like, hey, let's do something other than nail this kid with a reckless driving charge that will stick with him for the rest of his life.
Hey, Fulton County, like, you want to talk about Wisconsin, Washington State, you just threw yourself right up into the top 5, okay? You're right there with us in Florida and Idaho and all the rest of them, okay? Like, it's gotten that bad after Farrak and this mess. Like, oh my goodness.
P&W is going to be in court in probably the same courtroom. One of the other, I don't know if it's this one or another one, here in the next little while. He's got a case coming up.
16 years old. Does he really deserve a criminal charge the rest of his life for something they have absolutely no documentation or evidence of anything you're actually accusing? I mean,
it's the officer's observation, and the jurors were asked specifically about this during voir dire, where they said, "Hey, when an officer testifies, are you going to just assume that that carries more weight?" Now, the flip side of that is they didn't offer anything to the contrary.
They don't have to.
Ivan, I think we've got a lawyer or a lawyer adjacent call coming in. Can I take this one?
Okay.
I'll let you go. Love you, man. Thanks.
Bye. Yeah, bye.
Call from
Johnny Strabler.
Johnny, my friend, how are you doing?
I'm doing good. Let me get out of the other room because you're on TV.
I'm on TV. Woohoo! Hi, Mom.
Well,
hi, Mom. Okay, just kidding.
Nicole dared me to say I was Mr. Goodman Law.
I thought you were going to announce yourself like that. What are you thinking about this? Are you siding with the prosecution on this one?
Well, yes, and I worked a traffic car for several years. Mm-hmm. The training that goes into it is specialized. There's different levels of it. There's basic traffic, there's intermediate traffic, and advanced traffic. Advanced traffic would be something like 18-wheelers and interstate transport stuff. The other thing is if you're using radar, you're trained in that. If you're using visual speed estimates, that's also a training that comes at the same time you take radar. All this stuff is certified, goes through the state, and then is filed with the court by the department. So the judge would have that up there, and it could be requested or looked at.
And we heard that testimony from the officer that he has training specifically in determining, making judgment calls on speed, determining if
right. But what I'm saying is he's testifying to it. I'm seeing some of the comments people are making. Oh, we're just going with the honesty of the officer. Not this way. You have certifications that the court can actually say, "I've got him right here. If you want to, if you want to see him," or the prosecution or the defense. Some of these people are acting like this one gentleman because of his age. Age shouldn't be a factor. We do know when we were younger, we all were speeding and doing different crazy things like that. You got to be careful, and most of us are very lucky, but sometimes someone can get hurt. Let's just do what they call vicarious liability. Let's say the officer pulled this gentleman over and based on his age, gave him a break, that it wasn't so egregious that he had to write him a citation. The guy goes down the street and gets in an accident or hits a car, and he's injured, anything like that. The officer himself, plus the department, would be liable if it was shown that that cop had let him go right after, another type of stunt. And this was a misdemeanor. We're not talking a felony.
Right.
It's not going to ruin the rest of his life. It's a misdemeanor. Yeah.
It's got up to a year in the lockup and $5,000 fine. It's a maximum if he gets the maximum, which he probably won't get.
I agree with you 100%. He would have to have so many priors for the same exact thing to get maxed out like that.
Yeah. So, Johnny, let me ask you this: was it a problem in your mind when the officer was cross-examined and we found out? Oh, that's my timer. Sorry, hang on one second. I have a duck.
Sure.
A duck telling us that the court should start soon. Was it a problem that the officer did not put in his report any of these facts, the speed that he estimated him going at, things like that, and now months later is now testifying to it? Shouldn't those be in the report?
They should. 100% should be in the report. Now, there's a couple of reasons why it might not be. One is maybe he's not as good a report writer as others. I actually taught a class in report writing. It should have been in there. And under each section that he violated, say a red light, the code section for that. So you'd have all these different code sections. You don't have to charge him with all of them, but they should be in the body of the report. He ran a red light, 24-250 of the California Vehicle Code, and on and on and on. Now, some officers will write notes on the back of the citation. If the judge didn't flip that ticket over, or the prosecutor or defense didn't, they might not have seen his notes. They may very well be on the back of the notes and not in the report.
Okay.
That's not a good idea to do.
Right, but it could.
But I have seen it. I have seen it done. Yes, absolutely. I've seen that done many a time, and it still went in. I personally think that you should have everything in the report. It's better to write too much than to not write enough.
Yeah. What do you think? What do you think about the officer?
When you do write a report. Oh, go ahead.
Sorry, let me. We've just got seconds left. What do you think about the officer testifying, making a legal conclusion, and that standing? Do you think that's sort of a cheap shot?
Well, let me just say that it just started a fight with me and Nicole.
and now we have divorce.
Here's my point.
No, just kidding.
No. Here's how she and I talked it out, because she comes from the attorney point of view, and I just like to argue with her anyways. In the report, he is to come to those conclusions, and he's to go to the four corners of that law and cover every section this person violated and make a conclusion that it was reckless driving. When he's testifying, he shouldn't testify to his report. He has to testify to everything, but he shouldn't make a conclusion. That should have been objected to by the defense. You can't say the cop was wrong to make the conclusion. Yeah. The person that was wrong was the person who didn't object to it.
Right. That's right.
I don't know if he's the most experienced. He's not super experienced on the stand, maybe testifying. Did he get away with it? Yeah, it was a little bit surprising. But those are conclusions that should be in a report. The jury doesn't get the report, just the attorneys and the judge. Yeah. And he better have all his conclusions in there, because you got to remember, you got to write it all. You have to sum it up. It has to be approved by your sergeant, the detective sergeant, and then the court.
I know it's not evidence, but this case might really come down to who does the better closing. So we have a PowerPoint from the defense. They've done a good job keeping some evidence out. We've got a PowerPoint where they're going to go over, his take on things and try to, he wants to say, just the fact that he observable speeding, that's not enough to say reckless driving. He might bring in the private property. I mean, can you add up what happens on private property and say, now this was committed reckless driving? You can't reckless drive on private property, right? Unless
you can under certain circumstances. If there was damage done on private property, that would add to the conclusion. What you're doing is you're building a case with blocks. Yeah. You're starting with speed, what you're observing with the speeds. Different violations. That's why you should have written down stoplight here, this and that. Every block you put up there builds it stronger and stronger toward a case of actual reckless driving versus just one block of speeding. If you went onto private property, let's say you took out a power pole, hit a car, left, even if you let skid marks all over the place, like doing donuts or something like that or whatever, that's some damage you can see, and that would add up to it. There aren't many vehicle codes that you can put on private property, like being in a handicap zone or in a red zone. Those are enforceable for law enforcement officers. Yeah. Other than that, they can't really do much. But if he speeds through a parking lot and almost hits somebody and it's observed by the officer, that is definitely another building block onto the reckless driving. You got to put everything in there.
Interesting. We're going to see how the jury.
I would have tried to grab any camera stuff No, I didn't hear everything, but if you did go to private property, I, as an officer, would definitely want to see if I could get footage from buildings to add to my evidence.
Well, he didn't take any pictures. He didn't take pictures of where he said that he heard the Prius accelerating. That's where my ears perked up a little bit because
you heard an electric car accelerate.
Yeah,
that's a little unusual.
And then he's like, "Well, we heard it brake traction and gravel flying." I'm like, "Okay, I can hear that. I'm with you now." But the fishtailing back and forth. He had his dash cam turned on as soon as he was like pulls past him, and the camera starts rolling, but it doesn't observe any of the things that he's testifying to. It doesn't observe the running the red light. There's no measurement. There's no radar measurement taken. It's just he's going about 40 miles an hour, and he thinks his judgment was the car was going faster than him. It seems weak with what he does have, especially you add that to the fact that the report was probably I would say poorly written. If what he testified to is what happened, the report could have been written a lot better. And
did the officer testify as Wadire to how long he'd been an officer?
I believe it was on there. He's had some experience and years of experience. I don't remember. He's probably a younger officer, but there was a jump truck.
Well, I can tell you right
them
now,
in the car
he
as
was
well.
yeah. He was definitely not one of my trainees.
No, you would have drilled that into him. Johnny, thank you very much.
He'd have been up there.
I appreciate your take.
Sir, you have a great weekend.
You too.
By the way, did you get the photo I sent you?
Probably yes, but I have the memory of a goldfish, so unless it's in front of me, it's hard for me to recall.
I'm going to send it back to you.
Okay.
If you hear screaming, it's because Nikki found out I sent it to you, but it's a good one.
Oh, so you said I have permission to use it on the live stream? Is that what you said? Thank you.
Absolutely, that's what I said.
All right.
Okay.
Johnny, thank you very much. We'll see you. Bye.
All right.
That's the other half of the Nicole Goodman law firm. It was awesome. The officer was trying too hard on the stand. Used his emotions instead of facts. You heard that. PNW, you're right. Because we saw the handler, the trainer on the prosecution side, saying, the witness he was getting frustrated up there. He wanted to say certain things, and he was getting frustrated, and that's where he came out with this statement that could be objectionable. There should have been a motion to objection to that one. Court has not come back yet. The duck quacked a long time ago. We're refreshing every about 3 seconds, and nothing is coming up. Hope they've got this. Hope they didn't leave us hanging. We need to know how this one ends. PNW, I'd hate to have to send you down to the courthouse and say, look, we need a report. How did this finish? All right, the quack of justice is what we're going to call that one. That was a good one. Greeners, I like that. Let's see. Around 4 years of experience, says Jennifer, for the officer, the only witness, a star witness in this case. Marjorie, it is an odd-looking courtroom. The other 3 courtrooms that the Thurston County has are more traditional. This one was sort of cobbled together, repurposed, I guess you could say. A room was repurposed into a courtroom, and we've watched some great trials, some interesting moments in this courtroom. So we like it. Okay, they're back now. Let's bring this up. Judge is not back yet. We caught it the second it came live, so we're good.
Somebody just sent me a video of roaches fighting. I don't know who won.
Oh, yes, I got this one. I've got a picture of Nicole Goodman. Nicole. While we're waiting. Nicole Goodman in the pickle aisle at Walmart, finding my favorite pickles. Give me just 1 second. Airdrop. Oh, it's going to the wrong computer. That's why. Send it to this one. We're just going to briefly show an image. Nicole throwing up the deuces with a jar of spicy maple bourbon pickles. Nicole, thank you very much. Hopefully you're still, I still have you on retainer. I hope this doesn't change anything about our professional relationship. Glad to see you like them. They're spicy. They're good. Judge is back.
Should be back in just a second, Your Honor.
Prosecutor's missing. So, Steven says, 49ers fan. I knew it. Attorneys of Walmart subreddit. Just found their poster child. Greeners is like, hey, Nicole. Wonderful. We love Nicole. She's great. Johnny as well. Matthew Harris has been busy. He's a busy guy, man.
So we got the exhibits we know where the exhibits are. And
we troubleshoot it as much as possible.
Pardon?
We troubleshoot it as much as possible.
Okay,
keep this
good.
as smooth as we can.
So we've got, just want to be sure that I keep track of all 3 exhibits and the marked one. They all
State's Exhibit 1 and 2 should be with the clerk, and
Okay.
Defense Exhibit 1 is right there, and defense intends to use it during closing.
And then what was marked, the police report also needs to be handed into the clerk.
Did that go
Wasn't
back up
admitted,
there?
but it
I'm
was
sorry, I
marked.
think I left it with you.
We will locate it, Your Honor.
Okay, get that to the clerk.
There it is.
There it is. You can hand it over there.
And then I suppose we could have handled this before Your Honor took the bench. And I apologize. Part of my closing will involve a PowerPoint that's up and circulated to the parties. It does involve playing certain clips of the same dash cam footage that has been admitted into evidence.
Okay.
I would be happy to show those clips to the state beforehand just to make sure that they know, since I didn't pull it directly from the same
You want to do
USB.
that right now?
I'd be happy to do that.
Why don't we do that? Make sure everybody agrees that it's all part of the admitted exhibit.
Thank you, Cass. Congratulations on 11 months.
The last
Yeah,
slide.
wonderful.
of the slideshow. Right.
The state can't. The state has routinely prevented from doing such a slide. Defense.
I've given up on the whisper counter. We're over 40.
Yeah.
For a trial with only one witness. This
Your
is
Honor, can we address the defense's last slide of their
So why don't we
slideshow?
see it first, and then we can have that argument to make sure that we all agree on what we're arguing about. So why don't you that up, and so the
launch
state
the
knows exactly
PowerPoint?
what you're doing, and I know exactly what you're doing.
I wish it came in as a witness.
This is your defense PowerPoint, and Ms. Mann, there's a portion of that you're objecting to right now.
It would be helpful if I brought up the last slide.
Yeah.
Yes.
Okay.
PNW, I'm not sure what the rules are in Thurston. I haven't seen people texting, but they're far back. I would ask the bailiffs before you do that. Just ask them what the court decorum orders are regarding cell phones. They've got to be silent. I'm sure they won't want any ringers and stuff going off, or tones or alerts. He's quite accommodating. I don't think he has any idea. I'd love for him to find out. But every court is different, PNW. And even if this courtroom might have different rules depending on the judge. So it can be very specific to the actual event that's happening. Some judges allow some things and some judges don't. So you really have to.
Sorry. Okay, and you're objecting to a slide that simply says not guilty.
Yes, Your Honor.
On what basis?
On the basis of State v. Walker, it's
Impermissible opinion on guilt.
It's an impermissible opinion on guilt.
Tell me about State v. Walker.
We object that
I
he's
don't
not
have it
guilty.
for me, and I'm not being given benefit to read it, so you're going to need to tell me all about it. And defense, if they want time to look at that, you've got to.
We can have another break.
Do that. But tell me all about Walker.
1 moment, Your Honor.
She has no clue. He cited the case law, and she's never heard of this before, and now she has to
And you can share that with defense.
get up to speed on case law.
Your Honor, in State v. Walker, the court concluded that slides carrying the prosecutor's opinion on guilt were not just impermissible, but inflammatory and prejudicial. And I would argue that this equally applies to defense.
Remind me of the facts of that. I think I remember this case. And give me, is it appeals, Supremes, what year?
Guilty words. The word guilty in capital letters superimposed on a booking photo of the defendant.
In that case, Your Honor, the prosecution had a slide that had the words guilty in capital letters imposed over the face of the defendant. Was found to be impermissible. I would argue that this, well, not exactly the same, it's very similar.
So that was a Supreme Court case?
Yes, Your Honor.
And when was that? probably a lot longer than
2015, Your Honor.
9 years.
Yeah, okay. I do remember that now. So, Mr. Stillwell, anything?
No, Your Honor, I haven't had a chance to read State versus Walker, but the description of that slide, I think, sounds like it was much more inflammatory than simply the words "not guilty" at the conclusion of what is closing argument, where I'll be arguing that he's not guilty. No photos. I can't imagine that the text itself, without more, is as inflammatory as it sounds like the slide in that case was. It's simply a visual and literary summary of what I will be arguing, which is that Mr. Russell's not guilty.
And Ms. Mannigan, how shall I apply that then? And what is it that the verbiage from the Supreme Court maybe that you want me to consider?
The verbiage from the Supreme Court, Your Honor, is that slides carrying a prosecutor, or in this case, the defense's opinion of guilty.
The Supreme Court didn't refer to a defense, did they?
No, I was imposing that myself. I'm sorry.
Tell me what the Supreme Court said.
Many slides carrying the prosecutor's opinion of guilty are not just impermissible, but also inflammatory and prejudicial.
And so you think that this, how would Walker apply to
She's
defense,
guiding her through her argument.
A slide at the end of their closing that says not guilty. How shall I equate that?
Sorry, can you repeat that, Your Honor?
How shall I equate the Supreme Court decision based on what a prosecutor's limits are to what the defense limits should be?
Well, Your Honor, neither side, prosecution or defense, are allowed to give their opinion of to guilt in the court. It's impermissible.
All right, so an opinion. All right, I'm not finding that Walker is applying to the situation. I don't see this slide, which is a blue slide with a red hash mark at the top and says not guilty. That's what it says.
Not guilty. That's how he ends
the
his
decision
argument.
in Walker. I remember it also kind of ended up on the front page of the newspapers a few times because it was really quite something. It was a pretty bad picture, putting the defendant in a real bad. Their worst day is the mugshot, and then guilty slashed across it. It was quite dramatic. It was quite inflammatory, and so the Supreme Court decided that it was not. It had gone beyond what argument was allowed. It was closing argument. This I do not find in the same vein, and I also, and I think the Supreme Court too, finds a different standard that prosecutor has to hold than the defense has to hold. They both have to be ethical. One zealously advocates, the other does justice, and that's different. The prosecutor is held to a higher standard by the rules of ethic, by the RPCs, and in that decision, I think also that shows that from the Supreme Court's opinion. So I'm going to allow this slide. I don't find a basis to accept that slide from Mr. Stillwell's closing argument. I find it's argument.
Yes, Your Honor.
All right. Anything else in the instructions from you?
What's the attorney's first name? Is it Jake?
Anything
Jake
else,
Stillwell?
Man?
No, Your Honor.
Okay. Anything else, Mr. Stillwell?
No, Your Honor. Just that I'm happy to show the videos on my slides to the state.
Have you?
We have a chance to do that.
Yes, absolutely.
Yeah, let's get it confirmed that that's part of what.
And the email I sent was the PDF of the slides. Let me see here.
Let's see.
Oh, you know what? Yeah.
Thank you. If it's the right one, it looks like Mr. Stillwell might have been practicing law for about 9 years.
If there's a way, I would be happy to do this. But I don't want to share my notes on the PowerPoint, so I would be happy to have you view the footage on my laptop.
That's fine.
In presentation mode?
Yeah, no problem.
Thank you.
Jacob Stillwell is licensed in Olympia, Washington. If that's the right guy. Let me see if he's... Let's see, Jacob James Stillwell. There he is. Trying to find his.
I
if he's a public defender.
I play it again just without the.
And Your Honor, for clarification for my own notes, if the state was to have the exact same slide as defense counsel with the word not removed, would that be permitted under the court's ruling in this case?
I'd have to look at Walker again. Maybe. Are you intending to do that?
No, I just want to make sure that
Well, I'm not gonna make an opinion on something that is.
And then just since we're doing.
I was trying to clarify because the court said that the state was held to a different standard than defense.
Yep.
Which
is.
The state would disagree, Your Honor.
Well, I think the RPC, the rules of ethics, and the Supreme Court has done that. I think it's pretty clear. The defense does zealous advocacy. You both are held to the same base ethics, but the state prosecution has a whole other set into the RPCs that we have. I remember as prosecutor, we had to hold to that were different than defense and higher burden.
Well, we have higher. I would agree.
We don't have to argue about that now, but if
Yes,
you're
Your Honor.
intending to put in a slide that says just guilty, I'm going to have to kind of cogitate on that and maybe look at Walker again. But if you're not, I'm not going to go in there. We can get going with instructions of closing. So,
Thank you, Your Honor.
all right. So you've had this man, Mr. Stillo, you've had a chance to. You're good, this man, with those clippings that they're part of the admitted exhibit.
Yes, Your Honor.
Okay. All right. Let's bring the jurors in.
Before we do that, may I,
maybe
since
not.
I brought up the not guilty slide, if I could.
That put together.
I had it so that I could come up and press play.
Let's get it.
And I would like to.
Before we get to the thing.
Bring the jury.
Switch over the court. Yeah.
All right, so he's editing his PowerPoint.
Okay. Now we're ready. Thanks for the process. Feel free to be seated. Thanks.
Prosecutor's not in law school. She's licensed.
Don't miss the forest for the trees.
Don't listen to somebody.
We have a rogue juror. If we can summon the bailiffs to a sweep of the building.
All right, everyone can be seated. And so what you found on your chairs are my instructions to you, and I'll give you those instructions now. But first off, Ms. Mann, you've rested the state's case, and Mr. Stillwell.
Defense will not be putting on an affirmative case, so defense rests as well.
All right, so therefore we're moving on to closing instructions, moving on to court's instructions, and then the closing arguments. So you can follow along, pay attention. So I'm asking of you through these, and then we'll hear from the attorneys on their closing. So these are the court's instructions to you, the jury, on State v. Wakeman. And don't worry, they aren't all full page. So it'll take about 15 minutes to get through. So number one, it's your duty to decide the facts in this case based upon the evidence presented to you during this trial. It's also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. And you must apply the law from my instructions to the facts that you decide have been proved, and in this way, decide the case. And keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. So the evidence that you're to consider during your deliberations consists of the testimony that you've heard from witness, stipulations, and the exhibits that I have admitted during the trial. And if evidence was not admitted or was stricken from the record, then you're not to consider it in reaching your verdict. Now, exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they've been admitted into evidence. And the exhibits, again, that have been admitted will be available to you in the jury room. So one of my duties has been to rule on the evidence, the admissibility of evidence. And again, do not be concerned during your deliberations about the reasons for my rulings on evidence. And if I have ruled that evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations nor consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. Now, in order to decide whether any proposition has been proved, you must consider all of the evidence that I've admitted that relates to that proposition. And each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. So you are the sole judges of credibility of each witness, and you're also the sole judges of the value or the weight to be given to the testimony of the witness. And in assessing that credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. Now, in considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or to know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. Now, the lawyer's remarks, statements, arguments are intended to help you understand the evidence and to apply the law. It's important, however, for you to remember that the lawyer's statements are not the evidence. The evidence, again, is the testimony and the exhibits. The law is contained in these instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in these instructions. You may have heard objections made by the lawyers during trial, and each party has the right to object to questions asked by the other lawyer and may in fact have a duty to do so. And these objections should not influence you. Do not make any assumptions. Do not draw any conclusions based on the lawyer's objections. And again, our state constitution prohibits me, the trial judge, from making a comment on the evidence, because it would be improper for me to express by words or conduct my personal opinion about the value or weight of testimony or other evidence. Now, I have not intentionally done this. However, if it appears to you that I have indicated my personal opinion in any way, either during trial or in giving instructions, you're to disregard this entirely. So you have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it will tend to make you careful. And the order of these instructions has no significance as to their relative importance. They are all important. And in closing arguments, the attorneys, the lawyers may properly discuss specific arguments or specific instructions with you. And during your deliberations, you must consider these instructions as a whole. So again, as jurors, you're officers of the court. Thank you for your time and energy to the county. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, not on prejudice, not on personal preference. So to assure that all parties receive a fair trial, we ask that you act impartially with that earnest desire to reach a proper verdict. In instruction 2, as jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. And during your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence in these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Whoops. Instruction 3, the defendant, Mr. Wakeman, has entered a plea of not guilty. And the plea puts in issue every element of the crime charge. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. And the defendant has no burden of proving that a reasonable doubt exists for these elements. And a defendant is presumed innocent. The presumption continues throughout the entire trial unless during your deliberations you find that it has been overcome by the evidence beyond a reasonable doubt. And a reasonable doubt, again, is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or the lack of evidence. And if from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. And the term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something at issue in this case. Now, the law does not distinguish between direct evidence and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. And instruction 5. The defendant, Mr. Wakeman, is not required to testify. You may not use the fact that the defendant has not testified to infer guilt or to prejudice him in any way. And number 6, a witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any witness. Instruction 7, a person commits a crime of reckless driving when he or she drives a vehicle in willful or wanton disregard for the safety of persons or property. And instruction 8, to convict the defendant of reckless driving, each of the following elements of the crime must be proved beyond a reasonable doubt. Number 1, that on or about September 12, 2023, the defendant drove a motor vehicle. Number 2, that the defendant drove the vehicle in willful or wanton disregard for the safety of persons or property. And number 3, that this act occurred in Thurston County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction 9, willful means acting intentionally, purposely, and not accidentally or inadvertently. Wanton means acting intentionally in heedless disregard of the consequences and under such surrounding circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm a person or property. Instruction 10, a vehicle is a device capable of being moved upon a public highway and in a pond or by which any person or property is or may be transported or drawn upon a public highway, including bicycles. And concluding instruction number 11, when you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each of you has a chance to be heard on every question before you. Deliberations are to occur in the jury room and when all 6 jurors are present. You are all officers of the court and must evaluate this evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of your other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss the notes that you have been taking during trial if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories of your or notes of other jurors. And do not assume, however, that your notes are more or less accurate than your memory. You'll need to rely on your notes and your memory as to the testimony presented here. Testimony, if there, will rarely, if ever, be repeated during your deliberations. And if after carefully reviewing the evidence and these instructions, you feel a need to ask the court a legal or procedural question that you've been able to answer, write that out, question out simply and clearly. For this purpose, we have a form that we will provide for you in the jury room. In your question, do not state how the jury has voted. The presiding juror should then sign that question, date the question, give it to the bailiff, who is Ms. Garza, the clerk. I'll confer with the lawyers then to determine what response, if any, can be given. So you will be given the exhibits that were admitted in evidence, these instructions, and verdict form for recording your verdict. And some exhibits, again, and visual aids may be used in court but will not go with you into the jury room. The exhibits that have been admitted to evidence will be available to you in the jury room. So you must fill in the blank provided in the verdict form the words not guilty or the word guilty according to the decision that you reach. And because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, then fill in the verdict form to express your decision. The presiding juror must sign that form and notify the clerk here, the bailiff. The bailiff, who is the clerk, will bring you into court then to declare your verdict. So at this stage, we're going to turn to first Ms. Mann, and she does have the opportunity to reserve some time. The state has the burden of proof here, so they're allowed to be the last heard if they reserve time on their closing. But we'll hear from Ms. Mann and Mr. Stillwell in closing. So Ms. Mann, did you want me to give you any heads up, or are you going to keep your own time?
I'll keep my own time, Your Honor.
All right.
And I'll just reserve my remaining time for rebuttal.
All right.
On September 12th, 2023, Mr. Wakeman drove in a willful or wanton disregard for the safety of persons or property. Before I talk about the specific elements of this crime, reckless driving, I'd like to discuss the state's burden of proof for proving a crime in the court of law. It's the state's duty to prove beyond a reasonable doubt that a crime has been committed. You heard from the judge that a reasonable doubt is one that exists and comes from the evidence or lack of evidence. It's a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. And if, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. I submit to you that in this case, that means that if you believe that the defendant drove recklessly, you have an abiding belief. To convict the defendant of reckless driving, there are three elements of the crime that must be proven beyond a reasonable doubt. Firstly, that on September 12th, 2023, the defendant drove a motor vehicle. Secondly, that the defendant drove the vehicle in a willful or wanton disregard for the safety of persons and property. And thirdly, that this act occurred in Thurston County, Washington. Now, two of these three elements are clear with essentially no evidence to the contrary. It's clear that elements 1 and 3 are satisfied. The first element, that on September 12th, 2023, the defendant drove a motor vehicle. You saw with your own eyes the video of the defendant's vehicle driving on Officer Leishman's police camera video. You saw the officer pull over the defendant's vehicle and heard the officer identify the defendant as the one driving in court today. Similarly, for the third element, you heard the officer testify in court today that this happened in Thurston County, Washington, and you saw a map of the neighborhood where the defendant was driving. What is really contested today is this second element that I mentioned, that the defendant drove the vehicle in a willful or wanton disregard for the safety of persons or property. In this context, willful means acting intentionally and purposely, and not accidentally. Wanton means acting intentionally in heedless disregard for the consequences or under such surrounding circumstances and conditions that a reasonable person would know or would have reason to know that such conduct would, in a high degree of probability, harm persons or property. Please consider this in the context of everything that you have heard during this trial. 1, that you heard the defendant ran a stop sign. 2, that you heard that the defendant was not only ignoring the signs of the road, not only fishtailing and swerving dangerously, but actually went out of his way to pull off the road into a field and spin his car and do stunts. And thirdly, that the speed limit was 25 miles per hour, but the officer was driving at least 40 and still witnessed the defendant's car pulling away from him and gaining distance. You saw with your own eyes in that video how busy that intersection was where the stop sign was. And you saw on the map how close it was to neighboring houses, to sports fields, and to playgrounds. You saw how close it was to the people who lived in that neighborhood. During jury selection, we discussed why some areas are more dangerous than others to speed in or to drive off-road in because of external factors like sidewalks and like children in the area. Rochester Street was one of those areas because of its residential characteristics, its playgrounds, its sports fields. As jurors, you are officers of this court, and it's your duty to reach your decision based on the facts proved to you and the laws given to you, not on sympathy or prejudice or even personal preference. So when you consider the defendant, Mr. Wakeman, sped through a residential neighborhood, that he ignored stop signs, he ignored playgrounds, he ignored sports fields, when he did donuts in a field in the proximity of so many people with a passenger in his car, was he acting in a willful or wanton way? If yes, the state asks that you find him guilty of reckless driving. Thank you.
Still well when you're ready.
Morning. All right. And if you'll all please bear with me for one moment as I attempt to do the best millennial I can with PowerPoint. I will be referring both to this PowerPoint here and then as well the Google satellite map that we've been referring to throughout this trial so far to try and orient you all to where we are in the video. Judge Wilcox.
That's fine.
Thank you. And as I'll be kind of walking around a bit, I'll try to keep my voice up. I know we're not too far away from each other. All right. So for my closing, I'm going to let the video evidence largely speak for itself. I'm going to walk us point by point through what Officer Leishman said happened and compare that with what we see on his own dashcam video and why that matters to what he says happened when the dashcam video was off, before it was activated. So the first thing I want to focus on is Russell's driving conduct, right? So there's been allegations that he was swerving and fishtailing in close proximity to other people, right? To orient you all where we are here in this video, this is the opening of the dashcam footage. So at this point in the video, Officer Leishman is here, just coming out of the parking lot at Rochester Street West and about Minnesota's, right? So here's Officer Leishman, and we can see in a moment here, I have superimposed this high-tech red circle to show you where exactly Mr. Wakeman is driving for purposes of this still image here. It's this car. Right? So that's where everyone is. I'm going to play the video here. The circle will go over the car, and please pay attention to the driving conduct of that car as it travels down Rochester Street.
I can't see it, but I'm guessing the car is driving straight. Probably speeding, but driving straight. Imagine watching a video of a car drive straight down a road. That's what we're seeing now.
This period of the video is important because what we just witnessed was Mr. Wakeman driving down Rochester Street East. Rochester Street East is where this park is. Rochester Street East is where these basketball courts are. Okay? So this is the area of Rochester where he's close to homes, close to parks, and there's allegations of him fishtailing. I'd submit to you that the video says otherwise. What I saw in that circle that I've imposed there is him driving in a straight line down a straight line.
Your objection, this man.
Your Honor, objection on impersonal comment on the evidence. That's the attorney's opinion, not the actual evidence.
So there's some leeway here. This is argument, folks, argument. Remember in the instructions, I said the lawyer's statements and arguments are not the law, and with the evidence, you have to determine that yourselves. But there's some leeway because this is an argument. I'll allow that to stand. So go ahead, Mr. Stillwell.
And the reason that I impose the circle here is I do want you to come to your own conclusions about Mr. Wakeman's driving conduct during this stretch. And I think it's important to point out that that driving conduct is what occurred while he was going down this residential street next to the parks. Now, I'm going to play the video again. I promise not to play it too many times, but I do want to walk through it a few more times and point out some important points each time. And so this next one, I want to focus on speeding, right? This time I want to focus on Officer Leishman's testimony that he believed that Mr. Wakeman was speeding, in large part because Officer Leishman said he was driving 40 miles an hour, witnessed Mr. Wakeman pulling away from him while he was traveling at 40 miles an hour, and he used that as the basis to conclude that Mr. Wakeman must have been traveling more than 40 miles per hour. And you heard me on cross-examination discuss that in order for him to make that determination, at some point he needs to be traveling at 40 miles an hour. The comments that he made that sort of were made in addition to that were that, well, Mr. Wakeman could be going even faster if the officer who's pacing him accelerates, right? So if the officer accelerates and the other vehicle is driving further away from him, that might indicate the other vehicle's driving even faster. All right, so remember that analysis, right? Officer Wakeman is judging speed based on him going 40 miles an hour and witnessing Mr. Wakeman traveling at a great pulling away, indicating he's going more than 40 miles per hour.
So they're watching this video again for the purpose of trying to determine if the car is like gapping though, if the gap is growing between the two vehicles. So imagine watching a video of a car driving the same direction as you, way up ahead of you. There you go.
Now, the reason that's the stretch of the video I played for you making this point is because I believe it's a mixed characterization to say that Officer Leishman is traveling at 40 miles per hour for a sufficient amount of time to judge whether or not Mr. Wakeman is pulling away from him at that time. Reasons being, what did we just witness in that video? Officer Leishman is at this point, Rochester Street West. He slows as he comes to the stop sign here at Center Street, right? So rather than traveling at 40 miles per hour, he slows to a stop sign. He comes to a complete stop. He waits for traffic to clear on a busy city thoroughfare. He then carefully crosses that busy city thoroughfare. And then another car pulls in front of him, right? Driving at what appears to be the speed limit, as one does when you're in front of the cop. And then what we saw at the end is Officer Leishman then has to speed around that other car.
That was funny.
So what does that tell you? It tells you that Officer Leishman is not traveling at 40 miles per hour the whole time Mr. Wakeman is traveling down Rochester Street East. Rather, Officer Leishman was slowing as he approached the stop sign, came to a complete stop at that stop sign, carefully crossed the road behind another car, and then had to speed around that other car. So keep that in mind when the basis of the conclusion here and the argument from the state that Mr. Wakeman was speeding comes from the fact that Officer Leishman says he was pacing him at 40 miles an hour. But that pacing included slowing, stopping, restarting, and then speeding around another car. That is in addition to the fact that the state does not have evidence of how fast Mr. Wakeman was actually going. Mr. Wakeman was not issued a traffic or speeding ticket. Okay. So, next, I'm going to play this for you again. This time, I want to focus on Officer Leishman's testimony that his lights were activated. He testified that his lights activated and his dash cam footage turns on. So the idea being that his dash cam footage is on, that means his lights are activated. Okay. So I'm going to play this again. And this time, I want you to pay attention to what are the other cars doing around this officer? And does it make sense to you that this is a scene where a police officer has their emergency lights activated?
A car pulls out ahead of him. Oh, there's my back door. A car pulls out ahead of him in the video, as has been described, and is driving in front of him. So he's saying it's not reasonable to assume that the police officer had the lights on because the car wouldn't make that turn in front of a police officer and remain driving in front of them if the lights were on. Was not charged with speeding.
Counted 3 cars crossing Center Street, and then this dark sedan pulls in front of the officer, all while he apparently has he has testified that he has his emergency lights activated. You see a few moments before I stopped this here that while he's behind the sedan, what you do see on the video is suddenly a light. The sedan then turns on its blinker, suddenly yields to the officer. The officer then speeds around, right? That's what the video shows. So what, right? Who cares about all this? We're here for reckless driving. I'm focusing here on when the officer activated his lights. Well, I think it's important here because Mr. Wakeman's driving has been characterized as pulling away from a police officer whose lights have been activated. When those lights are activated, whether he's stopping at a stop sign, whether traffic is yielding to the officer, whether cars are pulling in front of that officer, matters because that tells you, or that might indicate to you, whether or not it's reasonable to think that Mr. Wakeman, if those lights were activated, would even have any reason to think those lights were for him, right? It matters because this incident is described as Mr. Wakeman pulling away from an officer trying to pace him at 40 miles an hour with his lights activated, when actually, according to the video, the officer has to come to a complete stop after slowing for the stop sign, waiting for traffic, traveling behind another car. That's a different situation where rather than Mr. Wakeman pulling away from an officer attempting to catch him with his lights on. I believe that characterization that is offered by the state makes Mr. Wakeman's conduct seem worse than it was, according to the officer's own dash cam video. I'm going to play it one more time.
He's got
I'm going to fast forward in a bit so we don't have to watch so much.
He's also got to hit
this time I want to focus on
the report
distance.
issue.
Specifically, I want to focus on the distance that Officer Leishman was when Mr. Wakeman entered the gravel parking lot. And to orient us to where we are here, we'll be watching the video from when Officer Leishman is here at the stop sign at Center Street. And Mr. Wakeman is here at the end of Rochester Street in the gravel parking lot. This Officer Leishman himself indicated it's approximately 1,000.
So they're rewatching the same video again, the latter portion showing the distance between the officer and the suspect's car, which was considerable. Vehicles were in between in the intersection. At least one sedan was between them after the intersection.
In case it was tough to see, I've circled it again for you here. Now, this is a screenshot of when Mr. Wakeman is first entering the gravel parking lot. Again, to orient ourselves here, Officer Leishman is here, Leishman is here, Mr. Wakeman is here, approximately 1,000 feet away. Officer Leishman is stopped at the stop sign, waiting for traffic to clear, then carefully crossing a busy city thoroughfare behind another car, still approximately 1,000 feet away. I've circled here where Mr. Wakeman is allegedly spinning in circles in the parking lot, right? That's the view from Officer Leishman's dashcam footage. Here, I've circled Mr. Wakeman leaving the parking lot. At this point, Officer Leishman has crossed Center Street. He's behind this other car, but he's still far on this end of Rochester Street. We're still talking hundreds of feet away. Now, to put some of this distance in perspective, right, from back of end zone to back of end zone, that's 360 feet. So if we're 1,000 feet away here, we're talking about Officer Leishman being at a distance of almost 3 football fields while crossing a street behind other cars while trying to view Mr. Wakeman's conduct at the end of the road.
Looks like the prosecutor is leaning on the
Another thing I'd like to point out,
shoulder.
actually staying on this one for a moment. There was discussion of Officer Leishman's dashcam footage, and he was describing it as a wide-angle camera, and that one reason why the images might be the way that they are is that he said that his dashcam has trouble, or something to the effect, picking up objects at a far distance, right? That was his explanation for some of the quality of the video. Well, I couldn't agree more. If Mr. Wakeman is at such a distance, the dashcam footage is having trouble crystallizing and just showing with precision his conduct. Well, that indicates to me that he is that far, so far away that his dashcam footage is having trouble picking him up. That also speaks to the distance with which Officer Leishman was trying to observe all of this. So now I'd like to move to people or property, right? So you've heard from Judge Wilcox and from
5 minutes left.
Thank you, Your Honor. And from counsel for the state, the elements of reckless driving. And some of those elements, and willful and wanton disregard for the safety of people or property. Willful means acting intentionally and purposefully. Wanton means intentionally and heedless disregard for the consequences under such circumstances and conditions that a reasonable person would know or have reason to know that such conduct would, in a high degree of probability, harm people or property, right? So let's look for people or property. What we're going to look through now is a couple of screenshots from the dashcam footage. And to orient ourselves here again, this is Officer Leishman now traveling down Rochester Street, right? So this is the street where we have residential homes and we've got parks. People or property. Nobody's on the left side of the road. No cars are on the road. No one's on the right side of the road. So Officer Leishman said, he testified that there had been pedestrians throughout the afternoon. What he did not say is that there were pedestrians there when Mr. Wakeman was driving down the road. Which makes sense, because that's what shows on his dash cam. Now here we are at the park, right? And you saw a Google Street Map view of essentially the same spot. And here, Officer Leishman is approaching the park out here on Rochester Street. And yes, as he testified to, there are children playing at the park. And you can see there are people at the bench there. We watched video a few moments ago of Mr. Wakeman's driving conduct while he was going down this road. It was smooth and it was steady. Okay? And we don't know how fast he was going. Again, Officer Leishman said he was pacing him for 40 miles per hour, but at the same time slowing down and coming to a complete stop. So we don't know how fast Mr. Wakeman was driving. Whether or not he was speeding is a matter of opinion. But what we can see from the video is he was driving smooth and steady while he's going by this park. And what else do we see? Yes, there are children at this park and there are people at the bench where they are supposed to be, right? Cars stay on the road. There's no evidence that Mr. Wakeman at this junction has left the road. The people are in the park where they're supposed to be. And there's this field in between the people and the road that is empty. There's nobody on the left. The cars are people on the road. Some people at the park on the right. So where people are supposed to be in parks. Another point about this photograph, none of these people were interviewed, right? So while Officer Leishman was behind Mr. Wakeman, we don't know what these people observed. That's, again, why we have to rely on Officer Leishman's testimony and on his Dashcam video. These people were not interviewed about what they saw. And the final screenshot I'll show you, and this is where, to orient you, Officer Leishman is now turning left onto Idaho Street, or Idaho Avenue, right after the park road. This image gives a good shot of this park here, right? This is where his dash cam is pointing, right here, right? This is where the basketball fields are. This is where the, this trail he talked about is, where there's baseball fields. No people. Empty. Empty side of the road on the left. Empty road, no cars or people. No people in the field next to the gravel parking lot. It is empty. This shot also gives us a good view of the gravel parking lot where Mr. Wakeman entered. Empty. No people, no cars. So again, what we're looking for here is proof beyond a reasonable doubt that he drove in willful or wanton disregard for the safety of people or property, right? Show me the people or property. Now, the video, I'll admit, is not the only evidence of what Mr. Leishman observed, right? Mr. Leishman also testified that he observed Mr. Wakeman's conduct before his dash cam was turned on and while his dash cam was pointed in a different direction. I will also point out to you Judge Wilcox's instruction that you are the sole judges of credibility of each witness. That includes police officers. And in considering a witness's testimony, you may consider the opportunity of the witness to observe or know the things that he or she testifies about, and the ability of the witness to observe accurately, and the quality of the witness's memory while testifying, right? What this tells me is Officer Leishman's reliability as a witness really matters when it comes to him testifying about what he saw that doesn't have video evidence backing it up. And the inconsistencies and the way that he has described this event against what we can see clearly on the video has bearing on his credibility as a witness to what he says happened before the video came on. He tells you that he observed Mr. Wakeman fishtailing and swerving all over the road before his dashcam video picked it up. But we saw Mr. Wakeman's driving when it is on camera. It's not swerving and it's not fishtailing.
You've kind of come to the end of your time. I'll have you wrap up.
All right, thank you, Your Honor. Well, and I've come to the end as well, because I want to reiterate the standard of proof here. And ask yourselves, after reviewing the video and after reviewing Officer Leishman's testimony, do you feel comfortable making a decision beyond all reasonable doubt that Mr. Wakeman drove in willful and wanton disregard for the safety of people or property.
Objection, Your Honor. That's a mischaracterization. It's not beyond all reasonable doubt. It's beyond a reasonable doubt.
Stay in the objection.
I am happy to rephrase. You have to find beyond a reasonable doubt that Mr. Wakeman drove in willful or wanton disregard for the safety of people and property. And just ask yourselves if you're comfortable with that standard, given what you've seen on the video when compared with what Officer Leishman said he saw. Or is it the case that the video shows that Mr. Wakeman was driving in a smooth and steady manner, where we don't know how fast he was going, in the absence of people or property in harm's way? In other words, he's not guilty. Thank
you. About 17 minutes.
He ended with the not guilty slideshow. Didn't address the missing information in the report. I think that was a missed opportunity. I realize the report's not evidence, but bringing that up might have been a good reminder.
Despite what the defense may want you to believe, driving recklessly does not require present danger. It doesn't require a pedestrian about to get hit by a car. It requires a willful or wanton disregard for people or property. Now, the defense says, show me the people or property. We have. You saw the cars at the busy intersection where Deputy Leishman testified the defendant ran the stoplight. You saw the playground.
It's not a stoplight.
Stop sign. Oh, my apologies. It's where the defendant ran the stop sign. You heard the testimony that there were pedestrians at this playground, at these sports fields. This was not an abandoned lot. It was a busy residential neighborhood. And you heard testimony that not only were there people in this neighborhood, there was a passenger in the defendant's car. He was carrying a passenger with him while he performed these acts. Now, there's been a lot of discussion about this video, and you do see a lot in it, but I'd like to remind you that a video isn't the whole story of what happened there. It's a snapshot. And in fact, the video only activated automatically when the officer activated his lights, which means the beginning of what the officer saw is not included in the video. And the video is affected by things like camera quality and angle. So you're not seeing exactly what the officer saw or exactly the full story when you watch this video. However, I do encourage you, when you go back into your jury room for reconsideration, to watch between 17 and 30 seconds of the video. And I apologize, but really get close to the monitor when you do, because as the defense pointed out, and as I'll admit, the quality is hard to see. It's hard to see the defendant's vehicle. But if you do, you'll see the defendant speeding. You'll see the defendant make a hard right turn into the field exactly as the officer said he did. And you'll see him make a hard pull out when the officer crosses the road. What you'll see is exactly what the officer described. The defense focuses a lot on speeding. They want to argue that the officer doesn't know exactly how fast the defendant was going. But what we have is a witness who has specific training on how to estimate car speeds and if they're speeding, and who was confident enough to get here and testify today that yes, he believes the defendant was speeding, that he estimated it based on his speed. And furthermore, the elements of reckless driving aren't all about speeding. That's only a small part of what happened that day. Okay, the defendant ran a stop sign. The defendant was swerving. The defendant was doing stunts like donuts or roadies. Yes, speed's a part of that, but it's not the whole story, and it's not the only reckless thing he did. The defense even said himself that the officer had to stop at the busy thoroughfare. The busy thoroughfare. Can you imagine what would have happened if the officer didn't stop, if he hadn't waited for those cars to pass? You see for yourself and have heard for yourself what happened that day. Okay, you saw the defendant's driving. And I ask you, as you go back and consider what happened, was it reckless? Did it demonstrate willful or wanton disregard for the safety of persons or property? If your answer is yes, then I ask you to find the defendant guilty of reckless driving. Thank you.
Well, now, let's see, it's 11:15. I'm thinking that we'll just put you into deliberation now, but I suggest that you get a drink of water. We got some snacks in there. Feel yourself a little. We're not going to make it work through lunch. We'll talk about that too. But I think maybe you can at least get started, get a presiding juror going, and see where you are.
The Reese's Animal
So
Crackers.
you see there's 7 of you there. 6 of you will start and be our jury. I've picked number 7, the very last there, to be my alternate juror because I've frankly lost a lot of jurors. They in the old courtroom, they'd fall asleep in the afternoon. So then we had to start over with an alternate. So I'll give you instructions as to what your job is now and your role is. The other 6 will get you going with Ms. Garza. And again, if you need a bathroom break, take it. If you need some water and a snack, please do that. It helps your brain work best. And then, like I say, I know people's stomach goes off for lunch, and we'll talk about that too. If that's a decision that you want to make, we can make that happen. So, juror 7, just hang with me, and I'll talk to you particularly about what your job is now. And up for the jurors.
Jurors, if you go by, I'll dump a few M&Ms in your hand. They're Christmas M&Ms. They're a little old, but they're not expired yet. Oh, you want a juror 1? Here you go. There you go. Okay. 4, you want a couple? Yes? More? Is this enough? There you go. All right. See you guys. Good luck on the deliberations. Make sure you get to come to the right conclusion. Hopefully you didn't watch our poll, though.
Okay, so everyone can be seated. And for juror 7, you're still part of this jury, but I want to kind of tell you how this works. And I'll ask, you're not going to have to sit here and wait in the lobby or anything. You'll be able to be 15, 20 minutes away. But at the outset, we've chosen extra just in case. And like I said, I think I've had 7 juries where I've had to pull in that extra. So it's likely. And so you're still part of this jury. So you're still part of my orders. You need something from her first. Yeah, we'll get that. We're going to get your contact information the way you want to be contacted so we can tell you come on back or you're relieved. So, so you're temporarily excused, but what that means, you're still under all those orders, all that nagging I gave you. Don't talk to the other jurors about this case. Don't talk to anybody else about the issues that people, the case. You'll be relieved of these orders soon, but not yet. And then again, remember, don't go online and say, well, I'm the alternate juror in a jury. You know, all of a sudden people are going to look it up, send you information, and that's not information of the case. And then we'll have violated those standards and your oath. So you tell folks, can't tell you about it, tell you all about it later under court order. Don't allow anyone to give you information about the case, and that includes family, friends, social media, and certainly anyone in the parties or anyone to give you information about the case, and try and keep yourself away from, I'm going to ask that you don't hang out in this courthouse, this building, just clear the space, because you'll be in public areas where you may overhear things that you just shouldn't, and you put yourself in a spot to innocently violate the orders that I'm giving you.
Don't watch a Zoom feed either, 'cause the prosecutor says all sorts of
gain
stuff.
information in any way about this case or the people in the case, the issues, then don't discuss it with anyone else. Let Ms. Garza know, and then we'll figure out what we need to do with the attorneys. And for now, just try and avoid reading or investigating any information about reckless driving or certainly don't do any research. Don't go to the area that this is alleged to have occurred, and don't do any investigation there. If in your regular travels home or work or wherever you're going to go while we wait to see if you're needed, that's your regular path. I'd ask that you find a different path, but if that's the path, you will not stop, you will not investigate, you will not give it any more notice than you would have on Monday before you got chosen for this jury. Don't do any other kind of research. Don't look up names. Don't look up people. Don't look up definitions of words. Don't look up law. Nothing. You've gotten all that here. All right. So we'll get information as to how you want to be contacted and try and keep yourself, within about 20 minutes of here so that we can get you back promptly. And we will call you when you're relieved of all these orders and let you know what happens. All right, so Ms. Garson's doing that, and we're going to be in recess. If each of you could write down how you want to be contacted, great.
Already doing it, Your Honor.
You're already thinking ahead. Thank you. And then Ms. Garza will contact you in that way. And, I'm going to kind of let the jury let me know. I don't like to keep people past 12:30. People's stomachs go off for lunch. So how about everybody anticipate reconvening here at 12:20. So if we have to make that decision, I have you all here to talk to about a lunch break. All right. And then I can give them a recess instruction on that. And let's all be back by 12:20 just in case we need to talk about that.
Yes, Your Honor.
Thank you.
You got all the exhibits? Okay, all
Stick
three.
around to get the feedback.
And the unmarked one too.
Explain who you are.
Yeah, but the unmarked one is the photos with you. So, perfect.
All right. It's a little informal, but we're in verdict watch now in this case. Let's see.
That was back at 12:20, Your Honor, you said?
Yeah, if you can just be back at 12:20 with your client.
Come back at 12:20. What time is it now? So is that an hour? Giving them an hour for deliberation?
Yes.
This needs to stay for the jurors to use if they want to watch it.
The mentor attorney is really taking ownership in the courtroom, just doing all sorts of stuff.
I don't know if there's only a certain spot.
I have no idea. So you're gonna need to.
I don't know if that drive that you down there is that exactly.
Oh, that's.
Oh, on the fund drive.
Yeah.
It's only what's been.
Okay, because they're watching.
Yeah.
They're already watching the video.
I'm glad it was you that was my first trial.
This is your first
Yeah.
trial? Is that right?
Yep.
How you feel?
I learned a lot regardless.
You know, it's like
Called it first trial.
6.
Really?
It's still just like working the
Don't say that.
Yeah.
And most of my second in this courtroom.
Oh, yeah.
Different.
You worked for like the legislature before, right?
Department of Commerce.
Oh,
Yeah, doing
okay.
like legislative.
Okay, yeah.
For a period, I've
Wasn't
done so much. Yeah. So I graduated Gonzaga in 14. Bounced around a little. I was a clerk. I was a public defender in Everett. And then I spent like 6 years doing.
Oh, the feed's down. We were going to get his Mr. Stillwater's backstory, but no, they've taken the feed down. Both rookie lawyers. It sounds like he's done a lot of stuff for years. It's her first trial. Yeah, go Zags, right? Yeah, she learned all about mistrials, what not to do. So, let's see. Yes, maximum penalty. This is what the judge could impose, and it might not happen if he is convicted. If the jury does convict him or find him guilty, then I don't know if there's going to be a pre-sentence investigation in here, but I would be very, very surprised if the judge throws 1 year in jail at this kid. I would be surprised if he misses next week in school. Okay, it's not going to happen. His school's in session. She's going to be like, get back to school, knock it off. You have to wait a year before you can drive again or something like that. Okay, the origin stories, yeah, they're gone apparently. see, we can take a break here for lunch. I know it's a late break, but they're late in the day because they're going to be back a little bit later. But what I need is some volunteers who can let me know as soon as this goes live, because I can refresh constantly myself. But I know a couple of you are really good at doing this and can text me when this happens. So we want to catch the verdict when it comes back. We want to hear the jury. And it's going to be quick. It's going to be live, and they'll be like, "Do you have a verdict?" That's like the first words we're going to hear. Please pass the verdict to the court, and then it'll be read. It's not going to be a long thing. There's no media to notify. As long as the parties are present, they are ready to proceed. We did the poll. I think it was like 80% of you or so felt the state did not prove the case. We did not ask the question, is he guilty? My gut tells me that this kid probably was doing a little hot rodding in his mom's car. That's what I feel. I don't know. I don't have enough evidence just from what I've heard. I didn't see the video, but I don't have enough evidence about the speed he was traveling. I'm not convinced that an officer in that position could make a good judgment of speed. So what he's testified to, I'm not going to give that a lot of weight as a juror. So was he over the speed limit? Possibly. Was he doing donuts? Possibly. Does that amount to reckless driving? Man, that reckless driving charge is huge. That's huge. I mean, think of people who get like a 90-day suspended sentence and what they can do in the law compared to what this kid could face a year in jail. Not sure. All right. So it probably was mouthy. Maybe had the stereo booming. He had the big Bose speakers installed in his mom's car, so he had the big subwoofer cranking the stereo as he's driving along. What's Thurston County on YouTube? I'll watch. It is. Show you. The feed we're watching particularly right now is Thurston County District 4, which is this little white circle. If you search for Thurston County District 4 on YouTube, there are 4 district courts. So this one will show up and it'll have all the uploads. There's all of our court from this trial. There are 3 others as well, right? You've got District 1, which here, let me go down here. You've got District 1, which may be in session. They're live. They're right here. We've seen that judge before.
Apartment complex.
Okay. We've got District 2. Let's see. District 2. Where's District 2? Oops. Went to the wrong one. District 2, they're not live right now. And we have District 3 as well, who is also not live right now. So we just have 1. Let's take a quick peek in 1 really quickly because we've seen this judge before.
Zoom hearing with my mental health, mind over mood or mood over mind. I did that yesterday by Zoom. And I started it on the bus. She asked me to do it when I got off. So I got off and I did it. And then I took care of my stuff with the court stuff afterwards. So I'm keeping in compliance with that. I'm guilty for eating poppy seeds. I did pot for UA last week, but it was through poppy seeds. They're waiting for the results to come back. It was a sandwich I ate. I didn't realize that it was going to happen until after I had almost finished the sandwich, and I looked at it and said, I'm going to probably pop hot because of this. So if I wanted to get
it was the poppy seeds
morphine, I could go straight to the doctor. They would just give it to me because of my neck and back injury. I took him here for a little while, as you guys know. I stopped. That's not what my intention is. My intention is to get better. That's why I'm going through all these medical issues, medical treatments. I go through physical therapy twice a week still. Also go to massage once a week now. I don't know what else I could do, Your Honor. I'm doing everything I can.
Okay. I know one thing you can do. Thank you. Zach?
Yeah. I do have a copy of the motion that I wrote in my response in my bag, and I have a copy, and I will make a copy, and I will have them give it to you so you understand what's going on.
Okay. By the way, I look here and on the site that I have, it doesn't have any hearing for you scheduled for tomorrow.
Yeah, it does. It actually does at 1:30, room 202C, I think it is. I have the paper in my bag.
So it's with DOC?
It's in Pierce County.
Oh, Pierce. Yeah, well, this is a statewide thing, but, so just check, double check.
Here, hold on.
I've seen it on links. When he was with me the other day.
Okay.
It's on
And he's gone. Apparently. Hold on. I'm not sure where he's headed, but he's. He's off.
You may.
I like this judge. He's always got a smile on his face. He's heard it all, right? Every excuse. He's seen it all, but he's still.
So the Superior Court uses a data system which has holes in it, which doesn't always compute to the state system. So that hearing doesn't appear here.
Okay.
Clearly you have it.
Yeah.
So I was concerned that maybe the hearing had been canceled for you or something, and I wanted to let you know, but it looks like you have it. And I'm guessing that the issue is that their Odyssey system hasn't gotten the information onto the state system yet.
Online.
So, okay.
Yeah, I had it scheduled for the 15th of December, and I remember I had talked to you and Zach and everybody else, and they had said that I was going to be terminated on the 4th. And I was really leery about it in the first place because I know how DLC acts. You know what I mean? And it was still a couple of months over what I was supposed to do. But I figured, a couple of weeks really isn't much difference. So I let it slide, and I told the court clerk to set it for after that date because I wanted to make sure for myself that they took care of it. And they didn't. You know what I mean? They decided to play their games. So, they're going to see me in court tomorrow.
Okay. All right. Zach?
Despite everything that's going on, you're staying on top of what you need to do, and you're trying to get enough resources figured out. This is your second stint in Southeast. Let it go and ignore them now. It happened once, it happened twice. Who knows how many other people have to do that. That's a good time to figure it out there. So I say just focus on problems moving forward.
Yeah.
And like I said, if whatever happens tomorrow, just kind of let me know if they need anything from you. I can get you.
Yeah.
Josh.
Sounds like a lot to navigate.
Is this Veterans Court?
So I think it's commendable that you're staying on top of everything and that you have all this going on and still able to move forward. Because it's frustrating when things happen that we're not in agreement with, but to move on from them and to try to make the best out of a bad situation is still important. And so, I just commend you for getting all that other stuff set up for housing, because that can be daunting and overwhelming. So the fact that you've already got multiple leads, I think is impressive. So keep it up. I know it's difficult, but it sounds like you're doing the right things. Okay.
Yeah.
And Isaac.
Colin, I do commend you on all you're doing, despite some obstacles that you've had. I just want to remind you, you've got access to a lot of resources here, and Zach is a phenomenal resource, and he's working to help you. So anything you need help with, he's here to help you with. So maintaining that connection, that contact, that relationship is pivotal to your success here. And I recognize that you've had a lot, and he's just a person that's here to help you. We all are, but good to see you.
Yeah, you too.
So, Colin, what's going on with the Northwest Resources and the?
Okay, so
we're gonna bail on this one here really quickly.
Occurred.
It sounds like they're giving him the support he needs. I'd like to see somebody who's had a rough time, that is getting back on their feet and is making efforts to change things around. I wish him all the best. That is awesome. It's sort of court ordered mental health work. He's working on himself. He's doing what he can. He's not, I guess, if he was perfect at everything, he wouldn't be there in court. He's admitted he's did some things that were probably not the best, but he's trying. So that's good. Poppies, I don't know about the poppy seeds. We'll just let that one slide. I think that's just going to water under the bridge. All right. We are, as we wait for Thurston, we've got this, here's what we got. We've got the timer. Their deliberation is now up to 15 minutes and, almost 15 and a half minutes of deliberations. We know we've got Judge Boyd, who is back in session right now, and I want to see, just to find out what's happening with her court. We have another court case with the Treehouse case. So we've got that we're going to be playing catch up with, but let's check in with Judge Boyd really quickly.
So,
Charles, can you give me like 2 minutes?
sure. All right, if you guys will step back and probation will look into that. And then Norma, on this case, with regards to the occupational license, their client needs to get a updated license first before his license has expired. So before.
It looks like she's just working her docket.
Barbara?
Okay. Yeah. But so his license has expired. So once he gets his license renewed, then I'll consider this. All right. So they'll come back with a new date on that. So the only thing we're going to hear on this today is the GPS. Well, just let her know that his license has expired.
You're in Dina? Just replace this.
Is there anyone who's ready?
Anthony, I need your application for probation.
Judge,
who's your
is there
client?
anyone who's ready?
It's Devin Strike.
All right, sure. As soon as, just let them hand me the file and I'll take it up.
Let's see if this audio is any good.
Somebody just sent.
It's a little loud. Sorry.
Somebody just sent me a video of roaches fighting. I don't know who won.
Okay, so we just need to grab that end bit.
Devin Strike. Somebody just sent me a video of roaches fighting. I don't know who won.
Yeah.
That's better.
That's what I think we're trying to.
All right, your client was late for court.
Oh, my apologies.
My lift was delayed.
All right, so you're going to have to make sure that you're on time for court. You understand?
No.
All right, so where are we on the mental health court?
Don't know. I don't know if Ms. Ferguson's here to give us an update.
All right, just give us a moment because I know he was waitlisted.
Yes, Your Honor. And I think we reset it for a month or so to see if we can hopefully make some progress on that.
Have they had any contact with you? All right. Let me see.
Oops, sorry.
Norma, on Devin Strike, do you know if they have seen him for mental health court? All right, so we're going to find out.
Okay, we got the new sound effect in. Adjusting the volume to get it right.
Somebody just sent me a video of roaches fighting. I don't know who won.
Is that about right?
Somebody just sent me a video of roaches fighting. I don't know who won.
That's better. All right, thank you, Judge Boyd, for that this priceless audio as well. Okay, now it's updated. Audio's better. All right,
Somebody just sent me a video of roaches fighting. I don't know who won.
Let's see, show chat, pop out chat. Make it full screen. Okay, closing arguments are done. We're going to unpin that message We are with Judge Boyd here just for a minute. We're still on verdict watch, so let me bring the timer up on screen.
You can call Michelle right now.
Okay.
When are we going to break for lunch,
Mhm.
Judge?
If you can call her and see where he is on the list. Okay. All right, so we're going to find out.
Yes, ma'am.
And then we'll,
You want us to sit back down?
yes,
Okay.
if you just wait, this shouldn't take that long.
Yes, ma'am.
It is. It is.
What more do you need to see?
Sorry, I got the volume way loud. I'll turn it down just a little bit. Judge Boyd would probably laugh. She's great. Before she responds to whether she likes the fact that we have the roach
See if you
audio
have any
bite,
objections to that, but they say federal pretrial has approved it.
remind her that we sent her a
Hi.
huge
Hello, Judge,
bouquet
I'm back.
of flowers.
Hi, and what is your client's name?
Mark Hernandez, Judge. That was the early term that's segued into something else.
You want to bring him up?
Yes.
What is it segue
Hello. All right. You asked for early termination?
Yes,
You told me you would be negative
I thought I would have been negative too.
because when did you use?
Like I told my attorney, I didn't use. It's just been around a bunch of my family members who've been using during the holidays.
I explained to him that one of the conditions of probation is to not be around people engaging in that activity.
Nothing says Christmas, I guess.
Ho, ho, ho.
Yeah. Your family members, if they're using marijuana around you, you probably shouldn't be around them. So who are these family people who are using marijuana during the holidays?
It's like my brother-in-law's.
Yeah, you can't be around them.
Sorry about that.
And you should tell your brother, thanks a lot. I'm now not being terminated early because I'm testing positive for marijuana. All right, Lashana, Mr. Hernandez,
Why'd you out me?
if you can have him tested for levels.
That's what I was going to ask, Judge.
Okay.
He looks nervous. Okay, that's a nervous look. I'm
Within
sorry.
the probation's discretion.
Yeah, he said it was a contact
Is there
high.
anything else you need from the court?
This time.
His eyes
Counsel,
got wide
anything
at
else you
that
need?
tested for
No,
levels comment.
No, Judge.
All right.
No.
You can't use marijuana when you're on probation. It's not allowed. All right. Before you leave, just speak with probation.
All right, thank you.
Yes, Mrs. Ray.
Yes, ma'am.
Yes.
We don't have any objection to that. Let me ask you.
Okay.
Can you write his number down?
Yeah.
They're gonna try to set him up. They're gonna call him. He was on the waiting list, Judge. So I'm trying to verify his phone number so they can give him a call.
Okay.
Okay, Mrs. RA has my phone, which means it will not be answered. Don't bother calling. I can't answer it either right now, but she's going to go pick up groceries. Which apparently you need a
All
phone
right,
to do
Norman,
now.
here
You can't
is
go shopping
this
without a
on
phone.
Pacheco.
Oh, he's here.
Because you have to text them and say, I'm here.
All right,
bringing
Mr.
you the
Pacheco,
groceries.
come forward.
Went to the bathroom.
All right.
You went to the bathroom.
This number, we are ready on Mr. Wilson.
Okay.
Summarize.
In right now.
All right. Mr. Pacheco, come forward.
I think they told the attorneys to come back in an
Hi.
hour.
Hello. All right. All right. You'll be allowed to travel, but you're going to have to UA upon a return.
Okay, that's fine.
All right. So when are you coming back?
Monday,
All right.
Monday night, because I gotta be back here in court Tuesday.
Yes.
Yes.
All right. Yes. You will be allowed to go.
Okay, thank you. Could I get a copy? They'll send me a copy or?
Yes. We'll give you a copy right now. Just give me a moment.
All right, thank you. Have a good day.
All right. You too. Mr. Pacheco.
Okay, can you ask if my be available by phone on Tuesday at 10 o'clock?
This Tuesday?
This Tuesday.
Tuesday at 10 a.m. Will you be around? Okay, 10 o'clock Tuesday.
Yes.
We are
All
on
right.
Verdict Watch. The
And
counter in the
then-
bottom is Thurston County's
Yes, sir.
Verdict Watch timer.
Yes,
We're
yes, sir.
refreshing
10
constantly to
o'clock
see
on
what
Tuesday.
happens down there. When they go live, we'll go back to it.
Thank you so much. Bye-bye.
You can't picture him playing polo?
Yes, I do.
That's his team jersey. What are you talking
So he's
about?
going to be interviewed at
horse.
10 a.m.
10 a.m. on Tuesday.
Tuesday. So when do you want to bring this back? Mm-hmm. Let's do about a month, maybe.
I'm looking at Mark.
February?
February.
That works.
All right, we'll come back on February 15th. All right, thank you.
Thank you, Your Honor. Are we excused?
Yes.
Thank you, Your Honor.
The polo guy plays
I need-
polo
I
on
need
a
to run to
Budweiser horse.
6. I'll be right back. Thank you, Judge.
You're welcome.
Big old Clydesdale.
All right, and then Shannon, I'm so sorry. We'll take you up right after we finish with the interpreter.
See what I'm asking.
Okay, all right, thank you. Hi. It is for Orlando and Dino.
In the future, interpreters are not going to be a thing. I'm just calling it right now.
Hello, how you doing? I'm doing okay.
Thanks for dressing appropriately for court.
Okay, does he need an immigration, does he need an interpreter?
Judge, I
Does he-
guess so, just to know what's going on.
All right, because he just spoke with me, but okay. All right.
He's like,
I'm sorry, I was here for an MTR. Judge, I'm here for an MTR. So
All right.
I don't have this information.
Oh, no, we're not on the record for this, but I'll give you the information. It's 2022 CR 2436, and it's Orlando Andino, Andino.
Okay, Judge, thank you.
Sure. So where are we on this case?
Your Honor, just an update. So it seems like there is an agreement that's been not filed, but I guess agreed to by the parties. But I'm still waiting on the Padilla letter from the immigration attorney. I've been in contact with Ms. Teresa Padilla Coles, who's been the immigration attorney, but she has not given me the Padilla letter.
Okay.
So I'm just waiting on that judge to go forward.
Are you okay with me texting her and saying, where's the,
Yes, Judge, I had emailed her yesterday on another defendant, asking if she can pick the defendant that you want to do for child. She said yes, but she said she was working on 2 other ones, so she was still working.
okay.
Yeah. I don't know if that helped or what.
All right. Can you mute us for one moment?
Judge has been muted. So this defendant walks up to the bar, is like, "Hey, Judge, how you doing?" Smiles. She's like, "Great. You're here for the interpreter?" And then he gets this look in his eyes. He's like, "Yeah, I don't speak English. I just used all the words I know. Hey, Judge, how are you doing?" Man, those Mrs. R.A. bought these. She said she went to some store and they just said all the Christmas cookies were on sale. They were 50% off. And I'm looking at this and it says Reese's dipped animal crackers. There's nothing on here that says Christmas. Anything there? It's like a lions and bears and tigers and chocolate. You know, Reese's delicious peanut butter goodness. And I'm going to have to call her bluff on this one. This was not a Christmas special. This was not a Christmas special. I'm not complaining because I'm eating them. So I mean I can't get too mad about this because I'm benefiting from her fib, if it was a fib. But she also bought herself some other chocolate covered pretzels, which were in a Christmas box. So that was good. Yeah, but they're just on clearance. When does Reese's ever go on clearance? I mean, honestly, have you ever seen Reese's on sale? No, everybody knows it's better than drugs, and you pay full price for it. It's just, why would they ever discount something from Reese's? It's delicious. Nosy Rosie says, "All right, stop promoting stuff. I can't find all this stuff you show us. I can give you Amazon links to it, but I don't even know what store she went to get that." What does the bag look like? The bag is huge. It's let's see, net weight 24 ounces. That's the same size as the pickle jar, so it must be a single serving size. Nope, they say 22 servings in here. Well, that's a misprint. There's only one, and I'm almost done with it. But it's a big, huge bag. I mean, it's Reese's dipped animal crackers, not sponsored, but I endorse them. Reese's has not made a bad product yet. All right, let's see. 22 servings in one sitting. It's part of my my New Year's diet. Some people they do. I have I ate a full salad before I started these, so I made sure I had a good good basis for a little extra consumption. And I didn't even have salad dressing on my salad. It was just lettuce, and honestly, I think it was even iceberg lettuce. So that's just like roughage. Lettuce. I had some mozzarella cheese and some bacon. That was my salad. Those three things. So this almost counts as like a topping on the salad, and it's still overall it's still healthy. Okay, the case we're watching in Thurston County, the jury has deliberated for over half an hour here. I think we're going to have a minimum of an hour because the judge said something about them coming back at a little later in the day. I think she basically gave him lunch. She's not going to do anything before that. So we've got at least another half hour. Can the bag sealing thing even survive 22 openings and closings? Oh, they put these bags on. They've got the little built-in resealable opening, which nobody uses because once you open it, you eat everything inside and then you throw it away. RA is working on that insurance payout for Mrs. RA. But at least we've got a plan. I am Dave. We've got a plan. PNW, appreciate you endorsing my math. Checks out. Troy, I do what I can, where I can, what I can.
All right. And who is the person? Is it Arturo Lopez who needs the interpreter?
It's Mr.
Arroyo.
Arroyo.
I swear we heard Arturo Lopez. I thought we've seen his case before.
Okay.
All right, Arojo. I'm sorry, Aurora. I'm sorry, I can't roll my R's.
Arroyo.
You all know what I mean. I'm working on rolling my R's.
I have two witnesses in the back. Should I call them up now?
Yes.
Got witnesses. These are probably going to be character witnesses supporting him and maybe being there to be able to support him if he gets out on gets released. Fruit gum stripe has been discontinued. I'm not too hurt about that because that was nasty to begin with. I'd never found any fruit stripe gum that was fresh. It was always like someone had like torn the package or something, and the nitrogen, whatever they put in there to keep it soft and yummy, was gone, and they were always just like they were brittle and crunchy. It's like 1-year-old Halloween candy. That stripe gum. It was not Wrigley's. It was not good. Arroyo. I foresee.
All right, are you all ready?
Crash.
Is this the one that needs immigration? That needs an interpreter?
Yes.
All right, yes.
He doesn't need an interpreter. His mother does.
Oh, the witnesses do. Okay.
One witness.
All right, court is calling 2019 CR 13237, State of Texas versus Carlos Ricardo Arrojo. Could I have parties announced for the record for the state? Defense.
Howdy, Joe Stenberg, representing the defendant.
And are you Carlos Arrojo?
Yes, sir.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Carlos Ricardo Arrojo who was placed on deferred adjudication in 2019 CR 13237 for the offense of unauthorized use of a vehicle on May 6, 2020 for a period of 4 years? Is that you? All right, state.
Violated condition number 18 in Bear County, Texas. The defendant, Carlos Ricardo Arroyo, is then and there failed to report weekly to the supervision officer for the weeks of March 28th, April 1st, April 4th to the 8th, April 11th through April 15th, April 18th through the 22nd, April 25th through the 29th, May 2nd to the 6th, May 9th to the 13th, May 16th to the 20th, May 23rd to the 27th, May 30th to June 3rd, June 6th to June 10th, June 13th to June 17th, June 20th to June 24th, 2022, in violation of condition number 18.
How do you plead to that? True or not true?
Your Honor,
She needs to hear you.
Your Honor, the state waives all the violations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 18? That's okay. Court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, you still wish to plead true to violation of condition 18?
Yes.
Yes.
Court will find violation of condition number 18 true. Is there an agreement?
No, Your Honor, I think we're all both going to go over this before.
All right. Any witnesses?
I have two.
All right, if you'll call your first witness, and if you'll call the one that needs the interpreter first.
Okay. There you are. I don't have my glasses on. So now.
Thank you.
So failure to report for several months, and it sounds like it's supposed to be a weekly reporting, and there were multiple months.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Lo juro. I swear.
All right, you can lower your hand. We have an interpreter here. If the interpreter, if you could raise your right hand, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
Norma Nero.
All right, defense.
Howdy.
Howdy.
Your relationship to this gentleman, he's your son, right?
Sí. Yes.
And right now, as far as your history goes, you're taking care of your mama, correct?
Sí. Yes.
And you're familiar with the fact that I think it was 2020. Your son blew out his right knee, could not use his right knee.
Sí. Yes.
And he could not work for a while, is that correct?
Sí. Yes.
And then another time after that, that same knee gave out on him and he could not work again. Remember that one?
Sí. Yes.
These are very leading.
But other than that, since he's been on probation, he's been working, right?
Sí. Yes.
He's had different jobs, and like the one he lost because he hurt, that's when he hurt his knee.
Sí. Yes.
And then when the knee gave out on him again, he lost his job because he lost over a week worth of work.
Sí. Yes.
But since then, he's been working like almost 40 or 40 plus hours a week.
Sí. Yes.
And he hasn't gotten in any trouble with the law. Is that correct?
No se ha metido. No, he hasn't.
And y'all met by y'all, his kind of like wife. I say kind of like they live together like their husband and wife.
Kind of like a wife.
Yes.
And that was in December of 2021, is that correct?
Sí. Yes.
And they lived with you all for a while,
Sí. Yes.
but now they've got their own place.
Sí. Yes.
And is your son, well, tell the judge about your son briefly. Is he good character? Is he honest?
Pues mi hijo es una persona muy trabajadora, de muy buen corazón. Well, my son is a very hardworking man with good heart. Y pues yo lo siento porque él quebró provecho. And I am sorry that he violated his probation. Pero es muy trabajador y muy honesto. But he's a hardworking, very hardworking and very honest. Tiene muy buen corazón. And he has a very good heart.
And let's just take it up when he met his new, I call it gal pals, back in December of 2021. Does he drink alcohol?
No. No.
Does he do drugs?
No. No.
Okay. Pass the witness.
Does your son own a cell phone?
Su hijo tiene celular. Sí. Yes.
Has he owned a cell phone while he's been on probation?
This is the why didn't you call argument.
Yes.
So
Yes, his cell phone.
So he could have reported to probation.
Pero hubo un tiempo que no traía también teléfono. But there was a time also that he didn't have a phone.
But he was aware that he was on probation.
Sí. Yes.
So he could have still reported.
Pues sí, ¿qué le puedo decir? Well, what can I tell you? Yeah.
Nothing else with the state.
No further questions of this witness.
All right, thank you so much for coming in.
Looping in this.
Okay.
So are no more need for an interpreter?
Correct.
All right, thank you so much.
You're welcome.
Do you need me to sign anything?
No, Judge.
All right, thank you so much.
Thank you.
Good morning. Well,
Good
afternoon. Yeah. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Guadalupe Mendez? Yes.
Judge's feed is taking a dump here. Here we go.
21, I think that's when you first met Carlos, is that correct?
Yes.
And y'all pretty much been living together since then?
Yes.
And you are on SSI because of your learning disability, is that correct?
Yes.
But you know that there's between right and wrong,
Yes.
and you're going to tell the truth?
Yes.
With respect to Carlos, since you've known him since December of 2021, does he drink alcohol?
No, he does not.
Has he taken any illegal drugs?
No, he does not.
Now, with respect to his knee injury, it's called an ACL, he had to go to the hospital
Yes.
and he was off work for a while and got workers' compensation, and you brought me those papers, correct?
Correct.
SSI is Social Security.
And then he went back to work when he was allowed to go back to work.
Correct.
And he's pretty much worked 40 hours a week, except when his knee went out again, and I think it was 2022, 2023, I'm not real sure. But you remember when his knee went out the second time,
Correct.
and he was off work again.
Yes.
But that time, not too long, like a week or so.
Mm-hmm.
Mhm.
Correct. I'm sorry.
All right. And you brought me a bunch of papers, which I asked you to bring me. Are these true?
Yes,
And that shows not all of his pay, but in the hours that he worked, over 40 hours a week, different places of employment.
correct.
And also he had some appointments he had to make. Did he make those appointments?
Yes, he did.
And that was in 2023, medical appointments for his knee and medical clinic work status. He had finally got approved to go back to work, right?
Yes,
And the last one of these papers is residential lease agreement, which I'll sign on October 1st of 2023. All you could find was the first page. Is that correct?
correct.
It's 5 pages. We offer those in evidence to show that he's been working.
No objection, proceed.
All right, that's just for the courts to review, or
Yeah.
are you offering those into
Can you
evidence?
just look at them?
You can just look at them, Judge. Does anybody know where in Minnesota that barricaded suspect is, as far as counties? Does that happen to be in Dakota County or Hairpin County or
Okay.
Rice, Scott? Just seeing
Will you tell
Ramsey.
Judge Boyd a little bit about Carlos?
Yes. Well, Carlos is a good person now. I mean, with the mistakes that he did, I mean, he was by himself. So, and I'm here to guide him to the right path, make sure he does what he's supposed to. So he won't be back here again.
And you know, he's without a doubt supposed to report to probation. When he's told to report, he's supposed to report.
Yes.
I got the records back, and I'll give them back to you. Thank you very much for bringing them. Anything else you want the judge to know about Carlos?
He's just a good man. He's a hardworking man. He comes home once he's out of work, and I just want to make sure that he's on a good path and not come back in here again.
And he hasn't picked up any criminal case and been arrested.
He hasn't got into trouble.
All right.
He's getting into trouble right now because he's not. He's not
Were you
reporting.
aware that he was on probation?
No, I wasn't.
So he never mentioned any of that to you?
No.
So would it surprise you because you guys got together in December of 2021?
Yes.
Would it surprise you that that's when he started missing appointments to take drug tests?
But on that time, I wasn't like, I was coming in and out of his life. I was staying with him, but I wasn't like living there for myself and everything at that time. But I wasn't.
So during this time, did he own a cell phone?
No, he didn't have a cell phone, and he would try to use mine. But again, like I didn't know he had a call for probation and stuff.
Nothing from the state judge.
All right.
Well, I have a feeling you're making call now, right?
Yes.
All right.
Yes. Now, well, make sure he goes back on what he's supposed to do, so he won't end up in here again.
Mrs. R.A. has my phone. I can't check anything.
All right, thank you so much for coming down.
Thank you.
We call Carlos.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You need to speak up.
Yes, ma'am.
You can lower your hand, state your name for the record.
Carlos Ricardo Arroyo.
All right, defense.
Carlos, you were, since you've been on probation, working pretty much full time. When I say pretty much, you did have twice when your right knee ACL gave out, you had to go have that taken care of. You're out for a while. But other than that, you've been working, right?
Yes, I have.
And the last time you lost a job is one of these temporary jobs that you gave the, as I understand, the work permit off excuse to the, whatever they call the people that hire you, but they
Yeah.
didn't give it to your employer.
Yes, I gave him why I was out and everything. I told him why exactly I couldn't walk for a whole week. I told him I went to my doctors. I got doctor's excuse. They still
said, we'll see later on. We can keep your call, but we're not too sure because you missed a whole week.
Okay, other than that, you've been working 44 plus hours a week, right?
Yes.
And like, since you met Loopy in December of 2021, have you had any alcohol?
No.
Have you had any illegal drugs?
No.
And why did you not report?
To be honest, I was just scared. I was young, I was stupid. You know, I didn't have what I have now. I didn't know what I could lose doing all this. Like, and I didn't think about the future, how it would affect me. And now I regret that decision. I was stupid. I was young. I could tell you. I wasn't thinking right as I am right now. Like I got a lot to lose right now. I got a lot.
Well, you understand that hopefully without a doubt now, you're supposed to report.
Yes, I do.
And if you cannot report in person, if you're supposed to report in person, you pick up the phone and call.
Yes.
But you must report. Do you understand that?
I understand it.
And if the judge, we're asking that she extend your probation. If she does do that, we're asking that she allow you to report, and you will report. Is that correct?
That's correct. I would do my best. Everything is to go to report and everything I should do. Get back on the right path. I wouldn't mess this up again. It's something that
And when you were stopped, you hadn't broken the law. They just read your driver's license, your automobile license plate popped up as a warrant.
That's correct.
And this is a badge that you wear at your current place of employment?
Yes.
And you basically the type of job that you're doing now for Toyota, but there's not Toyota, it's one of their subsidiaries that does the work for them, whatever you call it. What do you do?
I do the transmission for the trucks, for the hybrids, for the Toyotas. Pretty much all I do is just set up all the little parts into place for the transmission and then send it off to the next person just to finish it off. And that's pretty much it. That's all I do.
And if you understand, if you miss a part, transmission won't work.
Yes.
And you understand if you miss reporting, probation doesn't work.
I understand it.
You're asking the judge for forgiveness?
I'm asking her for a second chance and forgiveness. You know, I'm sorry for what I did when I was young. Right now, like I said, I'm grown and I wish I never had done that. What I did, it was stupid of me.
And pass the witness?
So were you aware that leading up to when you began to stop reporting when you were testing positive for drugs?
I was in a tight position. I was struggling with a lot of stuff back then.
So again, I'm asking for a yes or no. Were you aware that you were testing positive for drugs before you started failing to come in?
Yes.
Okay. And you haven't been submitted to drug testing in almost 2 years. Is that correct?
Only when I go to my job interviews, I do drug tests. That's it. But no, I haven't. In over 2 years, I haven't done drug tests.
So there's no way for the court to verify whether or not you have abstained from those drugs. Is that correct?
Yes.
And you would agree with me that the easiest thing that you could have done is pick up the phone and call probation.
Yes. But like I said, I was scared at the same time. Like, I didn't have the people that I had now in my life.
But at the same time, it's you who's on probation, not
That's
with
true.
other people. Is that correct?
That's true.
Nothing but to say.
And was it a matter of, I think you told me you were told by the probation officer you had to pay money?
I had to pay at least the patch and the monthly payment. If not, like they will revoke my probation and they'll send me off to wherever I was supposed to go off to.
And you didn't have the money?
I didn't have the money because I wasn't working at the time. I was struggling with money. Like I said, I'm sorry, I can't say nothing else than that. I was just struggling with the money, and that's why I was scared to go back to probation.
All right. Again, a pass.
Where were you supposed to be sent off to?
I'm not too sure, to be honest.
That's what I'm saying.
I'm sorry, I did not hear that last question.
Where were you supposed to be sent off to? Say.
Oh, get revoked. Adios.
Well, I mean, you're not the witness.
I know.
All right. So I have a couple of questions. How old are you?
I'm 28 already.
All right, so you're 28. So when you were placed on this probation, how old were you?
I want to say early 20s, like 22, 21.
All right, so why were you not reporting?
I didn't have the money to report anymore. I didn't have the job to do anything. My phone wasn't even on. I was struggling just to get a hold to my probation officer, John Barfield. I still remember his name.
No, because in this court, I always tell everybody, if you have an issue with probation and you feel like they're not addressing it, you can come to court. So why were you not reporting?
I didn't know how I could come and address to you or ask for help.
I say that all the time. I always tell people who are placed on probation, you're on probation. I want you to be successful at it. If there are some issues with probation, you can always come back to court and we're always here. Everybody can tell you we're always here.
I'm sorry, I said I was young. I was still there.
Probation, what are you recommending?
Your Honor, the recommendation would be for an extension for 2 years, extension to status, or revocation.
All right.
And I don't think you need status. Back then, that was written in 2022, Your Honor.
All right. And if you could do a trial court certification for me, please, because I don't have that in the file.
I just need to fill it out.
All right. If you all will fill that out.
Thank you.
And I'll fill in the name and I can fill in the cause number.
Okay.
What are you asking for?
For a reinstatement.
All right. Well, probation is saying that they will continue you, but you have to go on inpatient treatment.
What exactly is inpatient treatment?
That's where you stay in custody and you're transferred to a facility that will help address your drug issues.
I'll be willing to do that.
Okay.
You need to sign
Your
this
Honor,
and not a pre-part.
I would ask that before we make a firm decision on status, if we can do a TAC evaluation and see where he is.
I'm sorry. Sorry about that.
And state, what are you requesting?
I was just gonna ask for a year in the state jail, Your Honor.
And I'm not sure what to check because it's not appropriate.
Because I'm the person who checks.
Oh,
Defense attorneys are always checking the boxes on that as though defense attorneys are determining whether or not someone has a right to appeal. But that's me to make that determination. All right.
Yes, that's our verdict watch timer. We're approaching 1 hour in Thurston County. Still no verdict yet. As soon as we get a verdict and wrap up
Mr.
Thurston,
Rojo,
we're going to go over to the treehouse.
I don't think you're a good candidate to be continued on probation. I know probation is saying revocation or eat a SATF. Nobody knows where you've been. I don't know why it is that sometimes people think that being on probation, you can still do what you want to do. Have you completed anything on probation?
I completed the classes.
What classes?
The ones that you had set me up on, the child classes.
So you completed parenting classes, which means you have children.
Do you have children?
Yes, one in Mexico.
Yes, he does. That's why I ordered parenting classes. And I had here, there was supposed to be restitution to Guadalupe San Miguel. And if you were to turn out positive on the patch, that you would go to SATF. So What is his criminal history?
That one case?
Just this?
Yes.
Is this the only thing you have? Nothing else? Right. All right. I can deny the motion of alternate mean conditions that include a TAP evaluation and follow the TAP recommendations, or either I can revoke you and I'll sentence you to 1 year in the Bexar County Jail under 1244. Which do you prefer?
Which one was the first one?
The first one is deny the motion, alternate mean conditions. You remain in the custody of the Sheriff's Department until the TAP evaluation. What is the time on the TAP evaluation? Yes. It'll be 1 to 2 weeks. TAP evaluation is basically a resume to see what your drug of choice is and if you have a drug issue. If they determine that inpatient treatment is right for you, you will not be released from custody. You will go straight to the inpatient treatment facility.
Take it down. I took that one down.
Okay, the treatment.
The treatment.
All right, the court will find 18 true, deny the motion, alternate mean conditions to include a TAP evaluation in custody and to follow all TAP recommendations.
Rejected juror. It's
Extend
in Chippewa
for 1
County.
year.
Haven't followed it. Brandy
And we
was.
can do a referral
Brandy
to
was covering
felony
it.
drug court. Is there anything else you need from the court to be successful?
No, just.
I've said it again. I'm gonna say it. I've said it before. I'm gonna say it again. If there's an issue with probation and you feel as though they're not addressing it, you can always come to the court. Do you understand?
Yes, and how would I be able to do that if I?
Oh, just walk in the door?
Should I could just come over here and talk to you in person?
Yes.
Okay.
That's exactly
Except if it's a holiday, we're closed and we're not here on Saturday and Sundays.
Okay.
Okay.
Yeah, thank you.
All right. Thank you.
Thank you very much, man.
You're welcome.
Have a great week.
All right. You too.
So I realize he's been working, trying hard, but
Yes,
basically
thank
2
you.
years of not reporting on parole, and finally they picked him up on a warrant. The judge had to do something.
All right. Shannon. Yes. Are you all ready on Mr. Wilson?
We are, yes.
Okay. Oh, okay.
Still no verdict in Thurston County. We'll jump as soon as there's a verdict. We're gonna jump out wherever it is. Oh, he dressed
All
appropriate
right.
for court.
So state on this one, probation says they don't have any, and it's probation. Is this to remove GPS or tracking? State, do you have any objections to the removal of GPS on Mr. Wilson?
No, Judge, I know we put this one, just so you're aware, and I know you remember from last time, but he's still pending a DWI. Second, I don't, that's not his attorney's fault. I asked the misdemeanor prosecutors to plead that out when they can. They're still waiting on the labs from the DPS lab on that, so just wanted to make the court aware that that is still out there. But I don't have an objection.
Okay. All right. Is there anything else? All right. Thank you.
Thank you, Your Honor.
Thank you, too. You're welcome. Who's here on Arturo Lopez? Thank you. Oh, and Mr. Locke?
Sure.
They've been reaching out to get proof of your client's ignition interlock. And so my understanding, they called you?
They called me?
Mm-hmm.
Okay. I'll make sure that he gets that over to them.
Okay.
Thank you, Your Honor.
All right, court is calling 2023 CR 8286, State of Texas versus Arturo Lopez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Anthony Cantrell for the defendant.
All right, on Arturo Lopez, I don't have the steps. That's okay.
Oh,
No problem.
putting them out.
No problem. And are you Mr. Lopez?
Yes.
Counsel, have you received all the discovery and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Lopez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
All right. Did you understand you're charged with failure to stop and render aid in a moving vehicle? This is one of those hybrid cases. So the range of punishment is not more than 5 years in the prison and a fine not to exceed $5,000. Did you understand? All right. You're going to need to speak up.
Yes, Your Honor.
Right. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. State recommends community supervision. There's to be restitution, if any, to Riley, R-I-L-E-Y, Cooper, Tarnow, T-A-R-N-O-W, the VIP live panel, DWI intervention, ignition interlock for half the term. Did you understand that to be the plea?
Yes.
Defense?
It is, Your Honor, and he has paid restitution.
All right, state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There has not.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 8 years, TAP evaluation, 200 hours community service restitution, and no contact with Riley Cooper Tarnow. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. No objections.
Mr. Lopez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence from witnesses' statements, but most importantly, there'll be no live testimony. Did you understand?
Skipping quite badly.
Court will defendant has knowingly and voluntarily waived and consented to stipulation of test.
Yeah, that's a bad copy. And review the same. She's reviewing the same. That's what she's doing. While she reviews, we're still refreshing. We've been deliberating for over an hour now. 69 minutes to be exact. Let's see, 3. There we go. 69 minutes and 51 seconds. 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 69 of deliberation, waiting for the Thurston jury to decide if a 16-year-old is guilty of reckless driving. They just went live right now as this very moment. So here we go.
That's my fault.
I'm gonna play the music because I think. Well, first let me stop this one. Hang on.
So I just wanted to give the jurors a break for lunch, and I was going to give them a recess instruction. I probably didn't need y'all here, but I just didn't want to do without you. So we'll bring the jurors in, and I'll tell them that.
Play the music. She's giving them lunch. We have the under the sea green filter on the courtroom. Not sure why that's happening, but I was about to play the music. I was scanning frantically for this button, but not so. We're early. Hey, Mrs. Aria, welcome back. Get any good phone calls while we're gone?
Thanks. Have a seat. You can have a seat. Thanks. All right. Thanks, folks. Can we see you? I just wanted to be able to give you all a lunch break, a little into the usual lunch hour, but I don't want you to go without that. So we'll take about an hour and give you a lunch break. So we'll give you a lunch break away from the courthouse and then reconvene. So in this lunch break, we're still in session. We're just a recess. And it means that you're still under all my orders. So I will nag on you again. Do not talk to each other about this. The only time you're to discuss this case is when the entire jury is present in the jury room together. And that's when you discuss the case. At lunch, you don't talk about the case. You don't do any research. You don't look up anything. You don't look up any people. You don't look up any definitions, no law. You certainly don't go to the place where this is alleged to have occurred. If you happen to travel through there to get home or to go to lunch, you give it no more attention than you would have given it on Monday before you got picked for a jury. And of course, all, family, friends, coworkers, all of that. Can't talk about it, tell you all about it later under court order. Be really careful with your internet usage and communications. Don't tell them, yeah, I'm still deliberating in a jury, because then all of a sudden, very innocently, they'll send you all this information about this that isn't the evidence, that isn't the law, and we've got to start all over again. So just keep aware of that. Go ahead and buy some shoes or something, but just try and keep away from any issues and don't do any research. Don't allow anyone else to give you information about the case. Try and keep yourself away from overhearing. And so that's why I'm going to ask that you just leave the building altogether for lunch and come back as you did through that outside entrance to the jury room, and don't come into the courtroom unless Ms. Garza or I are bringing you in. And so if you do overhear any information about this case or the people, if someone tries to give you information about the case or people, anything about this, don't discuss it among yourselves. Tell Ms. Garza, I'll figure out what to do with the lawyers. All right. All right. So let's take a lunch break. We'll see you back. Oh, you have a question?
Your Honor, thank you for the lunch break. We'll back to Simon.
Oh, all right. Well, let me have you go back. I'm sorry. I was worried because it was 12:30. I didn't want you to go hungry. Well, if I put you back in and you decide how long you need, and just let us know. If you still need lunch, let me know.
And that's okay too. I mean, if you want to watch it for it, but we were literally about to.
Well, how about I have you go back in the jury room, discuss everything.
Yes, ma'am.
And Ms. That's fine. And Ms. Garza will tell me what you want to do. And we'll just take a recess and you let us know when you want us again.
Okay, so lunch just got canceled.
Okay.
Like, Your Honor, we already ate and we're just finishing up some paperwork. Is it okay if we just continue to deliberate through lunch? Play the music.
Okay, well, we're in recess until we know more.
Your Honor, the state would request that after the verdict's completed, that the court inform the jury of Miss Mann's status, as well as request that if they would be willing to stick around and give her feedback, that would be appreciated.
Okay, so that's what's going to happen. So now we were about to take a lunch break, and then no. So lunch just got canceled. Jury's like, we're about done, Your Honor. We're minutes away. We don't want to wait another hour to come back and continue deliberations. So no lunch. Welcome to the Broken Baker. Good to have you here, my friend. Where are you at? Let me find. Where are you at? There you are. Hey, y'all. Hello. Welcome. Great to have you here visiting. I would say take a seat, but we've got those reserved just for members. Good to have you here. Let me know if we can answer any questions or anything. Broken Baker, also a great YouTube channel in the LawTube world. So if you're looking for additional content, highly recommend that channel as well. All right, we have more of nothing is what we're waiting for, really. See, that one just stopped. Let's see what feed did I just jump to here? Getting Salty podcast. I've never seen that one. How did I find out? I'm not sure what that is. I'm not sure if I want to know. All right. While we are here waiting, we're going to go back to Judge Boyd's courtroom briefly. As soon as we have a verdict, we're going to start picking up on the Treehouse trial. Excuse me. You're welcome, Broken Baker. Appreciate you being here. We're going to go to the Treehouse trial, and we're going to pick up. We're going to play catch up, which means we're going to be listening probably at 1.25 speed throughout this afternoon and this evening, and then we're going to because they're already over for the day, so we're going to listen to this afternoon and get caught up, and then be caught up for tomorrow. We're going to start it. Hold your horses, guys. Hold your horses. I just know if we start the Treehouse trial now, what's going to happen is they're going to come back with a verdict in Thurston County, and we're going to have to interrupt the opening statements to get the verdict, and people are going to be confused. Or if we're watching the Treehouse trial, everyone's like, "What? Did I miss the verdict in Thurston?" It's just going to be a mess if we go right now. So just let's be patient. We will catch up. We will get it all. It's going to be great. All right. Nothing there. Okay, so I'll keep refreshing here. You guys let me know as well. Treehouse trial. Laura, you, me, and all the jurors, this is new to all of us. We're very close to a verdict, I think, Eliza. The jury basically just said, Judge, we don't want to go to lunch. Can you just send us back to the room for a few more minutes? I think we're about done. So if they can all come to agreement, it does have to be unanimous. We've got 6 people back there deliberating. Just one charge. No lesser includeds that I saw. No lesser includeds. Don't put the Treehouse before the Prius. We won't. Treehouse is going to be a lot of fun. I've heard some great words about it. I have not looked into it at all. We're going to listen to it together and learn together. We'll get caught up very quickly. It's got a pro se defendant. Thurston is live right now. What? Nope. I'm looking at Thurston. They're not live right now. Talia, I think you're delayed a little bit. They were live 3 minutes ago, but not now. Did the ex-lawyer make the jury? No, he did not. He was He was number 6 on the panel, and he got eliminated in a strike from the defense. They did not want him. Okay, everyone's saying Thurston is live. You're District 4? I think you guys are a little behind on the feed. And if you are, you'll never know, because then I'll be like jumping over to the feed right now on your feed where you're watching. Important on moments like this, if you're trying to give us an update, make sure you all are in the most current moment. So make sure the live button on YouTube is lit on my feed, so you're up to date with what's happened. You might be 45 minutes in the past and then be watching somewhere else and say, "Oh, it's live, it's happening." Nope. Why is everyone's... Okay, now I finally got live. Here we go. Just 1 second. Why did it just do this now? Oh, we need 3.
Stated presumably by our presiding juror today. So what I'm going to do next, and you can have a seat, and what I'm going to do next here is something called polling the jury. And
Whoa.
It's 2 questions to each one of you.
Okay, so I just told you incorrectly. We're going to wait for just a second. They already read it. Hang on. Don't spoil it. All right. Thurston County drivers, buckle up. Strap into your seats, because we're about to find out what the jury thinks about your driving. Specifically, one 16-year-old who is charged with reckless driving in the town of Thurston in his mother's Prius, 2008 Prius. Jury's been deliberating for how long? Well, about 79 minutes, 78 minutes. They're back now. We have a verdict. The judge is about to read this to the court. I realize we're late. Sorry, it was live. You guys were right. I was wrong. We have a verdict in the case. Okay, we're stalling so we can hear the music. Ready for the beat drop? Yeah, there it is, right there. Oh, that was good. That was a good one. All right, we missed it. We missed it. The case is over. We're going to go back and catch it all. All right, let's all join court here and listen. I'm not sure why we're doing the under the sea version of the courtroom camera. The white box is all off, but we'll listen to the judge here. All right, jury's coming in. Don't spoil it. Don't spoil it, guys. Spoilers will be banned for 5 minutes in chat.
Rise for the jury. And feel free to be seated, thanks.
The jury literally was
Seated,
like
please.
almost done with the paperwork.
So, one person, maybe juror one. Okay. So, have you reached a verdict?
Yes.
All right. I'm going to have Ms. Garza collect that, and I'll read that out. And
Here we go. No spoilers,
all right.
guys.
So, Mr. Stillwell, Mr. Wakeman, why don't we rise to this verdict? So, what I have here is State of Washington versus Russell Thomas James Wakeman. The jury find the defendant guilty of the crime of reckless driving as charged in count 1, stated presumably by our presiding juror today. So what I'm going to do next, and you can have a seat, and what I'm going to do next here is something called polling the jury. And it's 2 questions to each one of you. It's a yes or no. And the first question will be, is this your verdict? And the second question is this the verdict of your jury? And so those are the 2 questions I'll ask. And so juror 1 or 4-person, is this your verdict?
Yes.
Is this the verdict of your jury?
Yes.
Okay. And juror 2, is this your verdict? Yes. Is this the verdict of your jury? And juror 3, is this your verdict? Yes. And the juror of your verdict of your jury? Yes. Okay. And juror 4, is this your verdict? Yes. And the verdict of this jury? Yes. Okay. And juror 5, is this your verdict? Yes. And the verdict of this jury? And finally, juror 6, is this your verdict?
Yes.
And the verdict of this jury?
Yeah.
Okay. So I'll accept this verdict, and I thank you on behalf of the district court here for all your hard work and serving your civic duty as jurors. You're now released from all of my orders. You can talk about it in any way, shape, or form. You can research anything you want or not. It's really up to you. And you've served your service, so you don't have to call back. If you need anything from the court as to where you've been for work or whatever, Ms. Garza, do they get that from you or from jury? Okay, Ms. Garza can make sure you've got whatever you need if anybody needs anything. But we've got a couple of new lawyers here. Ms. Mann is still in law school. Mr. Stillwell, not a whole lot of years of experience, but we've been working together a long time. But they often welcome if you want to. You don't have to. You can be on your way. But if you want to, just stay behind in the jury room. They're happy to hear from you. If not, again, you're not obligated. You can be on your way. But if you want to, just stay in the jury room. And Ms. Garza's going to come on in and make sure you have everything you need. And then again, thank you for your service. All right, so you're excused.
Jury's.
Remember to call for ultimate juror, right? Okay, great.
The jury's going to be excused. I'm not sure if they're going to stick around. Interesting. I'd love to talk to them because I think we collectively saw this a little bit differently. Not that this kid hadn't done anything wrong, but it.
9 o'clock?
I think that it wasn't proven.
All right, folks, please be seated. So, is the state ready to go to sentencing?
We are.
And Mr. Stillwell?
Yes, Your Honor.
Okay. All right, so Mr. Wakeman, you've now been found guilty of this reckless driving, and my computer. And so we're going to move on to sentencing, and I'll hear from the lawyers for the state. I'll hear from Mr. Stillwell on your behalf, and as well hear from you if there's anything you'd like to say on the matter. All right. So let me just get my documents up here to help me. So Ms. Mann is the sentencing.
Your Honor, state would request 30 days of electronic home monitoring as well as a defensive driving class and the rest of the time suspended for 24 months.
The defensive driving class, just
and notification of the DOL as well, Your Honor.
Okay. Folks, have a seat. All right, so you're asking, again, that the court impose a 30-day electronic home monitoring sentence for this. Defensive driving class, like a 1 8-hour program kind of thing, or?
Yes, Your Honor.
Okay. Obviously, on this conviction, the Department of Licensing will be informed. That's the obligation of the court, and there will be at least a 30-day license suspension that the court doesn't have control over. That's up to the Department of Licensing. And then, Ms. Mann, on behalf of the state, you're asking how long of a probationary period?
24 months, Your Honor.
Maybe you can tell me why you're asking for this recommendation. Is there some other criminal history that I am unapprised of?
24 months
because of the defendant's non-licensed status, Your Honor. We believe that factors in.
Okay. Is that this is, I don't see any criminal history. Is that correct?
Correct, Your Honor.
Okay. Let me just...
She's trying to go easy on him, and she's like, why are you throwing 24 months probation at him when the maximum sentence was only a year in jail? This is first criminal conviction. If this ever happens to you, you'll know you're not up to live. You're way delayed on the live stream.
Okay, so no criminal history in this state, no criminal history in any other state. Correct?
Yes, Your Honor.
Okay. And
so she's disregarding
in that 24 months, then of course you're asking that this time be served a defensive driving class, not violate the law, not drive without license and insurance. And Mr. Wakeman is presently licensed, but will lose that privilege for at least 30 days once this conviction is reported. That's what I'm seeing from the Department of Licensing reporting now.
That sounds right, Your Honor. We might just check the exact dates.
And obviously, I'm just looking today.
Your Honor, there are licensing consequences that are different for people under the age of 18. That's what I'm checking.
Yes, there are. Thank you.
I don't remember. So that's why the state's non-committal on the 30-day. I just don't remember offhand.
It'll be at least 30 days.
I would agree with that. Yes.
Let me look into that.
They'll get to speak. His lawyer will speak in defense before the judge before she makes her determination, which will come here in just a minute. This does seem harsh. It seems harsh, and I realize had this situation been a little bit different, somebody could have been very, very easily injured or killed, but that didn't happen, right? And how many of us have, in our teen years, did something really stupid, and thankfully there were no major consequences to it, right? Pretty much everyone could raise our hands to that, and this kid just happened. The time he did it, it was within the view, not within the camera view, but within the view of a police officer, and so this seems a little tough. I wouldn't say this is malicious prosecution.
Well, I don't know if you know off the top of your head, it would be a different.
No, Your Honor, not specifically. My understanding is that it may be a year rather than the 30 days, but I don't have that citation, and I'm not certain. But my understanding is also that it is longer for someone.
We have under 4620. I'm thinking well.
So now he's losing his license for a
Really
year.
adds to the Department of Licensing, not a plea where I have to worry about director consequences, but at the very least, 30 days, they would, and like I say, the court doesn't have, there it is, the court doesn't have the ability to change Department of Licensing actions in that way, but
he may have an option to appeal based on ineffective counsel, because counsel had a duty to object to, to things that they didn't object to. And I think with the recording that exists out there of the prosecution admitting that there was this potential mistrial, that they're just going to be quiet about and hope they don't catch, hope defense doesn't catch. I think he's got an option to appeal. That will cost some money. But I think that's there. Of course, somebody have to let him know, because this feed's going to disappear very quickly.
The court on sentencing.
Your Honor, given Mr. Wakeman's age and lack of criminal history and the nature of the charge here, defense is asking that the court defer the sentence under RCW 366.067, which authorizes the court to defer a sentence after a conviction. In this case, Your Honor, Mr. Wakeman is 16 without a criminal record. To Your Honor's perhaps comments earlier, now that we're at sentencing, I feel it's okay to speak to. There was some pretrial negotiations that simply the parties didn't come to an agreement, but there was attempts to resolve this pretrial, including involvement of defensive driving classes. So Mr. Wakeman, in those efforts, was willing to step up and take those classes. And so this wasn't necessarily a case of sort of negotiations being ignored. There were attempts, but they were unsuccessful. And so we went to trial. And in light of that, I think it speaks to the fact that he was willing to take some affirmative steps after the case was charged. At this point, because his license may be suspended for at least 30, if not more time than that, I would argue that defensive driving class not be a requirement, in that I'm not sure if he would be able to with that, his license being suspended. And I'd also point out that having gone through this experience for Mr. Wakeman as a young person is a pretty intense experience that I think has brought home that the importance of good driving and safe driving. Mr. Wakeman also lives in this neighborhood, lives and works in this neighborhood where this took place. This is his home. He understands the people, he knows the people who lives there. It's his home too. And so I think the fact that he has been brought to trial on his driving and has now been convicted of a crime, I think he understands at this point, Your Honor. And I think given all of that, and given his willingness originally to do a defensive driving class, I hope he may still take advantage of that. But given his license status moving forward now, I think that might be difficult. But I think that the context surrounding this case and Mr. Wakeman warrants in this case a deferred sentence. And I'd ask for that deferred sentence to be perhaps 6 months, conditions of no new law violations. And if the court wants to, in lieu of an affirmative regarding defensive driving, include some around, no driving without a valid license and insurance, which I know tends to be standard. And in his case, with that revocation would mean no driving, and other traffic infraction relating conditions I think would be appropriate. But I would ask for a deferred sentence of 6 months, no new law violations, no traffic infractions, including driving without a license, a valid license. And then if he successfully completes those, for this to be dismissed pursuant to the statute.
And I know folks have been here in attendance. I don't know if anyone has anything they'd like to say before I hear from Mr.
I think his
Wakeman.
mom's here.
Well, I know Mr. Wakeman's mother is present.
Yeah.
You're welcome to say.
I'm just wondering if there's anything you wanted to say at sentencing. You don't have to, but I know that folks have been here throughout, so I like to give that opportunity for the family. You don't have to, but if you want to, you can. If you do, I'm going to need you up right there at the table so we can capture you on that recording device.
Good move. Good move.
No, wait, stand. There's a box. There's a box on the computer. Yep, this is a difficult time. We'll get you a box of Kleenex and you'll do what you can do. I understand. If you feel more comfortable sitting, you can do that too. I don't mean to put you through anything. I just want to give you that
It
opportunity.
happens.
I know. So this is your son. So is this your son?
This is my son, Russell Wakeman. I'm his only parent. And he's a good kid. He has 2 jobs. He helps me take care of his 3 biological younger siblings and his, we call her our borrowed kid who lives with us full time. And he's responsible. And I know that he may not have made the best choices that day. But we all make mistakes. And I think that it's a matter of the repetitive history when those mistakes are made multiple times. But seeing how I've been his mom his whole life, Russell learns from his mistakes. And I just want you all to know that he's a good kid.
Thank you. So, Mr. Wakeman or Russell, anything you want to say about all this? What do you think I should do or not do?
I'm not really sure. I mean, it's your decision, but I don't know. It would be really helpful for me if I at least didn't get I don't know if I could still at least be able to drive if it's possible, just so I can do what I have to do. But I mean, it's
Well, tell me about your life. What's your day-to-day life? You're in school still?
yeah, I go to school. I have the 2 jobs, you know. I work at a mechanic shop and at the gym that my mom owns in Rainier. I drive and pick up my siblings from school events because she works full time. I don't know. That's pretty much all I use that for.
So you're the oldest?
Yeah, I'm the oldest.
Okay, and by how much?
Charlotte's 13. I'm the oldest by 14. I'm the oldest by a year. Sorry, there's a couple of them. Yeah, I'm the oldest. The youngest is 10, 11.
So your mom counts on you to cart them around?
Yeah.
All right. Were your passenger that day, was that one of your siblings?
It was.
Your friend? Okay. All right. Anything else?
No, that's it. That's all I have to say.
And you're 16 still?
Yep, I turned
Right.
16 in August.
Okay. How long have you been driving then?
Since September.
So it was
he just got his
since
license.
I've had like my permit?
Yeah, how long have you been getting instruction on how to drive and been able to be?
I've I've known how to drive for a long time. I grew up around farms, so I've been driving tractors and other things for a while.
Part of that. And then you're working in a mechanic shop. So
Yes.
do they need you to drive vehicles that you've worked on?
No, I don't have to. No, I just, yeah.
Okay, you just work on them.
Yeah, I clean the shop and stuff.
Okay,
Whatever.
or you clean the shop. Maybe
help
not
around,
working.
yeah.
Okay. And learning that skill or?
Yeah, I'm trying to go down that path. I want to be a technician.
Right. And you've got another couple of years of school.
Yeah, 2 more.
So you're a sophomore.
Yes.
The ink was still wet on his driver's license when
All
this
right.
happened.
So, and let's talk about a defensive driving school. I'm now kind of turning to the attorneys. Is this a multi-day course that you're thinking? Is it a 8-hour program? There's several levels. We talked about
The introductory one, Your Honor, which I think is just, I might have the numbers backwards, but defensive driving 1, which I think is the 8-hour class.
Okay, so we know what we're talking about. And that's supplied, I think, supplied by Department of Licensing and by other private companies.
Both, Your Honor. They have a plethora of them. I think the last time I looked on Google search, there was like 30 or 40 that popped up in the greater Thurston County area.
Was the thought between the parties that be kind of an online course or that be an in-person kind of thing with an instructor?
The state has no objection to online. We want him to be informed. He's a 16-year-old kid that was operating a motor vehicle without a license and driving in the manner in which he was found guilty of. We want him to have information and knowledge. We want the advantage of those defensive driving courses is they articulate some of the dangers posed by bad driving and the consequences of those dangers. Certain situations, the state's asked for like DUI victim impact panels in non-DUI cases because of the information they contain, not because we think it's alcohol related. I don't think that would rise. His driving doesn't necessarily rise to the necessity for that level, which is why I think defensive driving 1 course articulates what the state's interest in giving him education and, functionally treatment, if you will, while at the same time is not overly burdensome to a high school student. The state's position, though, is that a deferred sentence is not appropriate for this defendant, regardless of his age. He either took the vehicle and operated without permission because he didn't have a license at the time of this incident, or he had permission to operate a vehicle without a license, both of which are concerning. So one or the other happened in that situation. A deferred sentence, I appreciate that he has responsibilities, but his license is going to be suspended and his responsibilities are tied to that license. The deferred sentence not appropriate at this time, Your Honor.
I would have wanted to hear all of that from the
September 12th license.
the prosecutor instead of
September
her.
16th. I see what you're saying now.
And Your Honor, if the no objection to a defensive driving class that he can do online or that's educational, that's not, my concern there was just if his license is suspended, not being able to participate in a class driving. But as far as if there are classes that are live courses or online education based where he's not necessarily in the car, I think that it would be appropriate as well. I'm still asking for a deferred sentence, but a condition of that being a defensive driving class, as long as he's not having to drive. I think that makes sense.
All right. Well, Mr. Wakeman, I'm not going to impose a 30-day jail sentence. I think that's far exceeding what I should do here. And why I think that is, I look at parity across. I've been sentencing people for 13 some years now as a judge, and I was a trial lawyer myself for decades before that. And, what we're trying to do here, and what I said earlier before trial, for one thing, too, I should make it clear, whatever pretrial negotiations were, why a person goes to trial, you have a right to go to trial. And that doesn't weigh in the court's decision as to what kind of sentence, That's her decision. I'm not going to chill that by saying, well, you went to trial, so I'm going to hammer you. That's not how it works. That may be a consideration in other situations, but here it's not. And so, and you have no criminal history. You haven't been driving very long. Sounds like you're really dependent upon by your family. And that in and of itself, I think is going to cause you, the ripple effect of behavior. That's going to weigh on your shoulders a long time now, because you're not going to be driving for a long time. And that's something I can't even have control over, is those ripple effects. But I am convinced to give you an opportunity to have this dismissed, a deferred sentence. And the reason being, because first and foremost, at this stage, we're working on rehabilitation. We're also working on punishment. And this is all going to work together. Punishment is occurring. You're not going to be driving for a long time. You have to do some work. You have the threat of, if you don't do what the court says, of having a jail sentence. But the deferred sentence will allow you, you're 16, there's a whole world ahead of you. I hope that your mom's right, that you've grabbed hold of this, that you're going to learn from this, you're going to make this better, and this is going to be a speed bump in a couple of years. I did that, it was dumb, but it's not going to ruin your life. Conviction, jobs, you'll lose opportunities for jobs. You go into school, go into vocational schools, they're going to look at that too and say, been convicted of anything. Then you may lose those opportunities. You may lose opportunities for school funding. You may lose opportunities for apartments and housing. All these things, is they always ask, have you been convicted? And you have to be honest. And so that follows you too. And it's not a direct consequence of having been found guilty, but I see that too. When you're 16, I think we can rehabilitate you. I think we can do this and give you that carrot to get this dismissed. And you're going to be the young man that you want to be, the young man that your mom sees you being, and you'll prove that now in your behavior. So you're working jobs, but I don't want to weigh you down with fines and fees, but that's part of what the state ledge says, is I should think about that as part of the punishment. So the deferred sentence means that I'm going to set a year and a half. And the reason I'm doing a year and a half is I think you are going to have a year license suspension from the Department of Licensing. Then we'll have another half a year. I have 2 years total, and I don't want to take it all, but probation for a year and a half, and then 6 months more there, you're good driving. Drive with a license, with proof of insurance, and all duel regulations, and of course safely. The defensive driving class, I'm going to give you a deadline to get that done. That's going to give you a lot of good information, a lot of education, help you be better, be a better and safer driver for you, for your siblings, for everybody else who's sharing the road with you. So one of those lessons we all have to learn is that it's not your road at all. It's all of ours. And we're counting on you to be safe and predictable and a good driver so that we're safe. And we have to be predictable and safe so that you're safe. We're sharing this. So that's what you got to get under your belt now. All right. So that introductory, we'll call it introductory defensive driving course. I would expect that. Stillwell, cost your client some money. So you say no later than April 1st. So you got some time to put that together, get some paychecks going. And
Your Honor, may I suggest April 30th? That would give the defendant 2 school breaks as well. That gives him both spring break and winter break to complete it.
That's a good thought. I will do that. So that makes some sense. So we want you to get this done. We want you to be successful. And so that's the fines and fees. So you're supported by your mom, housing, food, clothing, all that. You bring in some of your own, or does that go to the family household?
Do I bring in some of my own?
Your work at the mechanic shop, is that just for you, or does that also help support your family?
It's for me, but I mean, I pitch in whenever I can.
Okay. All right. I'm going to assess a much reduced probation fee because they're going to be looking at your record and see that you follow my orders. I don't expect that you're going to be visiting with a probation officer. I don't think that's necessary. A $60 probation fee. I have $5,000 that I can impose. I'm going to impose $103. So $60 probation fee, $43 court improvement fee. That's part of paying back the community, supporting probation, their work with you, make sure that you follow my orders. And that in the next year and a half needs to get paid in full. And I think that's real possible given the fact you got a job. I would like to see your mom or your family pay it. I want this to be you. I obviously don't know when you pay it, but I'd like you to think hard about that. Make sure you don't make it your mom's burden. So drive safely, don't drive unless you have a good license, proof insurance. Make sure that you and DOL get to know each other well so that you're certain when that license suspension goes into effect. All right. Let me focus on this and then I'll turn back to you for questions.
She's going to put this all together, but what I've heard is that she's going to make him take a introductory defensive driving course. Has to be done by the end of April. She is not going to order any jail time. I don't think they asked for jail time. I think she heard wrong. I think they asked for probation. Even the mentor attorney on the prosecutor's side was surprised when she's like, "You didn't ask for jail time, did you?" Heard that whisper. But she says there's going to be no jail time. The fees, she could go as high as $5,000 on this one, and instead she's going down to $103. The license suspension is handled by the driver's license division, and she has no control over that. But it looks like they are going to do a deferred situation where as long as he gets everything done in time, this can basically fall off. And I'm not sure if it gets rid of the conviction itself.
Mr. Wakeman, do you have any questions about what you have to do next? I know Mr. Stillwell is going to be helpful, but
Yeah.
you have questions.
I don't think so. So I do have the license restriction.
So the license suspension will go in effect. DOL, Department of Licensing, will send you a notice. They're going to send it to that address on Center Street. Is that 405 Center Street address?
Mm-hmm.
That's what they think. They'll send you notice when that goes into effect because we're going to report to them that you've been convicted of reckless driving. Then they will tell you when it goes into effect, how long. And it doesn't just end and you can drive. Then you have to go into Department of Licensing and say, okay, can I have my license back? And they'll talk to you about that. So,
Okay.
So that's why I say you're going to get to know them well, right? Any other questions?
I don't think so.
Okay, now Mr. Stillwell here, I know, does a good job in following up with his clients and helping them. Also, my probation department is there, has questions of board. So if anything comes to mind later, you can get a hold of probation and Mr. Stillwell.
Yeah, we don't do any docs in here. I do my very best to restrict.
Sentence, we'll give you a copy of that.
Even the information the court publicly releases,
Here,
I try not
I
to.
have one more thing I have to do called. Since you had a jury conviction and I sentenced you now, I'm giving you what they're called appeal rights, because you didn't plead guilty, so you still have the right to an appeal of the conviction as well as my sentence. And so some of this is going to sound a little foreign. That's also why Mr. Stillwell will probably talk to you more about it. You sign off on this judgment and sentence, and then okay. So, as I said, you have this right to appeal the conviction by the jury. Then you have the right to have a lawyer on that appeal. You're 16. You're not self-supporting. Thurston County Public Defense would be appointed to represent you if you decide to do that. Now, in order to do this appeal, you have to file with the court and the prosecutor's office a notice of appeal within 30 days of today. So 30 days from today, the 11th of February, no later. That may be a weekend, so for that. So if you don't file within 30 days, you lose the right to appeal. And that's gone. This conviction. So if you're found indigent or then you don't have to pay for an attorney. You don't have to pay for the costs of this recording. That is the record that would go up to the Superior Court to consider if I made some mistakes and things should be done differently. So if you don't file again in 30 days, you forever give up that right. And that's fine. You don't have to file an appeal, but you have to know that you can do that. And my clerk in the district court here, if you ask, we will give you a packet to do that. So other things, other forms, what we call post-conviction relief. We're now post-conviction. Other than this appeal of the conviction, such as a personal restraint petition, which would mean that you're in custody and you're not, a habeas corpus petition, a motion to vacate my judgment, a motion to, for a new trial, and a motion to arrest any judgment that I've made. That usually must be filed within 1 year from today, or you lose that right. But I'm sure Mr. Stillwell is going to go through some more with that because it's a lot of foreign, but we have the right to appeal. 30 days is the big number. You got to get it in to the court and the prosecutor within 30 days. So, anything else, Ms. Van?
No, Your Honor.
Mr. Stillwell, anything else?
No, Your Honor. Thank you.
Okay. All right. So we'll give you a judgment and sentence. Wish you good luck, and we're done for the day. We're adjourned.
All right.
You guys can go back.
Let's listen for a hot mic. Prosecutor got her first conviction in her first case. That's a win for her.
So they're waiting for you guys. And
Okay.
that's more welcome to go.
How much time?
You guys can get going. I'm going to talk to them.
So Ms. Garza, was this jail time on this person supposed to start yesterday? I'm not sure. I'll look it up.
So the defense is conferring with the defendant and family and friends.
And you feel free to go chat with them too if you'd like.
Thank you.
All right.
I wonder if they appeal. Because honestly, the
Thanks to the
sent-
family and friends for being here throughout this. It's really helpful. It's good to see you got a lot of support.
The sentence they received was probably the lightest sentence possible. I mean, you can't go much smaller than what she did. Okay, so it looks like we're done now. Oh yeah, it's over. So it froze. All right, so we're gonna get the Treehouse one lined up. I was wondering if I should stop and restart the stream because it's gonna be different. If this is Ayden, you're gonna have to behave. Let's hear. Hello. Come on, where's my phone? Come on, it needs to work. Why is my phone not working? Yeah. Hey, this is Scott. Hang on just 1 second. No.
When are we going to break for lunch, Judge?
I think I hung up on you. Sorry about it. Cynthia, give me a call back. All right, Law Talk with Mike is starting in the background. That's always good stuff. Love Law Talk with Mike. Let's get rid of this, though. We don't need that there. Okay, as we get set to start the other one, you can call from the UK. You could. I don't have a means for you guys to call for free right now. I realize WhatsApp and stuff, but my phone is tied up in other stuff that I do outside of YouTube. The WhatsApp account is linked to that, and it links in a funny way to my real number, which I don't want linked that way, so I don't give that out. see. It's swoop time. I need a good swoop. Is that a good swoop sound? I was waiting for see if Cynthia calls back or not, if it works. But Steven says, "Can I call just to block Ayden from calling?" No, you can't do that, Steven. It's funny. Ayden had some strong feelings here. I'm legit angry, and so it's better to chill. Hate seeing kids get wrapped into a black hole of the system. Okay, so this kid, here's what I'll say, Ayden. I think, first of all, he's got a support system. Even his friend, who was like his passenger, his co-pilot on this endeavor, where he's now been convicted of joyriding, or reckless driving in this case.
Call from Cynthia Beck.
Hey, Cynthia, this is RA. How are you doing?
Good. How are you doing?
I'm doing fabulous. What's on your mind?
Well, I during the jury thing, I got a text from the clerk's office.
Do you want this on the air or off the air?
It doesn't matter either way.
Okay.
It's fine.
Go ahead.
Anyway, I got a text from the clerk's office back, and I couldn't sit there and just not say anything, and so I complained, and she's like several other people texted and stuff, and that's why the judge took longer earlier at one of the other breaks she had, because she went back and watched the stream.
Ooh.
And she knew, that's why she did what she did to the prosecution just now with the sentence.
Wow.
So.
Wow.
Yeah.
I wonder if that's why also she took so much time explaining appeal options.
I think so, but yeah, the clerk wanted me to know that the judge was really glad that people had called in and texted and stuff, because she wouldn't have known otherwise. So,
man.
So anyway, I just wanted to let you know.
All right, Cynthia, thank you very much for the update.
All right, have a good day.
You too. Bye.
Okay, bye.
I was saying, as Cynthia called, the sentence is about as light as it can go. The judge clearly, from the very beginning of this case, did not want it to go this way. She didn't even want to have this move forward in a trial. She wanted them to reach some agreement that was lesser than what the state was charging. They didn't. She wasn't just saying, "Hey, just plead guilty." She wasn't in that boat. She was like, "Guys, this is a 16-year-old kid. Just looking it over, it seems like you're going for broke. You're going for everything you possibly can, and it's not." According to the judge's sort of the vibe I got was, it's not that bad. Yes, it's bad. Yes, we need to correct him. Yes, we need to rehabilitate somebody. We need to say, hey, this is not what we're about. But we believe that this young kid who literally just had his learner permit, he shouldn't have even been driving, but had his learner permit just a few days before he got his actual license, did a donut in his mom's car and was speeding. I don't know. Ran a red light. I'm not sure about that. I'm not convinced. It didn't happen on camera. What the officer testified to about his driving did not match up with what we heard described in the video, where he was swerving all over the place, and then the video starts and he's not. I'm like, really? I'm not sure if that's right, but anyway, the judge has kids. I think the judge has kids. All right, we're going to transition from this into another. Who was texting? Cynthia just called and said she had reached out to the court, and a couple people had told me that they reached out to the court and just said, "Hey, just heads up, there was something that happened there, and it didn't seem right." And so the Cynthia was saying that the judge went back and watched the stream with that hot mic incident with the prosecutors. I'd be curious if that happened in the presence of the prosecutor or outside the presence. But the prosecution, during a hot mic moment after they had arrested and the defense was ready to take over, the coach, the mentor, sort of was chiding the prosecutor, the girl who was prosecuting this, and saying, "Yeah, that was dangerous, possible mistrial." And she's like, "What'd I do? What could have been a mistrial?" And he walked her through it and said, "Yeah, you elicited testimony from this witness that there was a legal conclusion about his behavior, what was in his mind, his state of mind when he was doing this, and that's mistrial material." And he says, right now, our trial strategy is just like, don't mention it. Everyone pretend nothing happened. If they don't object, we're fine. We're good. And so it was a bad vibe. It may be right and legal and not a problem, but it was a bad vibe. It looked shady. And the judge, having already not been a fan of this, this prosecution, the tone was obnoxious. It was. And the whispering, oh my goodness, the whispering. It seemed dirty. It seemed dirty is what it felt. People felt dirty listening to it. Just like, oh, this is we're trying to get everything you can to stick on him, and we're doing things that aren't really right. The jury should not have heard what they heard. And the last thing in their mind before they went to deliberate was something that the jury should not have heard, as far as evidence goes. Anyway, good stuff. We'll have more stuff out of Thurston County. We've had some good cases. We've had some bad cases. But I will tell you the one thing we have had is always something interesting, always something eye-opening, sometimes something very entertaining. But never disappointed overall. So I'm thinking what happens in my mind. This kid with a great support system. His mom's behind him. He's a hard worker. He's apparently dependable. Learns from his mistakes. I think with as light as the sentence is, okay, he doesn't even have to report to a parole officer. With as light as the sentence is, it's almost impossible to fail in this parole setting, in this suspended sentence setting. He's going to accomplish his class. He's going to get his class done. The license will be revoked as long as he doesn't drive without a license. This thing could be dismissed and it'll be gone. Can you tell us about the treehouse? I can tell you all about a treehouse. A treehouse is where you have a tree and then you build a house in it, and that is all we know. Other than we're now going to go there. So let's.
Absolute requirement for that testimony. I've had a little research myself, and obviously the confrontation clause.
This is the very beginning.
And if the witness is, alive and well to the extent that they can testify in lieu of.
So we know nothing about this. This is Treehouse.
Method. I agree with you that the logistics of introducing documents and reviewing and the like is.
The gentleman with white sleeves is our defendant.
But it's challenging. So.
He is representing himself.
We address this once we get the medical condition.
Sounds fine, Your Honor.
Right, but
the only other
looks like we're headed in that direction.
Well, the only other issue I might address with that, if you might, is if the state decides to call her. While I'm making arrangements for the defense to call her, I'm not sure, whether they're going to make arrangements themselves if they decide to call her.
You got to speak up a little bit. You're not sure in the event that they called the witness in their case.
Okay. Well, I'm making arrangements so that she can appear via Zoom for the defense, right? Now, they still haven't decided whether they want to call her or not, but if they do decide to call her, I would assume that they're going to have to make their own arrangements.
Yes.
Okay, good.
Yeah. If the state decides that they're going to call Ms. Belmonte in their case in chief, I'm quite confident that they will use their resources, investigators, staff, whatever it is that's in their field of responsibility, and they'll take care of it.
Good.
I didn't get the sense, frankly, from Mr. Mansfield yesterday that it was likely that was going to happen, but if it is, then they got to take care of all the logistics.
Just trying to take care of all the bases, Your Honor.
And that's a good idea. So what else?
I did, Your Honor, I did just have a discussion with Mr. Mansfield. Mr. Valorado was telling me that normally it's customary, I guess, to tell the defense or tell the prosecution, either one, what witnesses you're probably going to call the next day, because some take longer prep than others. I was just wondering if we can make such an arrangement.
Well, it is true that in most cases that I've dealt with, professional courtesy extends to alerting one side and the other who's expected to be called as a witness on that particular day. It's not, an ironclad rule, but I put it in the category of professional courtesy. So hopefully that can exist in this particular case. From my vantage point, it seems like thus far there's been respectful dealings between the sides. State of any problem in letting the defendant know what your anticipated.
Judge, the state anticipates after opening the first witness will be calling Deputy Jenna Muller from the Monroe County Sheriff's Office. She was the first arriving officer in the city.
Do you have any others lined up for today?
Yes, Judge. After that, we anticipate calling Detective Marcus Del Valle from the Key West Police Department, and then I think the third witness lined up for today would be Mr. Roger Rowden.
Okay. All right. Well, that's pretty well today's lineup.
That sounds fine, Your Honor.
All right. And presumably you'll extend them the same courtesy
Of
when
course,
it's
of
your
course.
turn. So then, once the jurors get here, we go through preliminary instructions. There's a portion of one instruction where the defendant has the right to choose whether or not he or she wants a particular portion given. These are the preliminary instructions, and this one optional instruction at the defendant's request says, in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence from the exercise of a defendant's right to remain silent. A jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. So that can be given or not. That's the defendant's option. So
Obviously, I'm not going to stay silent, Your Honor.
well, that's not obvious to me, but you
speak.
That's fine. So can I take it then you do not want that paragraph?
No, that's
read?
fine. You don't have to read that.
All right. So is anybody invoking the rule of sequestration of witnesses? That's the next question. That we are. You are. Okay. So
he was saying no. He was shaking his head.
Rule, Mr. Tucker, but
A little, Your Honor. I wouldn't mind a little explanation from the court. I usually get educated.
okay. What that rule says is that witnesses, other than a victim, cannot be in the courtroom at any time except when they're testifying. So before they've testified and after they've testified, they have to stay out of the courtroom unless, the sides agree that that rule can be suspended for that particular person. Otherwise, they can't be sitting in here either before they've testified or after they've testified. Moreover, they are precluded from speaking to anyone about their testimony. Like if there's a waiting room with witnesses, it's prohibited from those witnesses to confer with each other. I think
that would make sense.
Yes, exactly. It's to prevent any kind of comparing testimony or discussing the experience. The only exception to that is that a witness may speak to the attorney, or in this case yourself, for either side, as long as that is done one witness at a time. So you can't have a huddle with the lawyer and 3 or 4 witnesses, but the lawyer, or as again I say, the pro se litigant, is entitled to speak to a witness. They're not covered by that rule. It is a serious rule. It can be enforced by contempt of court proceedings, whereby if a person were to violate said rule, they could be subject to being fined, being incarcerated, having their testimony stricken, any and all of the above.
Court's about to start. These are pre-trial
actions. If there's witnesses here, I'll bring them in and I'll instruct them about it. Other times, I just say, as I'm going to right now, it's the responsibility of the attorneys to let the witnesses know of the invocation of that rule and that they are bound thereby. So, any questions about that?
This one could be spicy. Could be.
All right. So,
could be interesting.
Then openings. Just remind everyone, opening statement is not evidence. It's not argument. It's basically, as I've heard it described, a roadmap as to what each side expects the evidence will show. So that's the basic focus of an opening statement. It's not testimonial. It's not evidence. What the attorneys say is not to be considered evidence. So we'll, if you've indicated that you, Mr. Tucker, want to make your opening after the state's opening.
Yes, sir.
Okay, that's fine. So, and then as I told one of the jurors yesterday, we will give them the opportunity to take notes. I'm not going to have jury questions. That's the court's option. I don't utilize that procedure. It's not mandatory. So they may take notes, and we'll presumably we have the notepads ready here.
Okay, we're going to pause for just a second while I get the feed. We're having just a little bit of clipping, and we're going to get rid of that clipping so it's a cleaner listen to. We always try to have the best audio we possibly can, and that is something I can fix. So give me just 1 second here. Okay, we're going to update that. Bring it over here. Put that on a different feed so it doesn't clip. Okay. Man, it's going slowly. What else is open that's taking up all my memory? Come on, guys. Give me just a minute. We're going to get this this feedback here. There we go. All right, so there's our defendant. We're just now starting the trial. We're going to have openings. The jury's going to be brought in. We'll have opening statements. Defendant representing himself and doing a respectful job. He's asked for the judge to explain some things to him, and as soon as he asked that, you saw the prosecutor sort of shaking his head. He's frustrated that he's got this. The judge is taking the time to walk him through these steps, and we might see more of that frustration.
Paul, can you put me through to Pam downstairs in investigations?
Great state of Florida. What are we going to do? We got hold music? I've got to turn off the hold music so I don't get a strike. This is nuts.
Yeah, who's this? Hey, is Pam there? How you doing? Yeah, Pam is actually in a meeting with Chrissy. I know, but I got to talk to her. Yeah, I got to talk to her. Okay.
Get her out of the meeting. We need Pam.
Yeah.
Joe. Okay. Kill the audio. Kill the audio. Okay. So that was a little bit of some audio, hot mic. But this is out of Florida. We're down almost, I think we're in southern Florida, down by the Keys. And this particular area, the treehouse they're talking about, this was, I'm not sure if it's an actual treehouse or if it was just like a club called the Treehouse, but it was sort of notorious for this was not a good part of town. Bad things happen here. Drugs being central, according to what we've heard so far. Let's see. 3 defendants first pled out, will testify. Second, life without parole, may testify. And the third is Mr. Tucker. Those are the defendants. I think the story is that we've got this this incident where it was possibly a drug or a robbery going on, and a neighbor shows up and gets stabbed and ends up dying. We're going to hear all sorts of interesting things happening. Colorful characters in here, probably plenty of them. It looks like a makeshift, not safe treehouse, says Jamie. We're going to switch while I fast forward and get caught up to where we need to be. Let's see. Where's my control? Quality's good. We're good there. That's all right. The speed is going to be 1.25 speed as we catch up. We're going to stop and talk a little bit about things as they happen because this is interesting. Skipping ahead, missing some moments. Boom. There we go. Okay. Where are we? Let's go back to camera 3, shall we? Right here. No treehouse in history has ever been safe. That's why they're awesome escapes for kids to build. Ivan, we had a neighbor when my wife and I first got married, a couple streets away, that had this massive tree. There were a couple massive trees, and they built a treehouse that sort of was bigger than the tree, and it was huge. And it was like, I think they had 4 or 5 stories in the treehouse, and it was junk. It was like mixed between scaffolding and scrap wood and everything else just everywhere.
Okay, good morning again.
The city ultimately made them tear it down.
I've been informed that the jurors, all 14 of them, are here and they're in the jury room. So at this particular point, let's bring them in, please.
Okay, we've got the audio boosted. We're also going to cut off the top end. We got a little bling on the ears. Looks cool. Are those reading glasses or sunglasses? They look like readers. Yeah, they're readers. jurors. The yellow, you can see from his shirt is most likely white. And with it showing up yellow, it's a white balance issue more so than the courtroom, but it is sort of an off-white wall for sure. Is that Mike from Breaking Bad? Yeah, Mother Pickles is clearly a pirate. He's clear. Look at the close-up. He probably has a hook.
Okay, that's great. Let's let everybody work their way to their seats. Please be seated, everyone. Ladies, gentlemen, good morning. Very grateful to see you all here this morning, all 14 of you. Thank you very much for being here and being on time. Over the last 3 days, as I'm sure you all recollect, we had the opportunity to go through the qualifications as jurors and then the rather protracted jury selection process. And then yesterday, you all ended up being seated and sworn as the jury to hear this case and decide this case. I gave you some preliminary instructions and explanation of what to do and not to do over the time between your excusal yesterday and being here today, and I also told you that I was going to give you some formal preliminary instructions the first thing this morning. So that's what I'm going to do. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Franklin Tyrone Tucker, case number 2017 CF 841 CK. This is a criminal case. Franklin Tucker is charged with first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault with a deadly weapon while masked, and battery while masked. The definition of these crimes will be explained to you later. The state's charging document, which are called an indictment and an information, are not evidence and are not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Franklin Tucker in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence. They do not consider it as such. Following the opening statements, witnesses will be called to testify or under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves, and I dwelled on that point yesterday afternoon. Your verdict must be based solely on the evidence or lack of evidence in the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means the phone or other electronic devices actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you, and I believe, in fact, yesterday on that parking pass, clerk did write down my office phone number, and that can be utilized under these circumstances. You all have that. The case must be tried by you only on the evidence presented during the trial.
While he's reading this, I'm going to skip ahead just a little bit. We don't need the jury instructions.
Jurors must not conduct any investigation of their own. This includes reading newspapers.
Let's see if we can get straight to our opening statements.
Computer, cell phone, the internet,
we know what
any
the charge
electronic
is.
device, or any other means at all to get information related to this case.
So the jury's going to be told all this. We're going to start straight with the opening statements. First from the state and then from the defense, which is our defendant. So here we go.
Adding to the shredder.
Their notes are going to be shredded at the end of the day.
I have enough to read, so I'm not going to be looking at jury notes, and we all respect that privacy. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. So, with those preliminary instructions, we will now go on to opening statements. So, counsel for the state, would you like to make an opening at this time?
Yes, Your Honor. At this court.
Yes.
Madam Clerk, Mr. Tucker. Ladies and gentlemen of the jury, good morning. My name is Assistant State Attorney David Alvarez, and along with my colleague, Chief Assistant State Attorney Joseph Mansfield, will be conducting the presentation of the evidence on behalf of the state this morning and throughout the course of the trial. I'd like to start off by saying thank you for your participation in this process. It's very important not only to the state, but to Mr. Tucker as well, so we thank you. And as the judge has already told you, the defendant is charged with a series of crimes. I'm not going to go over them again. We believe the evidence in this case will show that on or about November 17th of 2017, at 5650 Laurel Avenue, Stock Island, Florida, a place commonly known as the Treehouse, the defendant in this case, Mr. Franklin Tyrone Tucker, along with co-defendants Rory Wilson and Travis Johnson, planned and effectuated a robbery at that location, which at the time was the residence of Paula Belmonte. On said date, at approximately 7:45 or a little bit before there, these three individuals, and you'll hear testimony of this, the evidence will show this, that they actually spoke about how they were going to effectuate and pull off this robbery. They drove past the Treehouse once just to stake it out, came back. Defendants Wilson and Tucker put on their dark clothing and grabbed their weapons and their mask, and then got back into Mr. Travis Johnson's truck and drove to the Treehouse. The plan was, as you'll hear and the evidence will show, that Mr. Tucker and Mr. Wilson were going to go up the Treehouse, and the reason it's referred to as a Treehouse, it's a series of stairs that leads. I don't really want to say, I don't want to describe it as an apartment, but it's a place where people could sleep. It had tarps over it. It really didn't even have roofs. And I believe the victims in the case, Ms. Belmonte and Mr. Raggett, will explain that in detail, as well as some of the deputies that you'll hear from. But in the commission of committee, this robbery, defendants Tucker, this actual defendant, Mr. Tucker and Mr. Wilson, went up into the Treehouse and held Ms. Belmonte and Mr. Raggett at knife point. Ms. Belmonte was held at knife point with a knife to her throat. During the commission of this robbery, her throat was slashed, and you will see pictures of her injuries during the course of this case. The state is going to be introducing photos of that. Mr. Raggett was also held at knife point. He was beaten, punched several times. He'll actually testify that he was knocked back into a tarp. At this time of the year, I believe in November, it wasn't quite fully dark yet. It was dusk, the sun was setting, but they were able to discern that the alleged perpetrators were coming up the stairs, and eventually what happened. In the process of committing this alleged crime, obviously in fear of their lives, Ms. Belmonte and Mr. Raggett were screaming in fear for their lives, and unfortunately the crimes didn't stop there. a neighbor, Mr. Matthew Bonnet, heard the screams and decided to render aid, or at least try to assist in somehow. As he was coming up the stairs, the evidence will show that Mr. Tucker and Mr. Wilson confronted him. There was a struggle that ensued, and Mr. Bonnet was stabbed numerous times and eventually died from these injuries. The defendants then fled the scene. Defendant Johnson, who was waiting in his dark-colored pickup truck, the getaway driver, noticing that there was a commotion going on, decided to leave his two accomplices and drives away.
The pickup driver.
They ultimately
the
meet up
getaway
at a
driver
warehouse where they
ditched him.
were all residing together, probably about, I'll say about 500 or 600 feet from the actual treehouse, where an argument ensued, and Mr. Johnson decided to walk down to the Tom Tom to get some cigarettes, where he met up with Mr. Detroit Wilson.
Here's a picture of the treehouse we're talking about. It is
You're
an
going to
actual
hear from numerous
treehouse.
witnesses during the state's presentation and shall be presented with numerous exhibits of evidence for your review and consideration in this case. Ladies and gentlemen of the jury, the state is absolutely confident that at the conclusion of this matter, you will find that the defendant, Franklin Tyrone Tucker, is guilty as charged in the indictment and the amended information. Thank you.
Now, pro se defendant gets a chance. He's done a good job.
Tucker, would you like to make an opening statement at this time?
Yes, sir.
Okay, you may do so.
It's a purple vest. I didn't realize it was purple. Purple front, black on the back. It's like a card dealer's.
Okay. That was a nice presentation, I say. By the way, good morning, gentlemen. Good morning, ladies and gentlemen of the jury.
Nice presentation. I liked it.
That was quite the story. But the problem is nothing in that story tells you what evidence they have, what evidence they're going to show. You know, how are they going to actually tie me into that story? Anyway, you know, the prosecution, you know, tells that story, but the problem is very little of that story is true. That's the bottom line.
Here comes the objection.
You know, yes, about the only thing that was true in that story is yes, John Travis Johnson was there. That's a fact, right? This state witness, you know, they keep on saying he's the getaway driver, right? Out of all the evidence.
Object argumentative.
Yeah, I'm going to sustain the objection. Again, this is an opportunity to talk about what the evidence you expect will show.
Oh, but, that's where I'm going, Your Honor.
Okay.
Just give me a second, I'll get right there. I was actually just getting to that point.
Is it my tone?
Out of all
What
the
do you
evidence they
object
show,
to?
all the witnesses they bring, where are they going to show he's the getaway driver? That's what you need to look at, right? Because the defense, you know, we can show all day there is no evidence saying he was a getaway driver. We can also show that there's evidence that says otherwise, and that's what we do intend to prove. As far as the evidence we intend to put on, we're going to, you know, put on the surviving victim, Ms. Paula Belmont, who says, 100% sure it wasn't me that night. 100%. Now, just as Mr. Alvarez said, you know, this is a woman who was brutally beaten, robbed, had her throat slit, you know, literally sat there and watched her friend get murdered viciously. But yet she is testifying on my side. Now, don't get me wrong, you know, what motivation could she have? Anyway, going down the line here, we're also intent on going ahead and, you know, calling a few other witnesses here. The next one after that is probably going to be Mrs. Angela Oslowski. Again, talking about evidence, right? Well, this is the woman who did the FDLE reports, the forensic evidence that, you know, that they submitted, right? All the evidence comes back. None of my DNA, none of my, my blood, none of my fingerprints, none of that stuff. Okay? So, no forensic evidence, right? Okay? Surviving victim says it wasn't me. Okay, so we'll go on down from there. The next one, Mr. Tom Walker from Internal Affairs, right? Now, Mr. Tom Walker goes ahead and investigates the investigation because of a complaint I made, right? A complaint that comes back sustained, right? Comes back as sustained for an investigation that was so poor, so poorly executed. 208 pieces of evidence were found to be mishandled by the MCSO, including DNA, including physical evidence, including video. 208 pieces of evidence. Now, he also goes ahead and goes beyond that. He goes on to show that, you know, that the original affidavit that was used to arrest me, the one that actually, you know, everybody relies on as far as what the police say happened, right? He goes ahead and investigates that. Unfortunately, guess what? That's not accurate either, according to him. That he actually goes ahead and investigates this and finds out that the original affidavit that was used to indict me, used to give me these charges and put me in front of you people, right? Not that I don't like you, but
Objection, argument again here.
Well, I'll overrule that objection.
no, but yes, you know, it put me here. And so he'll go ahead and show that that isn't exactly accurate. That it's filled with inaccuracies. It also has what they call material omissions. Stuff that would be an exculpatory evidence to suggest that I wasn't there. Okay, so we're going to go ahead and interview Mr. Tom Walker. We'll go ahead and put him on the stand. Then after that, we have Lieutenant Colonel Chad Scabilia. Right? He's actually one of the higher ups in the MTSO. I don't know how familiar the jury is with that. Right? I know we all know Rick Ramsey. But do we know Mr. Scabilia? Probably not. But he is one of the higher ups in the MTSO. He's in charge of their operations. He decides, as of January of 2019, he's going to go ahead and do an investigation of the entire major crimes unit. Right? He's afraid that they're not living up to par. That's a good supervisor.
Object and ask for sidebar.
Okay.
Judge is like, okay. I've got a new counter. Well, they do a sidebar, and we're not going to be able to hear that. We have a. Oh my goodness! Hang on. Whoa. Oops. Sorry about that. We just. Where's my audio coming from? I don't know why. Okay, sorry. We hit a Twitter feed and it exploded on us. Okay, so this is continuing. Sidebar is continuing. Let me tell you what I'm doing here. We have a new counter, right? They're going to discuss this because I'm going to count, because this is a pro se defendant, I'm going to count the number of times. You can't hear the sidebar? I can't hear it. I mean, I could initially, but they turned it off. I've got the audio cranked, and I've got no incoming audio at all. Initially we could. Maybe we can hear some of the other ones. But we're going to count how many times the defendant, who is pro se, gets a lawyering 101 class from the judge. I will tell you that I'm up to 2 times so far. That was probably a third one, but we don't know for sure.
Second, I'm going to wait till this date settles in. I'm also going to advise the jury that I have overruled the objection, but I do want to remind you that this is opening statement. It's not evidence in the case, and it may or may not reflect what ultimately is evidence, and it will be up to you to decide.
His mic is turned
based
off.
on the evidence. So keep that in mind, that this, what I told you, the statements of the attorneys, is not evidence. So with that, let the defendant proceed with his opening.
Thanks. I'd also like to apologize for my tone. Obviously, I'm a little upset. You might understand. I don't know if you do, but you might understand. Anyway, continuing forward, back to Lieutenant Colonel Scabilia. His report, he goes ahead and he finds that there are a number of investigations in the major crimes unit that have not been sufficiently investigated, according to him. One of them, well, not one of them, out of the many that he finds, and Miss Danielle Malone, who we intend on putting on the stand, and to go ahead with this investigation. Yes, she's found to have, out of 17 active cases, 11 of them come up as insufficient, which we would argue mine is one of those. So we, we have quite a bit of evidence. I know that Mr. Mansfield asked you if you could convict me on one piece of evidence. Maybe. That's true. I could see that, depending on what the evidence is. You got a video of me doing something, or, I could see that. But what he failed to say is, okay, could you convict me on one piece of evidence when there's a lot of evidence that says something else? That's the question. And that's what we're going to try and get to with the defense, right? We're going to bring up witnesses, we're going to bring up evidence, and we're going to go ahead and we're going to challenge everything that the state is saying here, because I know it's not true. So, in the end, that's what we're looking for here, right? We're looking for the truth. And they can present their case, I'll present mine, and we'll see what comes out as true. And then you guys can decide. And I know from looking at all of you and from going through our board diary, yes, we'll decide correctly. Thank you.
Wait, interesting opening statement there.
Thank you.
For sure. This is gonna be crazy.
So, jury, you've now heard opening statements from both the state and the defense. So now we start with the evidentiary portion of the proceedings, and the state has the opportunity to go first. So, you prepared to call your first witness in your case in chief?
Yes, Your Honor. State would call Deputy Jenna Muller from the Monroe County Sheriff's Office.
All right, Deputy Jenna Muller.
Okay.
Wherever the podium suits you, a broad range is fine. As long as comfortable, as long as the other side's able to have a clear view of the witness stand and hear, that's fine. Ma'am, if you please step forward right through the gate there. Approach the deputy who's in front of the witness stand here. That's good. We just stop right there, turn, face the clerk, raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now and here shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, please have a seat on the witness stand, logging clearly, so everyone is able to hear you.
Wow. Mics are.
Good morning.
We're on the struggle bus.
Please state your name and for the jury, please.
Jenna Mueller,
And where are you currently employed?
Monroe County Sheriff's Office.
In what capacity are you employed with the Monroe County Sheriff's Office?
I am the Road Patrol Sergeant in District 1.
How long have you been doing that, Mr. Deputy Mueller?
As a sergeant?
Yes, ma'am.
Since July, I believe.
And in total with the Sheriff's Department?
I got hired in January of 2016.
2016, okay. I'd like to direct your attention to November 17th of 2017. Were you employed with the Monroe County Sheriff's Office on that date?
I was.
And in what capacity were you working with them at that time?
I was a deputy on Road Patrol in District 1.
And at some point on that date, I want to say approximately 7:45, 8 o'clock, did you have an opportunity to respond to 5650 Laurel Avenue, commonly known as the Treehouse?
Yes, I believe the original call was for me to go to the CVS right in front of that address.
Okay, and the CVS, how far is it away from the 5650 Laurel Avenue?
Across the street.
Literally across the street?
Yes.
Okay, and could you please describe for the jury what happened? What happened when you got there?
So I responded to CVS. The call was that there was a man there making excited statements, something along the lines of maybe his friends were hurt. I don't remember the exact dispatch. So I arrived there, made contact with a male who was shirtless, and he began telling me of this incident, a stabbing that occurred, and that it occurred at the Treehouse.
Okay, and did you ultimately respond to the Treehouse?
I did.
Were you the first surviving officer on the scene?
I was.
Could you please describe for the jury what you observed when you arrived?
So on arrival, I could hear, I parked my patrol vehicle out front of the property, and I could hear someone screaming from what ended up being the top of the treehouse. I made my way onto the property, up the stairs, and that's where I encountered the first victim, laying face down on the stairs, unresponsive. I went past him to the victim that was yelling, and she was at the very top of the treehouse with a large wound to her neck, and I believe her hand as well.
Now, a lot of people are interested, including myself. Could you describe why do they call this residence the Treehouse?
So it was legit a treehouse. It was almost like a outdoor platform tower. I believe there was 2 levels and stairs going up all the way to the top, and it was essentially a treehouse. It was just two platforms.
Did it have a roof or anything of that nature?
I think maybe part of it sort of had some sort of makeshift roof, but I don't remember exactly.
Running electricity?
I don't know the answer to that.
Okay, very well. You indicated the first victim you encountered was non-responsive.
Correct.
Did you call for medical assistance?
Yes.
And did they ultimately arrive there?
Yes.
Okay, and then you proceeded upstairs, and who did you come into contact with upstairs? Do you remember?
Yes, that was Miss Paula Belmonte.
And what was her condition like?
She was very excitable, yelling, screaming. And she had a large wound on her neck. I believe I found a towel nearby or something and applied pressure, had her hold on that while I went back to try to assist the first victim I had encountered.
Yes.
You guys, this is really a treehouse. This is the treehouse they're talking about. It's like it has Dish Network on there.
You had a chance to review those?
Yes.
Did they accurately and correctly reflect the entrance and the stairs of the treehouse?
Yes.
Permission to introduce this evidence if they don't need to.
Any objection? Mr. Tucker, any objection to this exhibit?
Let me pull the microphone down. No, sir.
All right, so we'll admit it as states. 1, it's a composite. 1A through C. We just need the clerk to mark it, please. Well, Mr. Alvarez, we can bring it up to the clerk so we can get it marked as states 1A, C composite.
Thank you, Madam Clerk. Commissioner, public jury.
Yes.
A lot of noise in this courtroom. I'm trying to fix what I can.
Deputy Mullen, while the jury is looking at the photos, could you kind of describe what they're looking at? Is that the steps leading into the treehouse?
Yes, so if I remember correctly, it was essentially like one flight of stairs and then almost like a landing platform and then another flight. And then I don't recall if there was a turn at the very end up to the top, but there may have been.
And just so I'm clear, you indicated that you encountered the first victim, which was non-responsive on the first landing, correct?
Yes.
Okay. One moment, Your Honor.
All right.
We're going to keep it on 1.25 speed until we catch up. I like that they keep the water bottle right there next to the, what is that, Raid? No, that's, I think that's a bottle of Home Defense for bugs. You guys see that? We're looking right here. This little bottle, squirt bottle. It's a cleaning bottle or something right next to the drinking bottle.
I know the jurors are reviewing the state's first exhibit, but the state has no further questions for Deputy Mullen.
All right, so before we have cross-examination, we'll let the jurors, each of them, have an opportunity to review the exhibit, and then we'll do a cross-examination opportunity.
Jurors are reviewing the exhibit. What was the exhibit? Was it the picture of the treehouse? Are they looking at the treehouse right here? We'll look at it as well while they're looking. Okay, nice. There is a really bad hum on this audio, and I'm trying to take it out, but it's all over the place. Fun little fact about the treehouse. It's bigger on the inside than it is on the outside. It looks like a small little hangout, but really once you get inside and you sit in front of the little 12-inch TV or whatever it is they have there, it really feels bigger. It feels bigger. The jury's still reviewing. The counter here is a different one than we've been using ever before. We're counting the number of times the defendant gets educated on what he's supposed to be doing next because he is his own lawyer. So this is Law School 101. Law 101 is the class, so we're counting that and the number of times that he's told, this is what you need to do next. This is the chance you have to question the witness, things like that. So if you hear something like that, go ahead and let me know. We'll add to the Law 101 count. It's now being used by traveling nurses.
Appears as though all the jurors have now had an opportunity to review the exhibits. We can return them, or the exhibit, we can return them to the clerk. State's completed direct examination. Mr. Tucker, did you care to cross-examine the witness?
Yes, sir.
Okay, you can proceed.
Thank you for coming. It's been a while, but
it's been a while.
Okay, that night, do you remember approximately what time? You know, what time you arrived on scene? What time you got to the treehouse?
I don't recall the exact time, no.
Just how about approximately? You got anything in there?
I want to say maybe it was like, I'd be guessing. I think it's like, 8 p.m., something like that. But,
You both need to keep your voices up, please.
Oh, sorry, Your Honor. Okay, so you get to the treehouse, and Paul's the second victim that you come across, correct? It's you come across Matt first.
Correct.
Okay. And how long before backup shows up? Approximately.
Approximately like 20 minutes or maybe 30 minutes. Another deputy showed up to assist me with clearing the property.
Okay. And did you guys actually clear the property, check, make sure there's no more suspects, anything like that?
I had done that prior to the deputy arriving on scene.
Okay, would that be on your body cam?
Yes, sir.
Okay, sure, I'll check that out. Okay, so
I'll check that
now
out.
you're at the property, you've done your sweep, you've got backup, correct? And I would assume the ambulance shows up before or after that?
Yes, sir. The ambulance showed up minutes after I got there.
Minutes after you got there. I just remember that too. Okay. Now, let's see. After that, what did you do after that?
I remember
After you went
that.
ahead and cleared
I
the
was there.
property, after the ambulance came, they took Paul to the hospital, if I remember correctly, right?
Correct.
So what was your duty after that?
I remained on scene. I started a crime scene log. I believe I taped off the immediate structure of the treehouse itself, and then also the entrance to the property. I asked anybody who was in the property to come outside of the property. I tried to identify everybody that was on scene or that I came into contact with. That was essentially.
You secured the scene, basically, right? And what does securing the scene? What does that actually entail? What is it? Why do we do that?
To not contaminate the scene, to not have people in and out, stuff like that.
Okay. Just to make sure that the evidence stays there, it stays, doesn't get
Scene
walked away
safety.
with or tainted, right?
Correct. Scene safety, make sure everything's.
Right, and safety, obviously, right? Okay, and now was there evidence just found on property?
No, I believe no. There was evidence found on the street itself.
Okay, was that ever blocked off? Was it ever roped off so that the evidence would stay secure?
Yes. Once other units detectives got to the scene, at one point they did block off most of the street, from what I recall.
And about how long did that take?
For them to arrive, or
for them to block off the street?
I don't recall.
Okay. Do you remember anybody walking away with evidence?
Walking away with the
Like
evidence?
picking up evidence off the street and walking away with it?
The only person I saw that handled evidence would be the crime scene tech from Key West.
Okay, that would be
Detective Mitchell.
Yeah, if I remember right. Okay.
Yes.
And so he was the one who handled the evidence once he got there. Right?
In my presence, yes.
Okay. And and then after that, what did you do after that? I know you started the crime scene log, you secured the scene, at least the immediate scene, right? The treehouse itself.
Correct.
And then what did you do after that?
I believe I assisted the detectives on scene with what they needed. We walked the street, Laurel Avenue, looking for any additional evidence. I did locate a $100 bill on the street. That's what Detective Mitchell came and photographed and collected. And I believe there was other individual pieces that were located. I didn't locate them directly.
But they were basically all the way down the street, right?
From what I recall, it was, yes, going down the street.
Sure. Okay, so you're looking for evidence after that. That's you're basically searching for evidence. Checking the scene, making sure you guys cover. You guys are covering the whole street now, looking for the evidence, right?
Correct.
Okay. Now you get to the scene, okay, and was I there? Correct. Just we'll go for that right there. Was I present when you got there?
I did not see you, no.
Okay. And was there any evidence that I was there?
I did not see you there. So
you know, right? Okay. All right. So nothing there. Now, okay. And you said other people started showing up. Other detectives, other officers started showing up. Was it Detective Mitchell from Key West PD? He shows up for the forensics, correct?
He did show up, yes.
Okay. And then who else showed up?
Let's see. At the time, Captain Phelps, Detective Pitcher, Detective Malone, Lieutenant Kellenberger, Detective Fernandez, possibly Captain Smith.
It's quite a few officers, right?
Yes, sir.
Most of them major ranking officers, if I remember
Bailiff
correctly.
/ butler sees the judge has finished his drink, jumps
your
up,
first
refills
encounter
his
was
mug.
with Todd O'Quinn, correct? With the skinny white guy who ran out.
I believe his name was Todd O'Quinn.
Todd O'Quinn, Todd Sumner O'Quinn is his name, but his full name. So he's the one who approached you first. But he's not the one who called 911, but he's the one who approached you, correct?
Correct. I believe he was yelling in front of CVS, and some other bystanders contacted 911.
Okay. And what was he saying to you? Do you remember?
For the exact verbatim, I would have to refer to my body
sure.
cam.
It's been a long time. I understand. Believe me, I understand.
But he told me that there was some sort of altercation. I believe he said he saw Mr. Bonnet being stabbed. and he saw a white suspect and a black suspect.
Do you remember the circumstances being, for the white suspect? The white suspect. Do you remember any of what he said about him?
Again, I would have to refer to the body cam because that would give an exact recording.
Right. Yeah, that definitely helps.
Yeah.
And you may do that. We'll see. Now, prior to all this happening, before you even got to the treehouse, before you even got the call, what were you doing before that?
I believe I was patrolling the trap yard in an area called La Curva prior to.
An area called what? I'm sorry.
It's called La Curva. It's a trap yard.
Oh, La Curva? Yeah, I know La Curva.
Yeah.
Okay.
I believe I was patrolling there prior to getting the call.
Okay. Okay. And how long would you say you were doing that?
Again, it would be a guess, but approximately 15, 20 minutes.
Okay. Were you ever in the CVS parking lot that night?
I could have been prior to.
Do you know approximately how long?
No.
What if I told you maybe hours? Maybe an hour, hour and a half, 2 hours? Just prior to the crime?
Well, it could be, yeah.
Okay, just checking. Okay. And did you go into CVS that night at all?
Well, I don't have a direct recollection, but if I was there, I probably went in and maybe got snacks or.
Yeah, see, I could see that. I could definitely see that. Okay. All right,
I
so
can
we
see
know
a
where you were
cop getting
before, we know
snacks
where
at
you went
CVS.
afterwards. And, okay, so you're searching and everybody else shows up and they start searching, right? What about, the other investigators? What are they doing? Because, were they all searching on Laurel or did they, go other places? I mean, did they do anything else that you know of?
I know some units responded to a property on 2nd, but I wasn't there. I don't know who responded. Was it
the warehouse property?
Yes.
Okay, so it was the warehouse property. Now, when I say the warehouse property, you and I know what that means. I'm not sure the jury knows what that means. It's on 2nd Street. Could you please just describe it for them just so that they have an understanding of it?
Yes, it's on 2nd Street in Stock Island. It's essentially a big warehouse. It's like an aluminum or metal sided building, pretty large, and I believe there's it's sectioned off, or at least it is now, into separate areas.
Now, was the interest at 2nd Street or the 2nd Street warehouse? Do you know?
I believe at the time, the information that I was able to put out and receive from the victim was that there was a suspect that possibly resided there.
Ended up being true, did it?
I actually don't know if they found him. I don't know the results.
Did you show up for when they brought Rory Wilson in? Were you there for that?
No,
I know the people were messed, so it was hard to decide. I don't know whether you were there or not, so I'm just asking.
Yes, I was not.
Okay, just checking. Okay, so you got there are units at the 2nd Street warehouse, but you're not one of them. You're still back at the.
I stayed at the scene the whole time.
Okay, you're at the scene. Okay, so we'll go ahead. Okay, is there any other involvement you had in the investigation beyond, that initial night?
The very next night, I was on patrol again, and I got called again by dispatch to a residence at the end of the road because they had found a knife in their yard.
Okay, and where was it? Do you remember? Where? What was it in the mobile home park, or was it?
Yes, at the time there was a mobile home park there called Ocean's Edge.
Okay.
Water's Edge.
Water's Edge.
Yeah,
you're absolutely correct. I'm sorry.
And it was one of the trailers that was on, I guess, is that 2nd Street, right at the end of Laurel Avenue there.
Yeah, I seem to remember which one. Now, did you stay there and collect the knife, or did somebody else come and do that?
I recall that.
No, I responded. I saw the knife, and I contacted Detective Pitcher, at the time I believe was the lead detective, and then Key West Detective Mitchell came and collected the knife.
Now, at the crime scene, who would you say was actually in charge of the crime scene? Who was actually running the show?
I know that Key West PD Detective Mitchell was doing the collection, but
For the
beyond
forensics
that,
part, yeah.
yeah, beyond that, I don't know who.
I mean, normally it would have been Sergeant Kellenberger's job, correct? I know a little bit about MCS protocol, MCSO protocol. I don't know.
He would be
I don't know nearly as much as you, obviously.
He would be the supervisor of the.
He would have been the supervisor, right? Okay, and but there were people there above him, correct?
Correct.
Okay, and did people from the state attorney's office show up at the crime scene?
Yes, sir.
Okay, and how about, did they ever have a suspect at the crime scene?
Not that I recall.
Okay. Do you remember Anathea Clay?
I believe she showed up on a bicycle at one point.
Okay, was she a suspect in the crime?
Not that I'm aware of. I know she was mentioned by Miss Belmonte that she knew the suspect.
Okay, but I'm not trying to tell you what to say or anything like that. I'm just trying to see if we can both remember here, because if I remember correctly, didn't Paula come out of the treehouse when she's holding her neck and screaming? Isn't that the first name that comes out of her?
I'm going to sustain it. That's
Okay.
Facts, not an evidence.
Okay.
I can't testify, man.
Anyway, you do remember the Anathea, that she was mentioned by Paula?
Yes.
Okay. And she was eventually brought to the crime scene, correct?
I remember her showing up on a bicycle.
Okay. And did anybody get a statement?
I don't know the answer to that.
Okay. I'm not saying you do. I'm just, because I don't know which officers did everything, so I just trying to get my knowledge here. So you don't know whether anybody took a statement from her.
Objection asked and answered.
I'll overrule the objection.
That was just rhetorical. I'm sorry. But she wasn't arrested, correct? That you know of.
Not that I know of on the scene, no.
And did you have any other parts of this investigation beyond those initial days?
Yes. A few days later.
Okay, a few days later, and
I was on shift again, and I got called to assist with arresting you.
Oh, thanks.
He's all surprised. Oh, me.
I'm not going to hold it against you.
I appreciate it.
Now, and then well beyond that, was there anything else you did for this investigation?
Yes, it was much later in the investigation. I was
can
actually
still
a
be
detective at the
friends.
time, and I was a plainclothes detective. My partner and I at the time were asked to locate Miss Anthea Clay. And then separately, my partner and I, at one time, went to Miami to pair up with, our whole unit did, to pair up with Miami-Dade detectives in an attempt to locate another person to serve a subpoena. My involvement with that, though, was literally show up, and then we were dismissed, so we went home.
So just go there, go home.
Yeah, I didn't have much.
I'm sorry about that. I'm sure it wasn't fun. Okay, but the Anthea Clay thing, back to that one. So what was the intention of when you went to go, engage Anthea on this time?
At the time, Captain Phelps was the boss of the unit I was in, like higher ranking.
Right, yeah.
And she asked my partner and I for assistance with locating Miss Anthea Clay. And she knew, or she had an idea of where she lived or would be seen. So we were playing clothes, so we set up and we watched. And when we located her, the captain made contact with her, and I believe she brought her in for interview.
Right. And did she act surprised or anything like that to see you guys? Or
I don't recall.
And you remember being brought in for the interview. Were you there for any of it? Or
I did not. I waited outside.
Okay. So that's the extent of your involvement, though, that I know of, correct?
As best as I can recall right now, yes.
And that you know. Okay, great. No further questions, John. Thank you, Mr. Detective. Sorry, Detective. I want to call you Detective because I remember you being a detective before, too. Deputy Muller. Thank you.
Is there a redirect examination?
Yes, Your Honor. Deputy Muller, good morning again. Mr. Tucker asked you about the actual time that you arrived on scene and were dispatched. And I know at this point it's been, 6 years. Is there anything that would refresh your recollection if you take a look at it, maybe your report?
Either my report or my body cam would very much refresh my recollection.
Ivan, I do have a Bitcoin wallet if you really want one. I don't know what that's going to do to my tax implications.
You're fine. Commissioner Prochak?
Yes.
Let me show you a copy of the report.
Give it a coin vaccine.
Dispatched and arrived.
Yes, sir.
When you've had your recollection refreshed, say so, and then the prosecutor can retrieve the report and you can testify from your refreshed recollection.
Yes, sir. I'm refreshed.
Could you please describe to the jury exactly what time you were dispatched?
I was dispatched at 2018.
Okay, and name and terms. What
That
time
is 8:18 p.m.
Okay, very well. Mr. Tucker asked you if he was on the scene when you arrived. Was Rory Wilson there?
Not that I recall, no.
Was Travis Johnson there?
No, sir.
Were any of the alleged perpetrators there?
Not that I'm aware of, no.
You indicated that on the second night you were on duty, correct?
Correct.
And you dispatched, I guess, to a mobile home that was referred to as Water's Edge?
The trailer park itself is, yeah. Or was.
And that's where the knife...
Yes, sir.
Okay, thank you so much, Judge. I have nothing.
So, may this witness be excused, or is she held subject to recall?
She may be excused, Your Honor.
Okay. I would agree, Your Honor. Thank you. You can step down.
Thank you, sir.
Excused. So, members of the jury, I think this is a good time for our morning break. So let's talk about the basic ground rules for the break. You don't have to stay in the jury room. If you want to walk around a little bit, stretch outside the jury room, you may do so. Just let the bailiffs know who wants to go outside the jury room. They will escort you through the secure portion of the courthouse. You can then, when it's time, be back in the jury assembly room, and the bailiffs will bring you back. During the break, whether you stay in the jury room or whether you go outside, the rules, the instructions that I've given you about, exposure to information, discussions, conversations, all those things that you've heard so often, they remain in effect. So we're going to break until
Ivan, this is just for you.
10:55.
I think you know what
Leave
this
your
is.
notepads right there on the chairs, and we'll be back, and the state will have the opportunity to call their next witness.
All right, so here's what we're going to do. It is late in the day. We are going to give me just 1 second. We're going to pause just for a wee bit. We're going to pause. We have our first witness done. It's later in the day. We have a podcast still tonight to go on. We've got to do some preparation for. Ivan, you've got to remember this. I'm never going to be able to find this again. Honestly, I have no idea how to. He's got it. Okay, good. All right, all those letters make sense to you, and hopefully to me. All right, yes, it's a Bitcoin wallet, which I think is empty. Not a strong witness there. We do have a podcast tonight. Lois, thank you very much. Hope you can make it there. That would be wonderful. We'd love to see you there. In this case, this is the Treehouse murder. It's going to be crazy. We've got some weird witnesses. The defendant is already making some mistakes. He's already asking questions about, so what happened? What did you do when you come on scene? And she says, well, I did this. I saw so-and-so was stabbed on the ground. And I'm like, oh yeah. He's like, yeah, I remember that. Yeah. Okay. I remember. Yeah, that was a good night. And then what'd you do? Oh, then I arrested you. Oh, yeah. Won't hold that against you. We can still be friends. Are we still on for this weekend down at the bar? No, he didn't say that, but it's hilarious that this guy he's trying to be very, very friendly and personable. And in doing so, he's, I think, sharing more than he should. Sharing a little bit more than he should. Eldime, it says, if it's not empty now, it might be soon. That's all right. I think there's nothing in it, so it's good that way. It was empty when it started. All right. So what we're going to do is we're going to wrap up today at this point. We are going to catch up again tomorrow. We're going to be catching up. So we're going to start early tomorrow. No sleeping in. Okay, no sleeping in. I say that for me, but we're going to start early, probably about 8:45. And we'll begin. We're still going to be on catch up, and so we're going to be watching on 1.25 speed as we catch up, and then eventually when court begins, I think hopefully tomorrow we're going to get, if not most of the way, we're going to get very much close to being caught up to being live in this trial. Does that work? And we'll have some more information. We'll have a new thumbnail, of course, about this, and you can check it out that way. This is going to be a fun case with the pro se defendant. I had to leave. Did we get a verdict? We did get a verdict, Nosy and Rosie. We got a verdict, and it was a guilty verdict. They found him guilty of reckless driving, and then the judge proceeded to whittle down the penalty to a mere fraction of the possible sentence. Kimar says, I just got an ad. Did you just refresh? You should not get an ad right now. My ads are turned off. Ad automator off. But yes, came back as guilty. It was a surprise. She took the $5,000 fine and cut it down to $103. Gave him up till the end of April to take a defensive driving introduction class online, and his license will be suspended for probably a year because he's a brand new driver and this is a serious charge. But the way she structured this, we believe that if he does not drive during this time when he's not allowed to drive and he takes the class, then there's a good chance this will be dismissed and it will be off his record. So she gave him some hope, but he's got to be good. He's got to be good. All right. It's been a very fun day. We have a podcast tonight. It's going to be 8:00 here on this channel. If you have not ever joined us for the Not Relevant podcast, it is it's high time you did. Really, honestly, what are you waiting for? What more do you need to see? Let's see. I think we have some. There it is. What more do you need to see?
What more do you need to see?
The podcast is tonight, and it's going to be Thomas and I. It's going to be fantastic. I can't wait. It's always a good time when we're hanging out with Thomas. He's a great friend, a great supporter, a great mod, a wonderful weatherman, which we've leaned on him during this past week because we've had some crazy weather all over the United States. We might talk about that still because it's not done. Tomorrow is looking possible tornadoes as well in my part of the woods. So we'll see. Anything else we need to cover today before we move on? We've had a big day, man. We've had Thurston County. We've had Judge Boyd. We've had this. We've been all over the place. We've got snow coming tomorrow, says Alley Cat. Winter is here. Winter is coming. I think I'm retiring from the podcast, says Adam. Adam, we might bring you in through retirement and have you join us that way. It'll be a fun party tonight. So we'll be back in a little bit. Cool. I'll set my alarm for the podcast. We're gonna put the thumbnail up here in just a little bit. You can obviously join and chat amongst yourselves before we join, and then let's see if we can. Somebody says you're headed over to Melanie Little. Let me see everybody who's on. I like to spread the wealth when we finish for the day. I'd like to see if we can send a few people other directions. So let's see who's on right now. Surviving the Survivors up. Melanie Little. Mel's up. Big congratulations to him. Judge Manning, we're not going to go to her because she doesn't let us use. She lets us redirect to her, but she doesn't want us to use her feed. Yeah, about that. So let's see. Attorney Melanie Little is talking about Karen Reed. Tell you what, Mel has a police chase. Let's go check out the police chase with Mel. Let's see if this is still live. It looks like it's still going right now. So we'll join that, and we'll go finish that out there. All right. When you go over there, please do click the like button. Congratulate him on his huge accomplishment, hitting 200,000 subscribers. That was really cool. That happened this week. We were sort of there for it. Sort of helped it happen. I appreciate all of you that did that. Snow on its way to Arkansas. Stay warm. Stay safe. Winter is coming. Beagles are on the way. All right, I might pop in to see Melanie Little as well. I'll try to watch both. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit more better. Uh-oh, I added more to that. A little bit better. And please stay safe till we go live again, which will be at 8 o'clock tonight for the podcast with Thomas and Scott for the Not Relevant podcast right here on the Recovery Addict channel. Thank you, guys. Have a wonderful day. Be nice to each other. We'll see you guys later. Bye-bye.
I was kicked back, taking it easy.
Just fighting. I don't know who won. Now at Murdoch Stolen.